Tēnā koutou katoa. Welcome. This is the resumed hearings on the proposed Timaru District Plan. This is hearing stream G, where we're dealing with growth, financial contributions and designations. I'll invite Commissioner Mackay to open with a karakia.
Tūtara mai te runga, tūtara mai e raro, tūtara mai e roto, tūtara mai a wahu, kia tau ai te mauri tū, te mauri ora, ki tū katoa, haumi e, hui e, tā ki e.
Tēnā koe. My name is Cindy Robinson and I'm a lawyer based in Christchurch and I'm the chair of the hearing panel. I'll just invite my fellow commissioners to introduce themselves. I'll start with you, Stacey.
Good morning, Stacey Scott, Timaru District Councillor, also Commissioner on the full PDP.
Hi, good morning, I'm Jane White and I'm a Commissioner based in Christchurch and my background is in planning.
Kia ora koutou, ko Megan Mackay tōku ingoa, no taumitua hau. My name is Megan Mackay. I am an independent hearing commissioner and lawyer based in the Taumutu Takiwa of Selwyn.
Morena koutou, my name is Rosday Cleven. I'm a commissioner based in Ōtepoti, Dunedin, and my background is in resource management.
As with all of the hearing topics, the panel has maintained a conflicts of interest register, just to note any matters that may preclude or limit the involvement of any panel member in decision making. I'll just invite panel members to update that list in the hearing.
Thank you for this particular hearing. Just to note that I'm a director of Venture Timaru, which is a submitter on the financial contributions. Also to note that my 4 children attend school at Roncalli and Sacred Heart Primary School.
Just in terms of the panel ruling in relation to those conflicts, the panel has no issue with Councillor Scott's children attending local schools. Just in relation to the matter where she is a board member of a Timaru entity that is a submitter, she will not participate in deliberations on that particular hearing point. Are there any other conflicts? And I have nothing to add there. Before we commence proceedings formally this morning, the panel wish to take a moment to acknowledge the passing of Ms. Georgina Hamilton, who is a partner in Gresson, Dorman and Co, and express our sincere condolences to her family, friends and colleagues. Ms. Hamilton has appeared before the hearing panel on previous stages of the hearing. So I'll invite you all to remember Ms. Hamilton and take a minute's silence. Thank you. Right, I'll hand over to you, Ms. Vela, and you can introduce your team and we'll get underway. Thank you.
Yeah, thank you, Madam Chair. So we have three Section 42A officers here. To my left is Mr. Bonis, who has not appeared before you yet, but he's the only one who hasn't. So Mr. Bonis has prepared the preliminary 42A report for growth and the Section 42A report for growth, along with the additional memorandum in relation to the National Policy Statement for Highly Productive Land that was released, I think, in January from memory. And to Mr. Bonis's right is Ms. Williams, who has prepared the 42A report on designations, and Mr. Andrew Willis for the financial contributions report is online with us today. Also online, we have a number of experts who fed into the 42A report for the growth chapter. Mr. Tim Heath from Property Economics has undertaken the residential and business sufficiency and capacity analysis. Mr. Matt Collins, you've already seen as well. He's transportation planner from Abley. You also know Ms. Yvonne Fluger, landscape planner at Boffamuskel. And Mr. Kevin Kemp should be here in person. No, he's not. But if we need something from Mr. Kemp, we can make sure that he's here at some stage too. We do not have Mr. Steens, who was the Parks and Recreation Manager for the council, but he's now retired. So if there's any particular question about that one submission, we can arrange for some written comments from the council. And we also don't have Mr. Andrew Dixon, who is the Infrastructure Group Manager, and he's provided some input into Mr. Willis's 42A report on financial contributions. But again, we can arrange for some written comments from Mr. Dixon if that's required. So you will have in front of you from me the legal submissions that I filed on the 30th of July, but also a supplementary set that I filed this morning in response to Minute 41. I'll come back to those in a moment, but they're sort of offered in an attempt to help direct the hearing as opposed to being perfect answers to all of your questions. But we wanted to give you some sort of initial thoughts on that to help you direct your questioning of the witnesses if that's what you'd like to do. So in terms of my legal submissions, I don't need to go into those into too much detail, I don't think. If I start with the growth topic at paragraph 13, just to provide, I've really just provided the context to bring all of the threads together into one place so that both the panel is reminded and the submitters are reminded of the process that we've been through so far. But essentially, the growth topic is about submissions to rezone land which is general rural zone into rural lifestyle, general residential or industrial zones, or also to either extend or bring forward existing future development areas, along with some submissions on the provisions, but there's not particularly many of those, and Mr. Bonis can take you through them. In terms of the future development areas, essentially they're areas that have been identified in the PDP as to signal that land is suitable for growth in the future, but they retain their general rural zone at this stage. So they're not land that's already zoned urban, they're still rurally zoned land. The way that works is essentially that a development area plan will be developed before a decision is made to rezone that land. And the development area plan requires a sort of a range of information to support the rezoning of that land. And that includes things like integration with supporting infrastructure and the surrounding environment, and to ensure that the effects have been considered and appropriately managed through the rezoning, including the ability to service newly developed areas. And that's a key factor really in Mr. Bonis's assessment and recommendation of many of the submissions is can this area, in light of the growth forecasts, be adequately serviced? And there's a balance to be struck really between providing for that area for growth, but also making sure that it is tied to growth projections so that we can have an efficient allocation of infrastructure and we're not simply putting additional costs, particularly in relation to maintenance, on ratepayers to maintain that infrastructure when the growth isn't demanding it. And so Mr. Heath obviously is the expert in that area, along with Mr. Bonis, and questions around that can be directed to both of those. The FDAs were informed, at least in part, by the Timaru Growth Management Strategy that was completed in 2018 and the Growth Management Strategy Review. So the FDAs don't necessarily specifically reflect those documents, but those documents have informed the zoning in the PDP and the FDA, the identification of FDAs. And I think just to remind the panel of the process, Mr Bonas prepared the preliminary Section 42 reports that came out in October, and that essentially set out the information that Mr Bonas was seeking from submitters in order for him to make a recommendation. Submitters were provided the opportunity to provide a package of information in response to that preliminary report, and the 42A report assesses those submitter packages, excuse me, along with the other submissions, and that's the report that was released in advance of this hearing. And as I mentioned at the beginning, Mr Bonas has been on site visits with many of the submitters, and what became evident to him during those site visits was that there was some confusion around how the NPSHPL applied, and that's the rationale for having provided that additional memorandum. So that set out his initial analysis for submitters to respond to in terms of how he saw the NPSHPL applying to each of those submissions. And that's because, sorry.
Can I just ask, on that memorandum is described as being on a without prejudice basis.
Yes.
Can you just unpack that a little bit for us as to why that is in the context of these proceedings? Are you going to present a different legal argument as to how the provisions apply, or are you able to confirm, or Mr Bonas
Yes.
confirm, that that is how you interpret the NPS?
Yeah, thank you, Madam Chair. I guess that was really only to say that it was his initial analysis that he was putting out there to help submitters understand his initial thinking, but that if there was something that came from submitters in response, he might change his view. Mr Bonas can confirm whether he has. I don't think that he has.
Panel, that's correct. It was essentially put out there as a basis of my opinion, and I wanted to provide the submitters with an opportunity to disagree with that if they did. And my understanding from all the submitted packages that we've received is that nobody disagreed with what the memo is, and accordingly there's no change of view from me. Thank you.
Thank you. So 20 submitted packages have been received in response to that preliminary Section 42A report. And again, Mr Bonas can go into this in some more detail, but essentially the large majority of them don't provide the information at a level, the required information at a level that has enabled him to make a positive recommendation to support those. And that's not necessarily to say that evidence can't be brought in this hearing that might alter his view, but at this stage, that's the basis upon which he's made his recommendations. Just a brief comment at paragraph 22 in relation to one of the reports that has come through in many of those submitted packages, which relates to the report by Mr Patterson. And I haven't written down the name of that report, and I can't remember the name of it off the top of my head now. But essentially, it sets out scenarios of an aspirational economic future for Timaru. And so it's not there's quite some criticism in some of the submissions and the submitted packages around Mr Heath's analysis, and a lot of reference to Mr Patterson's report. But that was prepared for a particular circumstance for Venture Timaru, and is, as I said, aspirational, but it doesn't necessarily reflect what the actual current growth projections are. So it's a report that says this is what Timaru can do if it would like to increase growth and bring business to Timaru, but it's not the same as the report that Mr Heath has undertaken. Also, just to note that, and just to be clear, because I'm conscious that Mr Bonas hasn't supported many submissions, the council's not opposed to changes that would achieve a consolidated integrated settlement pattern in accordance with the strategic directions, etc., of both the regional policy statement and the PDP. But as I said, for the most part, the information just hasn't been provided that would enable him to draw that positive conclusion. So I've just addressed both the NPSUD and the NPSHPL. They're interrelated and they're complex and complicated. And even though I reread these an hour ago, I'm probably going to get myself tangled up, because it's the kind of thing that you have to rethink yourself into every single time you do it. So I've just set out sort of the high-level objectives and policies of the NPSUD at 26 and 27 that I won't go into, but just a reminder that Timaru is a Tier 3 local authority. So the obligations that apply to Timaru are set out at paragraph 28, and they need to the council needs to assess the demand for housing and business land in urban environments and the development capacity that's sufficient to meet that demand in the short. They need to provide at least sufficient development capacity to meet expected housing demand in existing and new urban areas for standalone and attached dwellings, and land suitable for various businesses over the short, medium and long term, and that needs to be plan enabled and infrastructure ready. And then there are obligations to go and revisit that if it's proving that the zoning, etc., and the PDP is precluding that level of sufficiency. And development capacity, plan enabled is defined by the NPSUD, and I've set that out at paragraph 29. Infrastructure ready is defined as well, and that's at paragraph 30.
Move on to providing sufficient development capacity. Can I just take you back to the NPSUD in clause 1.5, which you've footnoted?
Yes.
Sort of quoted, or you've just summarised what it does in part, but it goes on to say adopting whatever modifications to the NPS are necessary or helpful to enable them to do so. What does that mean?
That's a very good question. I haven't given any thought to that, to be honest. So it requires them to, it strongly encourages them to do the things that Tier 1 or 2 local authorities are obliged to do, but adopt any modifications necessary. I might have to have a conversation with Mr. Bonas about that, because I haven't thought about that at all, what that might specifically entail, particularly in this particular context. But I will say that the council has had regard to 1.5 and that encouragement in undertaking this exercise, and Mr. Heath can go into this in some more detail. But essentially, and I'll come to this in a moment. This is where I'm going right now. But he has adopted high growth projections, and he's applied a what's it called, the competitiveness contingency, thank you, on top of that. Neither of those requirements are required by for a Tier 3, they're Tier 1 and 2 obligations. So the key conclusions of Mr. Heath's report at 32 for residential capacity, at least, is that there is sufficient plan-enabled and infrastructure-ready dwelling capacity to accommodate demand beyond 2053 without actually rezoning any of the FDAs. So the FDAs are an additional contingency that can be brought online as and when necessary. And there's also, that's under the medium growth scenario. Under the high growth scenario, that applies out for the next 20 years. So that demand is catered for without FDAs for the next 20 years under a high growth scenario, which includes that competitiveness contingency. And similarly, in terms of industrial land capacity, based on high growth projections, there's sufficient industrial land capacity for the next 20 to 30 years without additional FDAs. I'll just pick up at 36 again, something that can be explored with Mr. Heath, but just to sort of pick up on the comments that I was making at the very beginning of these submissions. There are costs and benefits associated with zoning additional land, and the benefits can include things like lower land prices, increased choice, increased certainty in future location of industrial and housing land provision, and the potential to disincentivise out-of-zone activity if there are capacity constraints. But the key cost really is that inefficient infrastructure allocation that can occur if a council's having to provide additional infrastructure, which may be, at least in part, compensated for through the financial contributions sort of framework. But to the extent that the way that the financial contributions policy works, any benefit essentially that might accrue to someone other than the developer of the land is absorbed by the ratepayer base and not paid for by the developer. So there'll be a gap into the capex, but there's also ongoing maintenance costs that aren't recoverable from the developer and will need to be paid out of the ratepayer base. So if you don't have more people in town to pay for that, it just gets absorbed by the current population, essentially. That's my high-level understanding of things, but you can delve into that further with Mr. So I think that's addressed paragraph 37. So in terms of have you got any questions about the NPSUD? Thank you. So in terms of the National Policy Statement for Highly Productive Land, essentially that places some restrictions on rezoning land to either an urban zone or a rural lifestyle zone, if that land is defined as HPL. And of course the transitional definition applies at the moment, which is LUC 1 land. And we know that the government is talking about and is consulting on actually removing LUC 3 land. At the moment, we've approached this as if LUC 3 is still still included in the transitional definitions, which is what's required. And the recent EDS case has confirmed that. But Mr. Bonis has also identified where land is LUC 3 and where if the policy statement happens to change in between now and your decision, where his recommendation is, where the LUC 3 classification is determinative for his recommendation. So hopefully he's made that clear enough for you to say, I think there's only one actually, for you to say, right, well the law's changed and so Mr. Bonis's recommendation on this is likely to change. So in terms of, so the two most relevant policies are 3.6 in relation to rezoning land to urban, and 3.7 and 3.10 in relation to rezoning land for rural lifestyle. And essentially, the way that 3.6 operates is that it says you can only rezone to urban if you meet these certain conditions. And those conditions are conjunctive, so they have to all be met, and they're set out at paragraph 40. And so the urban land must be required to provide sufficient development capacity to meet expected demand for housing or business. There must be no other reasonably practicable and feasible options for providing that capacity, and essentially the benefits must outweigh the costs of losing that HPL land from primary production. And even where those criteria are met, the spatial extent of an urban zone that covers HPL must be the minimum necessary to provide for that development capacity. And so of course Mr. Heath's analysis feeds into that clause 3.6 and that pathway. And so
Excuse me, Ms. Failer,
sorry.
Can I please just ask one question on that, just to be really clear in my mind? So is this an all or nothing test, meaning that all of those three limbs must be met, or does the panel have any discretion to recommend rezoning if only some are met, or if the evidence is incomplete? And so the reason I'm asking that question is to really understand what the legal risks are or the limits on the panel in recommending rezoning in those cases.
Yes, so the relevant provision there is 3.64 of the NPSHPL, and that's the one that applies to councils that aren't Tier 1 or Tier 2, so that applies to Timaru as a Tier 3. And the way that that's worded is it says the council may allow urban rezoning only if, and so to me that's quite a prescriptive requirement and creates a narrow pathway. And then each one of those criteria, A, B and C, is joined by an and so that means that each one of those criteria need to be met.
Thank you.
And that's really what I've picked up on in paragraph 42. In our view, the panel can't accept submissions seeking the rezoning of land unless all of those criteria are met. And in terms of rural lifestyle rezoning, clause 3.7 of the NPSHPL provides that councils must avoid rezoning HPL as rural lifestyle, except as provided in clause 3.10. And then 3.10 has a range of criteria as well. I think it's a slightly wider sort of pathway. There's more room for a little bit more discretion there, but it's still, you still need to be satisfied of each one of those limbs in 1A, B and C. And so they're set out at 43. Essentially, there need to be permanent or long-term constraints on land that mean that it's not economically viable to use for primary production for at least 30 years. The use would avoid any significant loss of productive capacity of HPL in the district and fragmentation of large and geographically cohesive areas, and potential risk sensitivity effects. And then again, the benefits essentially outweigh the costs of the loss of the HPL land. And so that brings me to an extra layer of complexity, which is what is actually HPL land and how does the transitional definition work, particularly in conjunction with the growth management strategies. And we have addressed that Mr. Bonas has addressed that quite well, I think, in the preliminary Section 42A report. So I've just provided a bit of a summary of that here, really. So essentially, if it's to be HPL, it needs to be zoned general rural, which all of these are, or rural production, which is not something that is used in the plan, and it's LUC 1, 2 or 3 land. And the complexity comes here, which is that it's not HPL land if it's identified for future urban development, and I'll come to that definition in a moment, or subject to a council-initiated notified plan change to rezone it, which would be the PDP, to urban or rural lifestyle. And the definition of identified for future urban development is that it needs to be identified either in a published future development strategy as land suitable for commencing urban development over the next 10 years, but the growth management strategy is not a future development strategy prepared under the NPSUD. It was prepared before the NPSUD came in, and it doesn't necessarily tick all of the boxes for one of those. So it doesn't fall into that limb, or a strategic planning document as an area suitable for commencing urban development over the next 10 years, and at a level of detail that makes the boundaries of the area identifiable in practice. So there's 2 or 3 key things there. The first is, what is urban development? That's actually not defined in either the NPSUD or the NPSHPL, but urban in relation to a zone is defined in the NPSHPL as residential, commercial, industrial, some special purpose, some open space, sport and recreation. So we've taken the view that urban zones, urban development in the context of the PDP is residential and industrial zones, but the rural lifestyle zone is not considered urban. And I'm just trying to remember why I said that, but I think it might come back to the national planning standards, but I'll have a chat to Mr. Bonas and come back to that one, I think. So essentially what I'm saying there is our, so urban development includes obviously residential and industrial, but not rural lifestyle. So what's a strategic planning document in the context of the HPL? We have those. They're the growth management strategies. And so to be a strategic planning document, it needs to be adopted by local authority resolution. The growth management strategies have. We did set that out in the, if I remember rightly, the HPL memo, and provided that information, but I can find it again if you need it. But essentially that's what the growth management strategies are, but they also need to actually be able to fall into that exception. They need to identify land for urban development over the next 10 years and at a level of detail that makes the boundaries of the area identifiable in practice. So the original 2018 growth management strategy doesn't identify specific land parcels, it just identifies general areas that would be suitable for future development. But the 2022 review does identify land at that level. And so it would fall under that definition of strategic planning document in terms of the exception. What it does do, though, it's not quite that simple. It identifies land that would be suitable for live zoning, which we've interpreted as essentially those ones that should be put into the PDP either as a rezone automatically or as an FDA. But then everything else is identified as other zoning opportunities, and we've interpreted that as not being suitable for development within the next 10 years or the life of this plan.
Why do you say an FDA is live zoned if it requires a plan change to actually zone it? Why is it not part of the other zoning opportunities?
Yes, I think, well, some of them might be identified as other zoning opportunities, and I can't recall the detail of what matches up with what, but you'll remember that I said the growth management strategy doesn't necessarily exactly reflect the FDAs or the zoning PDP. So there is a little bit of a difference between the two. But I guess what I'm saying is that if it's identified in the growth management strategy as suitable for live zoning, then we've interpreted that as being suitable within the next suitable for development in the next 10 years, as identified by the strategy itself, separate to what the PDP says, because the definition of HPL relies on the exemption that comes from being in a strategic planning document. Does that make sense? Pardon?
At cadastral level.
Yes.
The reason why I ask that is if there are submissions that relate to land that is identified as an FDA, but the submitter is saying, we want to go now, whether there's an argument open to them that effectively the council should be zoning now, i.e. live zoning, rather than identifying an FDA.
Sure.
Madam Chair, the Growth Management Strategy Review 2022 identified live zoning, but on the basis that an outline development plan or some sort of development area plan would actually need to be incorporated within the plan. So it didn't go as far as saying, here's an area, rezone it, go. It said that there are various other bits and pieces that need to happen with each of them, including an ODP, and it identified specific attributes with each area in a sort of generic sense that would have to be incorporated within an ODP before it then went through that stage. So it didn't identify them as a live zoning was probably not the best phrase to be used within the review, but essentially it was a two-step process.
Is there a difference, and it probably is a question for both of you, between an FDA, where there is obviously a plan change signalled, and that could be either the council-initiated DAP process or potentially an outline development plan, and a type of deferred zoning where the land is actually given an urban zone now, but subject to a plan change to implement an ODP with rules?
Yeah, sure.
Yes, and it's been raised by evidence from a number of parties for the application of an FUZ zone. I've incorporated that within my summary. I can either go into that now or...
So that deferred type status, is that the category that now the NPS would say is a fuzz or an FUZ? Is that the technique?
Effectively, in my view, they're the same thing. So an FDA is an overlay over a rural zone. A fuzz zone is a zone, but also requires a second stage to actually ignite it or engage it or put in the outline development plan and actually allow urbanisation to occur. The fundamental difference, as I'll go into, is how it's treated by the HPL, because under the HPL, a future urban zone is under the urban category, under the planning standards, and therefore the panel's determination as to HPL and whether or not it can actually proceed or engage has to commence straight away, whereas with an FDA we've taken the view that the zoning occurs later and therefore it doesn't come up hard against the HPL now, it comes up when the rezoning sort.
Sorry to harp on this issue, but I'm just bringing to mind probably the Christchurch context where historically there's been the sort of zone subject to an outline development plan technique used and how that then translate into the national planning standards, is there not another sort of iteration that precedes a fuzz, that is a zoning now with a set of rules that prescribe what has to happen in terms of an ODP rather than a plan change required to trigger the urban zoning?
That is a mechanism that I guess is available under the RMA, but it's not the one that's been engaged with in terms of the proposed plan. And as I go on to shortly, I don't think that there's sufficient evidence in front of the panel in terms of the alternative either.
Thank you, I appreciate that.
Thank you, Madam Chair. I think that's really taken us through the rest of submissions on the HPL. At 49 to 53-ish, that's really just a correction from some information that we'd given you previously around the relationship between some chapters and the use of the phrase or term that one chapter might take precedence over another. And we, as we were reviewing this chapter, realised that we'd actually omitted this one. So, as Mr Bonner said, this is essentially, the FDAs is an overlay overland and signals that there might be some change coming to this land, and the idea is that it signals that for essentially to ensure that investments aren't made in that land that might not have been worth it once the land gets rezoned. But so what it does do is say, despite the fact that we've got these objectives, policies and rules around primary production, if you're in the FDA overlay, these rules, if there's an inconsistency, take precedence, and these objectives and policies also need to have essentially additional weighting. That brings me to, what I might do actually is just pause there for a moment while we're on the growth chapter and turn to my supplementary legal submissions filed this morning. And as I said, these respond to the questions that you, thank you, gave us in advance of the hearing via minute 41. But obviously, given the time and some lack of context, we've attempted to provide you with some information that will hopefully help, but we recognise aren't necessarily the perfect answers to your questions. And so the most efficient way of doing that was just to provide some legal submissions, but I've certainly, Mr Bonnis and Ms Pfluger have provided me with the appendices and some of the information in them. So some questions may need to be directed to them. But essentially, at paragraph 5, again, have just set out some of the background. And part of the reason for doing that is just to be clear about the process that we've been to, as I mentioned earlier, the level of information that has come in, the approach that the council has taken in light of the lack of a lot of information around most things, but including landscape, including the brief that Ms Pfluger was given, because I don't want there to be any question about her evidence and the extent to which she did or didn't go into particular things.
I just want to make it clear too that our questions are not directed in terms of a criticism of Ms Pfluger. It's more of we needed to pull everything together into the correct statutory framing.
Yes.
And I appreciate the work that you've gone into to help us with that.
And I acknowledge that in hindsight there could have been sort of better linkages, I suppose, to those objectives and policies. So we've had our first initial step, but we're happy to provide some further information. So I might just jump to the legislative framework because you specifically asked for, specific provisions under the RMA in which landscape, amenity and character issues might be considered. And you'll recall my legal submissions from Hearing A had an extensive appendix that came from Colonial Vineyard case and also a summary in the main body of those submissions. And I've essentially summarised that summary here and pulled out the relevant bits that would be relevant consideration to consider the landscape effects. And they're set out at paragraph 12. So essentially, the PDP needs to be prepared in accordance with the council's functions and Part 2. Obviously, there are landscape and amenity and character issues in Parts 6 and 7, and also to give effect to the national policy statements and operative regional policy statements. And then in the Section 32 process, the objectives that are being advanced by a submitter need to be considered in terms of whether they're the most appropriate way to achieve the purpose of the RMA. And then the provisions of the proposal, i.e. other objectives, policies, rules, need to be examined as to whether they're the most appropriate way to achieve the objectives of the PDP, or if the proposal's suggesting they're amending those objectives in relation to those objectives. And so then, in terms of that analysis under 32(1)(b)(2) as to whether the provisions are the most appropriate to give effect to the objectives of the PDP, or to achieve those objectives, the benefits and costs of the proposal need to be assessed. So that's where landscape effects generally will come into consideration of a proposal, i.e. the alternative zones that are being promoted. And then generally in making decisions on rules, you need to have regard to the actual and potential effects on the environment, including adverse effects anyway. And so 13 really just puts that into context, which says we need to give effect to the higher order documents that guide landscape amenity and character, including natural character. Any proposed rezoning needs to be assessed in light of the strategic directions of the PDP that relate to those things, and the extent to which the proposed zoning achieves the objectives of the PDP must be evaluated, and the benefits and costs of landscape, amenity and character-related effects need to be identified and assessed. And as I said, we're in a situation where we don't have a lot of information about that, and Ms Fluker has just provided some initial sort of high-level comments to help Mr Bonis in his considerations when he's making recommendations, and the panel obviously as well. Paragraphs 14 to 17 really refer to the Appendix A. So Mr Bonis has provided this to me, which essentially sets out the objectives and policies in the regional policy statement and the PDP that have guided his recommendation in a landscape context. There aren't any landscape-related objectives and policies in the NPSHPL, and the only one in the NPSUD that I've picked up on that mentions amenity is Objective 4 and Policy 6, and really they're just saying, just because, they're saying this policy statement is providing for urban development, that's going to involve some change. That might change the amenity of areas. Some people might like it, some people might not, but the change itself is not an adverse effect.
Yeah, it's an interesting provision because obviously it's like at what point in time does it apply? But interesting also just in terms of the identification of FDAs. I think my initial concern with some of the conclusions reached by Ms Fluger, for example, if you take it to its extreme, however can an FDA that is in an underlying rural zone ever overcome changes to natural character and amenity expected in the rural zone? So when it comes to do a future plan change to actually rezone it for urban use, what is the environment that you are taking into account? Is Policy 6 effectively triggered at that point? And that might just require some reflection on. It just almost like, it seemed like, how can you ever say that there's no adverse landscape effect or amenity effect or rural character effect in that situation?
Yeah, and I think, I mean, in the context of Section 32, that's an assessment in terms of the costs and benefits, right? So it's not necessarily saying you can't ever, if there's going to be an effect, it's saying, well, how do you balance the benefits of the growth against the environmental costs, and what do you do? What provisions can you put in place in order to manage those the best that you can? And Ms Fluger's evidence has, in some cases, sort of given some signals as to what sorts of things might be required or what further information might be required in order to make that assessment. I mean, I can give some further thought to policy 6 if you like, but my sort of reading of that is really not even saying you can't take into account amenity effects, but it's really saying the change itself in amenity isn't necessarily an effect, adverse effect, yeah. You also asked how landscape amenity and character outside of those, what we sort of call Section 6 type landscapes, VAL is probably Section 7, but how they've been taken into account in the planning recommendations. And again, something that you can explore with Mr. Bonis, but essentially at paragraph 20 there, he has looked at, in relation to each submission, whether that proposal would give effect to the higher order instruments in terms of the growth aspects. So would it give effect to the NPSUD, the NPSHPL, and the regional policy statement provisions relating to consolidation and coordinated consolidation and coordinated settlement patterns, and efficient integration of infrastructure and land use, and then those provisions of the strategic directions in the PDP. And if he came to a conclusion that said, yes, I think it would, then he's really given some closer consideration to the landscape related effects in the context of that Section 32 cost-benefit analysis. He hasn't, where he has recommended submissions be rejected, he's only, on the basis of landscape, he's only done that because there's a lack of appropriate information for him to be able to make a positive recommendation. But where he has considered that the proposal would be the most appropriate way of achieving the objectives, he's done a 32AA assessment to support that recommendation. So, as I said at the beginning, there's scope through the evidence that you might hear to change his mind, but he hasn't had that information yet. And lastly, Appendix B, we've just attempted to, or Ms Fluger and Mr Bonis have attempted to provide some initial comments in response to the specific questions that you've asked, Ms Fluger. But I think we could probably just come back to those. Yeah. And just before, I'll come back to my, just the last few comments on financial contributions, and we've got Mr Willis online. So essentially, this council relies on financial contributions, not development contributions at this stage, to recover development costs. And I've just set out here the RMA requirements in terms of what the PDP needs to do. So it needs to set out the purpose of the contribution, how the level of the contribution will be determined, and when the financial contribution would be required. And obviously that's your financial contributions recovered when you impose a condition on a resource consent, and those conditions need to be in accordance with the purposes that are specified in the plan, and the level of contribution needs to be determined in accordance with the methodology essentially set out in the plan. And I think for the most part, the issue around certainty of financial contributions has been resolved, having read Mr. For the Rooney Group. Mr Holt? Yes, thank you. And so I don't necessarily need to go into those. Before I just finish, and this might interrupt the flow of this hearing, but I just wanted to raise with you too, Madam Chair, is that, in relation to the mapping comparison tool that the panel's requested the council to provide, we do have Mr Caswell from the council, who's one of the GIS operators here online, and I just wanted to raise that with you in case you wanted to have a conversation with him about what that might look like and what the limitations are.
Just park that till the end of the hearing. We've got quite a lot of things to get through.
Yep.
But just going back to financial contributions, the panel was just undertaking some preliminary deliberations yesterday, and we were working through some of the transport provisions, and I was reminded by the panel that Mr Williams had made submissions about financial contributions in relation to a proposed heavy traffic generating rule, and he made submissions about not only the statutory requirements but but conditions of consent still needing to meet the Newberry tests, and also fairness and reasonableness of financial contributions. And it just left me pondering as to how that relates to a rule that effectively permits an activity with a financial contribution. I'm thinking in particular the point that Mr. Hull has made for Rooney in relation to the open space requirement and the specification of the 4% requirement. And if there are arguments that that 4% is excessive or not fair and reasonable, how does that relate to a permitted activity rule? Do you understand what I mean? How does the council test whether or not in any given case 4% is fair and reasonable? Is there still a requirement for the council to evaluate on a case-by-case basis whether or not that's required? Because what happens is you essentially say, well, if it flips the onus or the responsibility on the applicant to say, well, we don't think 4% is reasonable in this case, therefore they're put in a consenting framework. So at what point is fairness and reasonableness needed to be considered? Do we dwell on that in terms of the framing of the rule?
Yeah.
Or is there still an argument to be had by a submitter in the context of a consenting regime?
Yeah. I mean, my gut reaction is that the condition itself needs to be fair and reasonable in the context of Newberry, but I might need to give some further thought to that as well. Yeah. Thank you. In that case, shall we start with Mr. Willis on financial contributions, given that he's online and...
That might be, yeah, and he can get on with his day.
Yes.
Then. Thank you. Right. Is he, Mr. Willis?
Good morning, Commissioners. So, probably my shortest report to
Just,
the panel.
sorry, Mr. Willis, just before you get underway, we'll just, can you hear us?
Set out in my, sorry?
Sorry, we just want to get the technology sorted. The volume's very low and we're having trouble hearing you. That would be the first. And now we can see you, so that's... You're in all directions.
Maybe I'll keep talking so you can sort the volume.
It is.
Behind.
Testing 1, 2, 3.
Yeah, that volume's much better. I'll turn my microphone off and we're in your hands. Thank you.
Thank you. Well, good morning, Commissioners. Yes, as I said before, this is my shortest report, which I was quite pleased about. And as set out in the summary, there were really only four, well, as I saw it, 4 key matters that were raised through the submissions process. And those, of those, only one was followed through with evidence from Mr. Hull on behalf of Rooney Group, which I think, Madam Chair, you raised just before, which is around the 4% financial contributions. I haven't formed a view on that 4% matter at this point in time. And I am interested in, I guess, the discussions and the questions of the panel. I note the questions you asked of for legals, and we will get back to you on that. In terms of the actual financial contributions chapter itself, there's not really anything that I want to bring to your attention other than the fact that all those issues appear to be resolved through or evidence except for that 4% contribution.
Thank you. The difficulty I'm having with understanding the 4% is that your opinions are entirely reliant on what Mr. Dixon has said in his evidence. And Mr. Dixon, as I understand it, is simply saying we're doing it because other districts have done it. And then I've gone back and looked at the Section 32 evaluation, which essentially says the same thing. So I'm struggling a little bit, and maybe you are too, in terms of forming an opinion. What is the evidential basis that the council was relying on to prescribe the 4% in relation to the open space?
I understand that the council is intending on developing new greenfield areas as part of urban growth, and I believe there is one for Gleneasy that's planned. $500 per section doesn't go a long way when you're procuring, developing, upgrading open space. And so my understanding is that that's been hasn't been sufficient for the council to properly provide the levels of service which the community expects for green space and recreation areas, and that they've looked around to see what other councils have done and determined that 4% is probably about right, which would give them sufficient capital to actually provide the level of services required. And Mr. Hull correctly points out that the council's revenue policy and LTP, etc., doesn't appear to identify the need for additional funding. My understanding is that the current LTP was based on the operative plan's approach to funding, and therefore hasn't taken that into account, that there will be additional funds, and that the LTP will be updated if and when this alternative approach is then provided forth with the district plan, and there is additional anticipated contributions coming through from this finished contributions process. So kind of sort of caught really through at a point in time where the existing LTP doesn't recognise it and hasn't planned for or identified because the funding wasn't available.
And as part of your report, have you interrogated the evidential basis or the reasoning why other districts have gone with the 4%?
No, I did not.
If Mr. Dixon has?
I know that he benchmarked that exercise against those councils. I'm not fully over the level of detail that he went to in his examination of why 4%, 5%, 7%, etc., and how and why that's spent by those councils. No.
Okay, well, I understand Mr. Dixon's not available, but it may be something that we can ask him to clarify for us. Other panel members, do you have any other questions about?
Kia ora. I have just two questions. I do have one question for Mr. Dixon, but we'll put that to him separately. My first question's around an issue that's been raised by some submitters around grandfathering of consents under the approved operative district plan, where they've said subdivisions that have been approved under that should not be subject to any increased contributions. And you've said, look, there's no need for a rule change to address it because council implementation practices already handle that. And is that a question for you, or is that a question for Mr. Dixon to understand how it actually does knit together in an operational sense?
Yeah, so look, my understanding is that the financial contribution is determined at the time of the consent or subdivision which triggered the need to take it, and it's fixed and determined at that time. So it doesn't go up just because the plan's changed. It's already established and certain and specified and written down. So when I first responded to that submission, I thought, well, yes, that's reasonable, because I wouldn't want that requirement to change on the way through, and grandfathering seemed appropriate. But then I realised, well, actually, it's not going to change, because through the operative plan, it's not going to retrospectively go back and change the requirement that's already been set.
Right, set at the time of consent.
Yeah,
okay.
Yeah.
That's really helpful. My next question was about the PPI practice versus policy. So Mr. Hull raised that the producer price index currently applied to will be currently applied to completed infrastructure works, and that it inflates the contribution beyond the actual cost. And he said that's inconsistent with the drafting, but so if it's set at the time of consent, how does the PPI then get applied under this plan for new development?
Yeah, well, I think the issue that Mr. Hull is raising is not necessarily an issue of the framework.
Right.
He actually, on closer examination, after reading my Section 42A report, and I had a phone conversation with Mr. Hull, he is comfortable with how the framework is specified. I think his issue is he thinks that approach hasn't been taken in practice by the council when establishing the financial contributions in the past. He hasn't. That's also set out in his evidence, so that's a matter for the council to consider and go back and check as to whether and how they have been applying that approach. And the approach is correct, it's just how it's been applied.
Okay, no, that's really helpful. Thank you.
Mr. Willis, just before you go, I just wondered if you could just walk us through. I wasn't quite clear how the certification process worked in the context of the financial contribution rules. So we've got the permitted activity, and then that's per 1, and per 2 is the certificate issued by the council. Or if there's a certificate issued by the council, it becomes a permitted activity. And I just wasn't entirely clear about how those rules work in practice.
Yeah, with financial contributions, there's not a lot of councils that do financial contributions, and some of the law around it has been uncertain in the past around can you have financial contributions on a permitted activity or not, or how would it apply. I guess the approach that I've taken here was that rather than dealing with it through a controlled activity and having an argument at the conditions stage and enforcement issues at the condition stage, which provides a less certainty, I've suggested that you can have a permitted activity rule and the council will simply provide you with a statement of what the financial contribution would be as determined through Appendix 7, but also with reference to the long-term plan and the various methodologies as identified in that. And the council will provide you with a statement of what the financial contribution should be. If you provide that, then it's permitted, basically. If you choose not to provide that, then it's a resource consent. And then there's some matters of assessment there which would permit the council to, I guess, consider through a resource consent pathway alternative approach than what's specified in the Appendix 7 and also the LTP, should there be a reason to do that. So it actually provides a bit more flexibility.
If it was a controlled activity, would that enable the council to do that sort of fair and reasonable test at that level to determine what actually the contribution should be, certify what the contribution is, rather than forcing a consent applicant to get a resource consent to argue the point with the council?
In practice, I think that there will be some discussion between the applicant and the council anyway when they provided the certificate for the amount. I would imagine there'd be dialogue as part of developing that. But yeah, potentially, yes, if it came through as a condition, that also might be some dialogue around the development of that figure through that conditions process. But at the same time, you either need to meet the permitted standard in the certificate, or you'd need to meet the condition, and you're in an objection pathway, either way. So from my perspective, I thought this approach here provides a bit more certainty and brings the matter up front rather than having to have an argument over whether or not you're meeting the conditions.
The way per 2 is phrased at the moment in terms of the certification, it's a certificate that no financial contribution is payable. Is there not the opportunity for that to include or a lesser contribution is payable? Why is it a sort of either you pay the prescribed amount or you don't pay it at all?
Yes, well, I guess a lesser amount could be set out in permitted standard 1 anyway, because the council identifies what the amount is in that first standard. This permitted standard 2 was simply there to ensure clarity around, well, if there isn't one that needs to be paid for because there simply is no infrastructure for you to connect to, or that requires upgrading, or you have already paid a financial contribution in part through a previous stage, and the council can confirm to you that there is none required. And so I thought there's value in confirming that pathway exists as well, rather than the council giving you a certificate which says what you need to pay is $0. So this came up through discussions with the Prime Port, actually, that there's a view there that in many instances, although they're doing a development, there is no infrastructure for them to connect to, and therefore wouldn't it be clearer to, rather than requiring a zero certificate, just simply saying the council's confirmed you don't need to pay a $0 certificate.
I've already flagged the issue we have in terms of the consent burden, I guess, in terms of determining whether there should be a lesser based on fair and reasonableness contribution. So it would be grateful if you could perhaps have further discussion with Ms. Vela about that and come back to us perhaps as part of your interim reply. Thank you.
Mm-hmm. Sure.
That's fine. Did you want to deal with designations now, and then we could break, and then we've got a clear run on Mr. Bonas?
Sure.
That's all right. We'll have a couple of coffees before we...
Good morning. My name's Rachel Williams, and I prepared the Section 42 on the designations that are being rolled over from the Operative District Plan and the Notices of Requirement. The purpose of that report was to assist the hearing panel in making recommendations to the relevant requiring authorities. The requiring authorities, other than Timaru District Council, will ultimately make the final decision whether or not to accept or reject in whole or part the panel's recommendations. Overall, I recommend, based on submissions, that all of the designations and notice of requirements are confirmed in the proposed district plan with the following modifications. Modifications to the mapped extent of Kerry Rail's designation as set out in Appendix B of my Section 42A summary statement. Modifications to the site identifier of Ministry of Education's designations to include legal descriptions, as well as other minor modifications, including incorporation of MEDU 11 into MEDU 9 and mapping modifications to MEDU 26 and MEDU 27. Minor updates to NZTA's designation and conditions being incorporated into MEDU 24 to MEDU 28, NZTA 1 and TDC 45. With respect to evidence lodged, there appears to be no outstanding matters in regards to the designations. And I also wanted to make one minor update to my Section 42A report. Figure 4 in my report on page 22 does not accurately demonstrate the location of the Hilton Exchange. The Hilton Exchange is a small white building located south of the red outline. It must have shifted in the turning it into a PDF. And I'm happy to answer any questions the panel may have.
Thank you, Ms. Williams. I would like to focus my questioning on your MEDU section. I would like to firstly talk about MDU 24, 25 and 26. I've got a series of questions I'd like to work through with you on that. I have a few concerns, so I'd like to work through that. So by requiring full compliance with the general residential zone development standards, are we not essentially overriding the benefit of the designation and treating these schools as ordinary land users? No. My thought process there was, because under the underlying zone rules, they would require resource consent to establish any buildings or anything like that. The purpose of requiring them to comply with the development standards was to ensure that any built form that was established in the future was compatible with the underlying zone in terms of its design and overall bulk conform. And to me, the underlying standards aren't overly onerous, requiring a 1 metre setback and requiring compliance with the recession planes. I don't think that's overly onerous and wouldn't. It still allows development to occur on those sites, but allows it in a way that is still compatible with the underlying zone, if that answers your question. Sort of. I've got one that might back that up then. So have you considered the precedent this may set for other public service designations in residential zones across the district? Does adding zoning standards undermine the streamlined nature of the designation process?
I don't believe so, because they still don't have to apply for resource consent. They have to go through the outline plan process, what requires them to submit particular information and what we can recommend changes to the designation. So imposing those conditions to me was important to make sure that any future built form was still compatible with the zone. Because I still think development should be compatible with the underlying zone to ensure that it achieves like the overall strategic directions of the district plan.
But could imposing these conditions result in the schools needing to seek resource consents for otherwise reasonable educational development, such as halls or a school library though?
No, they wouldn't have to get a resource consent, they would have to get an outline plan. What's a more streamlined form of resource consent? They don't need to be notified or things like that. It's more a streamlined process.
Okay. My final question on these is there any evidence of adverse effects from existing school operations that would require enforcement to protect neighbouring amenities? Like, is there any evidence of that on these particular schools?
I suppose it came through in the submissions, for example, pick up and drop off. And
no, so that's not. So that's with regards to 27 and 28.
Oh, sorry, I'm getting confused.
So that's not with these ones.
But I suppose no particular evidence. But I lived close to a school, and they can produce noise and traffic effects. But I've got.
Should put on the record, I also live next to a school, but that's not part of my consideration in the process. We're here to consider evidence that is being presented through submissions rather than your personal.
Oh, so no submissions were received and no evidence to my understanding.
Okay. Okay, so if we just move on now, if we move on now to 27 and 28, which has a different set of rules. Mm-hmm. So how does applying zone-based rules to a designated education facility align with the intent of the Resource Management Act, in particular section 171, which enables requiring authorities to achieve their objectives?
I'll just quickly get 171 up so I can refer to that. It's my understanding that we still need to consider the effects of any designation and that ensuring that it still achieves part 2 of the RMA. And it wouldn't have significant adverse effects on the environment or neighbouring properties. So, sorry, could you repeat the question?
Well, it's sort of similar to the previous questions, is how does applying the zone-based rules to a designated education facility align with the intent of the Resource Management Act, and in particular section 171, which enables requiring authorities to achieve their objectives?
Sorry, could you just repeat that one more time, just so I've got it clear in my head?
I'll try and rephrase it then. Would applying these conditions create inconsistencies across designated education sites in the district? And if so, what is the planning justification for treating Roncalli and Sacred Heart Primary School differently? Okay,
so we've got no scope to, with designations that have been rolled over from the operative district plan, we've got no scope to impose conditions or anything like that as part of this process because there was no, there was only minor modifications sought to those designations from the requiring authority. With putting in new notices of requirement, these are new sites that are going to be designated, and the designation process does allow for built form and new activities to be established separate from that Schedule 1 process, so neighbouring properties would have less of a say of new buildings and things like that were going to be developed. And I suppose when I was going through the Section 171 process, I was considering what would the effects of any new buildings or new activities be on those sites, and what conditions I thought from the underlying zone would be important to impose on those new notices of requirement.
So then, has there been any evidence presented on adverse effects from Roncalli or Sacred Heart's past developments that would justify these controls now?
I'm not, to my knowledge, apart from what was received in submissions. I would have to check with council's compliance and monitoring team to see if there's been any questions in relation to that or any complaints.
Okay, because that to one of the submitters, my question is, what is the relationship between Macaulay Trust and 7A Craigie Ave?
So it's my understanding that they live at that because there's a bus parking bay.
No, that's on the other side. So this is on Craigie Ave side, 7A Craigie Ave, Macaulay Trust, who is submitter 142, who are requesting the 10-metre yard setback.
Mm-hmm.
What is their relationship with that land?
I don't know the answer to that question, apart from their neighbouring property to the...
Yeah, well, I looked it up because I thought I would ask you first, but they do not own that land.
Oh, I did not. I wasn't aware of that.
So I was just trying to work out what the relationship between Macaulay Trust was, who are talking about 7A Craigie Ave and requesting these conditions when they do not own the land.
I'm not sure.
Okay, well, that's all right. Okay, so just moving on to the transport that you raised. Is it typical practice to apply district-wide transport thresholds like Trans 720 to a designated education site when the outline plan process already enables council to manage traffic-related effects?
I have reviewed other district plans, and the Selwyn district plan, for example, they do have some designated education sites that require a transport assessment.
What one, sorry? I missed.
The Selwyn district plan.
Oh, Selwyn, yep.
And the reason I incorporated that condition was to enable that information to be submitted to the council as part of the outline plan process, because it's my understanding that the council can't request further information on the outline plan. So if any information was needed in relation to transport, we wouldn't be able to ask for that. We would just be able to submit recommend changes based on what they submit as part of that process. And it might not necessarily manage all the effects that council wishes to provide feedback on or can provide input into.
So have any other designated schools in the district been made subject to these thresholds? And if not, why is Roncalli being treated differently?
I only had scope to recommend those conditions in relation to the new notices of requirement. I had no scope to recommend conditions.
No, but my question was, is there any other designated schools in the district? Do they have any of these?
No, it would only be Roncalli as the high school, and then it would be the other new notices of requirement would have the same condition.
Okay, because given the school already operates within a defined bus window, which I think which was in the evidence, and that vehicles can be cleared for emergency access, what evidence exists that further mitigation is needed?
There'll be no evidence to my knowledge. It was purely from talking to our council's land and transport manager. It was really if there was new development that increased the number of pupils that attend this college, to enable council to get an understanding of pick-up and drop-offs and whether or not that would require any further transport.
Is that there's been a new development or in the future?
Well, there's no future development to my understanding proposed, but there could be in future. It depends entirely on the school.
Okay, so has any monitoring or complaint data been presented to support the need for this additional control?
Not to my knowledge.
Okay, thank you.
I just have one kind of question grouping. Can you just help me understand the role of conditions and designations and what happens if a designating authority doesn't meet those conditions?
It's my understanding that they could still apply for an outline plan to not comply with those designations, or I'd have to look into that actually, as whether or not it would require a plan change or if they could do an outline plan process.
Thank you.
I might have to get back to you on that one.
That would be good. And also, because in particular I'm thinking about, clearly with resource consent standards for a zone, those standards, the permitted standards, are permitted.
Yes.
And there's an opportunity through a consent process to then seek something different. And I just want to be very clear in my understanding about whether that same situation applies to a designation condition. So that's the purpose of my
I'll
questions.
double check that for you.
Thank you.
No further questions for you, so thank you very much for your report. The panel will take our morning tea break now. We'll break for 15 minutes and then resume for Mr. Bonis's report. Thank you. Look, we'll get underway. Just a bit of sort of admin as to how we might handle the submissions or the reports. We'll hear from you, Mr. Bonas, and then the Council's associated experts who are either here or online. In terms of panel questioning, because of the volume of material, we've done our best to try and carve out priority topics per panel member. So the approach we were thinking was that happy for a bit of an open forum, that when the question is asked, if it's better directed to one of the experts, then they're welcome to, you can manage that and they can answer at that time, rather than us having to loop back through the same issues. And that we would probably start with just some general questions that apply to everything across, and the panel will ask questions about that, and then perhaps move through each FDA so that we can sort of group the questions, and then obviously the rezonings as well. Does that, so you'll just have to bear with us, because it's, the other thing is too that, you know, there might be a question related to a specific submitter, and then we've just got to make sure grouping. So with that said, I'm also just conscious that we have submitters that are waiting. Mr. Shercliffe, I think you're waiting as well. This could take a little more time than probably what's been allowed for, and if that's going to inconvenience any submitter, then we're open to sort of pausing and letting the submitter present their case if they're comfortable to do that. And we just apologise in advance, but it is quite a complex and big part of this week's hearing. So, thank you.
That's perfectly fine. Thank you, Madam Chair. And I was going to mention too that the council experts have reviewed all of the evidence, and they do have some initial comments to provide you on the evidence, so they can do that after Mr. Bonas. And I'll pass to Mr. Bonas now.
And I feel partially responsible for the way we're going to have to break this up, so thanks for bearing with me. I've got a summary, and I'll jump into that shortly, but I just, while it's sort of fresh in my mind, Madam Chair, you asked a question about clause 1.5 in the NPSUD this morning, and if I can turn the panel's attention, I don't expect you to sort of rifle through it, but I'll name the paragraph so that you can at least write it down and find it later. So 5.3.11 of the Section 42A report talks about the analysis provided by property economics has relied on evidence, is based on an application of a medium and a high growth forecast, inclusion of the competitiveness margins for buffers, for determining sufficiency in terms of meeting expected demand despite only being applicable to Tier 1 and 2 authorities, and has treated each urban area as a discrete spatial entity and not aggregate to either a district-wide assessment under the NPSHPL, that's the exemptions in terms of can you carve something out. For Tier 3, it's you have to demonstrate it at a district level, not at a settlement urban level, or consideration only of Timaru settlement as constitutes an urban environment under the NPSUD. I also note at paragraph 5.26, and this is in relation to the extent to which the rural lifestyle zone accounts for capacity. The rural lifestyle zone under both the planning standards and the proposed Timaru district plan is not an urban zone. Neither does the RLZ provide a contribution to sufficient development capacity for housing. It is neither an existing or new urban area, and that's referenced through the NPSUD clause 3.21a, or necessarily infrastructure ready, and that's NPSUD clause 3.2b. Accordingly, the assessment of housing demand capacity undertaken by property economics identifies a realisable capacity of 44 allotments associated with the notified RLZ, and also identifies the potential RLZ capacity that would be introduced through the notified FDAs. However, the property economics assessment neither relies on nor incorporates RLZ capacity as associated with meeting projected household and existing or new urban area demand requirements under either the high or medium growth forecasts so as to satisfy long-term 30-year demand. And that goes back to the point, I think, that you were raising, Madam Chair, as to clause 1.5. what do you do, or what can you do under a Tier 3? So those are all the additional elements that we've put into the assessment that have given me a little bit more confidence in terms of where the growth capacity and sufficiency assessments have popped up. So I'll jump into my summary, and I won't, given we've set aside possibly till Tuesday for questions, I'll try and whip through this as quickly as I can. I think we can probably take 1 to 3 as read. 4, the technical experts who provided evidence upon which I've relied in preparing the Section 42A report have considered the matters relevant to the expertise raised in evidence. They're available. They've actually provided summaries through to me, so I've got a reasonable understanding. I'll take 7 as read. That essentially just sets out, it was quite a difficult 42A, probably not only to read but also to draft in terms of how you set out key issues. So it was broken up in probably a different way from other 42A reports. In relation to evidence received, I will take that as read as well, and that's at paragraph 8. And then I'll jump into 10, summary of issues in evidence received. So at 11, jurisdictional matters, further submission number 272, evidence of misuse build. It is considered the outcome sought in the evidence of misbuild for Travers, further submission number 272, has outside the scope of the original submission. Further submission number 272 relates to original submissions 203, 211 and 216. The original submissions do not seek to spatially extend FDA 2 as sought in the evidence of misbuild. A further submission cannot expand on the scope, spatial extent or provisions beyond that raised by the original submission. And I've relayed that through to Ms. Bold, so that won't come as a surprise. In terms of the growth forecast, and this is the evidence of Ms. Dolan, and I've named the submissions there. In her planning evidence for the above parties, Ms. Dolan's criticised the property economics residential capacity report 24 and the industrial land economic assessment 25 as used within the evidence and relied upon by me. Now, Mr. Heath, who prepared the property economics report, is a qualified economist with significant experience preparing similar capacity analysis, and no technical evidence has been provided by the expert to challenge the property economics analysis. I've consulted with Mr. Heath, who considers that her criticisms are unfounded and is prepared to respond in more detail during this hearing if there are questions. Ms. Dolan states the property economics report has not been peer reviewed to analyse the data and confirm the assumptions made, and I recommend the property economics report be peer reviewed. In terms of an initial response, the Section 42A preliminary report contained the property economics residential capacity report, and it was issued on the 29th of October 2024, 7 months in advance to receipt of submission evidence. And we did that on purpose. We had a reasonable understanding that there was a reasonable supply of capacity, and we wanted to update that and provide that to the submitters before they went to the effort of providing responses. Question 1 and 2 requested submitters to test that analysis through technical experts and respond in submitted packages. Now, I repeated that message with submitters during the site visits. Now, I agree with Ms. Vella's legal submissions that submitters advocating to changes to the PDP have an evidential burden of establishing a case for those changes and are required to forward a proper evidential basis to support their submissions. I consider that the property economics, residential and industrial reports remain as a robust base for the panel to rely on their deliberations. And the off-piste discussion this morning as to all the checks and balances and additional buffers are part of why I have that confidence. Application of future urban zone, and that's the evidence of Ms. Dolan again, and I've identified the submissions. Ms. Dolan has requested in her evidence that the pathway for rezoning the above submissions should now be undertaken by way of future development zones rather than by the notified FDA framework. She suggests the FUZ could be subject to a structure plan that would also incorporate further technical investigations with infrastructure funding to subsequently be worked through between the developer and the council. Now, I note that the FDA or FUZ mechanism provides a two-stage process by which land is urbanised or zoned for rural lifestyle activities. And I understand the main difference between the mechanisms is that the FUZ process is implemented by a special purpose zone, future urban zone, embedded in the district plan, whereas an FDA in the proposed district plan is by way of an overlay. Both mechanisms require a subsequent plan change to enable urban development. I should also state that a FUZ zoning would not be applicable for rural lifestyle zone, simply because of the nature of what it is. An overview of the FDA mechanism is provided in the Section 42A report. Ms Dolan's approach also has potentially unintended consequences for those parties she represents in terms of the application of the NPSHPL, and this is what we were discussing earlier today. So I don't know if I need to read that all out again. It's pretty clear to the panel. At 25, I consider that the FDA framework established in the notified PTDP remains appropriate. In terms of the NPS for highly productive land, Ms Vella took everyone through that this morning, and I don't think I need to go through it again. I've identified which submissions that's still an outstanding matter, or was at least until I received evidence. And at 27A for sub number 30 McKnight, the analysis from Mr Milner is considered sufficient in my view in terms of a consideration under clause 310 as the rural lifestyle zoning is sought. In terms of corrections to my section 32A report at 28, I'll take all that as read, but essentially things have moved on in terms of urban development in Mr Willis's interim reply to the panel, just picking up Prime Port's request for port zone to be included, so I've incorporated that. In terms of the further submission, FS number 267 from Mr Shield, who I understood was going to attend today but is not, I've just noted there the structure of the Section 42A report and the way in which further submissions are reflected or acknowledged. They're not individually listed. In terms of a list of resolved and outstanding matters, that's included in Appendix A. And in terms of updates to recommendations, I've not provided a preliminary review at this time on the evidence submitted, except as identified in the statement, as I wish to hear the evidence and the panel's questions. However, at 38, I acknowledge the evidence of Ms Wharf on behalf of submission number 190, Payne, and I note that Ms Francis, Ms Trevawatha and Mr Massey for the Regional Council, as these relate to the Section 42A recommendations in relation to FDA 11. Essentially, in a nutshell, I understand the remaining contested matters associated with FDA 11 relate to density of any associated rezoning to rural lifestyle zone, 1.5 hectares versus 2 hectares, and the implications of establishing an immediate pathway for a rural lifestyle rezoning for FDA 11 without understanding the reality of the ability to get resource consents from the Regional Council. Essentially, is there a gap between a minimum zone size and whether or not ECAN would actually then provide resource consent for wastewater disposal? I note that I consider that further caucusing between the submitter, ECAN and relevant TD experts may be useful to recommend an appropriate solution should the panel direct to that. However, my initial view is that a 1.5 hectare density as sought by Ms Wharf would likely create conflict with the application of sub S14, which is the 2 hectare without reticulation rule. Effectively, the integrity of that would go immediately. At this stage, based on the evidence lodged and technical advice, I recommend acceptance of the following. Submission number 30, that's McKnight, and that's the addition of 2.26 hectares, as sought in the evidence of Mr Ross, as subject to further considerations as to plan mechanisms. I note Mr Ross sent through to me last night at a reasonable time potential mechanism to sort of deal with that last little issue. I didn't have time, unfortunately, to look through it. I met Mr Ross this morning and suggested to him that I would raise this as if the panel wishes to direct us to provide a joint witness statement on this very discrete matter, that's something that I think would benefit. Also, in terms of submission number 228, Westgarth, which is the alignment of the boundaries of FDA 1, FDA 4 and the top of boundary FDA 4. Ms Fluger has advised me that based on the receipt of the 1 metre contour information requested in the 42A report, the amending proposal associated with a realigned boundary is the more appropriate, and I agree. And lastly, just looking through the PowerPoints from Mr Shirtcliffe, he notes our interactions on the site visit. I've discussed that with him this morning, and I think the best that I can say is our recollections of that vary, to quote Queen Liz. So I can get each of the to go through these summaries. That's excellent. Mr Heath, are you available?
Morning, everyone. How are we going?
Oof.
Hear me all right?
Thank you, Mr Heath. We can hear you. Can you hear the panel?
Yes, I can. Thank you.
Okay, thank you. If you take us through your, there's no summary statement as such, it's just responses, an update, and a quick overview, and then an update on your position following receipt of submitted evidence. And then
Yes.
we'll move to the other council specialists, and then we'll circle back and ask our questions globally of the team, if that's all right.
Yep.
Thank you.
No problem. I suppose from the outset, it's really important to understand that the analysis and the numbers I've done have adopted the high growth scenario. Looking at the medium growth scenario, there wouldn't be much involvement with me because the existing zone provision is sufficient for the next 30 years comfortably. To put it into context, the high growth scenario or meeting the high growth projection series, there's only a 5% chance of that being realised. So, or a 5% chance of reaching the high growth scenario or more. So what that says is there's a 95% chance of it being below the high growth scenario. So at the moment, it's sort of tracking, it's been sort of following the medium and just popped up above the medium projection recently. And that's a result of the post-COVID sort of push across the country where immigration grew quite significantly. But that's tapered off now, and we're actually seeing a significant drop in net migration into the country. So that I think Ms. Dolan identified a 1.9% growth in 1 year. That's just a 1 year spike. It's not. It's unlikely to represent a long-term trend if we had some updated projections from that. So when I'm talking about these numbers and the capacity required, under the medium scenario, there is no additional zone land required. They're sufficient. It's only if you manage to reach the high projection, 5% chance, does a shortfall fall, and that's in the last sort of 10 year of the 30-year time frame that we're looking at. So it's a really optimistic baseline that we're using here on the assumption that if the high growth scenario is realised. But as I said, the chances of that actually occurring is very low according to the Stats New Zealand the latest Stats New Zealand projections. And I will say the most recent projections identified in my industrial report, which was an update from the projections in my residential report from late last year, Stats New Zealand actually softened those projections slightly. Very, very minor, but it was a slight projection reduction in the high growth. So that sort of provides an indication of the immediate post-COVID recovery correction. In terms of residential, in our modelling and looking at the PDP zones provisions and the market variables, under the high growth scenario, the PDP zones could supply approximately 4,000 new dwellings to the Timaru market. In addition, the growth areas have a potential to deliver a further 3,456, 3,500 additional dwellings to the market rounded. As I said, under the medium, you only require 1,000 new dwellings. So there is already more than sufficient to meet that particular projection series. Under the high growth scenario, if it's realised, need to provide for almost 5,000 dwellings. So that's over the long term. This means that the current realisable capacity is sufficient to supply 80% of that high growth scenario already to meet that capacity requirement. So even under a high growth scenario, you've got 80% of the provision already in play. 80% of the capacity, already in play. So what that means in reality is there's no additional capacity requirements to be put in place for the next 2 decades. And it's only in that third decade of the 30-year period would some pressure come on and additional capacity may be required subject to how the market's growing at that point in time. So it's not a short to medium term issue. In terms of that's sort of in a nutshell the residential overview. In terms of industrial, again, under the medium scenario, no issue with capacity. You already have that in play now with the zone provision. It's only under the high growth scenario that you're likely to get a potential shortfall in the long term. So again, the last 10-year period of that period. And I think we need to remember, and when we're looking at these projections, there is an objective to see some consolidation of land use activity within the district. That's from an economic efficiency perspective, and it's also a cost of infrastructure perspective. There's two angles there. The size of residential sites at the moment is large, and I think it's identified at just over 700 square metres in average site size in the existing urban area. That in the context of residential development and the market moving forward is large. The largest growth sector in the timber market, and actually any market, is the older demographic, who are less likely to require those large section sizes and are more. We're seeing the demand for more smaller properties, more manageable gardens, and lock up and leave type scenarios. So that more intensified product is really being driven by the baby boomers moving through their age cohorts and into retirement. So the demand that would have been there for those larger sections is probably going to start softening, and the demand for more intensified, smaller sites, but still standalone homes, which is what we've got in the realisable capacity, that's where the bulk of the demands come from, would be on smaller sites. And that's where the opportunity is to provide the efficiency and intensification required to better utilise the existing infrastructure assets that Timaru have in play. If we are going to rely on greenfield expansion to accommodate growth, we are in effect duplicating infrastructure resources, because there's existing capacity in the existing infrastructure assets. So that comes at a significant expense, one, in terms of the construction of those assets, and two, in terms of the ongoing maintenance. So it's a movement away from an efficient market and efficient utilisation of those assets. Just in terms of providing some, in terms of the submitter evidence, is most of the issues Ms. Dolan has sort of raised, and she's raised similar issues across multiple submitter evidence. So I'll just identify some of those issues and provide just a brief response to provide some context that hopefully the panel finds helpful. Ms. Dolan places a bit of weight on the local economy is strong and growing in the primary sector, and that it will continue. One, we can't be so categoric that it will continue. I'd like to think it will. That'd be great if it will. But what's driving that growth at the moment is rural primary sector productivity, not necessarily urban growth and urban land use growth. So they're quite different economic drivers. We can't use growth on farms to then justify rezoning of urban land. They're quite different. They're quite different beasts. But the fact that it's strong growth at the moment, or good growth at the moment, is a positive. And I certainly hope it's maintained. But in terms of the primary sector and rural growth, Ms. Dolan tries to use that as then a justification for more people wanting to move to the district. Well, there's no analysis on the comparative advantage that Timaru is gaining or not gaining that would drive that growth. So the rural sector growth is not only in Timaru, it's right across the country. The New Zealand is dominated by rural growth across the country, so unless there's some identified comparative advantage increase for Timaru rural sector, which hasn't been identified, I don't think we can rely on that alone to drive or justify there's going to be a strong increase in population, because the growth in the rural economy would spread it across the country, not just in Timaru. I talked about the 1 year spike that Ms. Dolan relies on as the 1.9%, and I've explained that was a post-COVID sugar hit, not only in Timaru but around the country, but that's softened significantly with about 100,000 less net migration now into the country from when that metric was identified. There was, I think, I need to make a correction in one of my responses on page 2, where I said that we've used a average site size of 450 in the general residential zone. It should be we used 450 as a minimum site size in that zone. And the importance of that is that I think Ms. Dolan has assumed that we've then put 450 across the whole general residential zone to justify capacity. That's not how the model works. We have to take a real world view in that there are existing sites in play of different sizes and shapes. So, for example, if there's a 1,200 square metre site that's in the market now, that would only yield 2 dwellings. So, because there's only 450, you can go into it twice. So that then leads to a higher average site size and median site size than the 450 assumption. So I've done some calculations, which is additional calculations since I've done this, and the median site size in Timaru as a result of all our modelling is actually 528 square metres. The average site size in Pleasant Point is 721 square metres. So the assumption that we're all racing to the bottom of the barrel to get the smaller site is just not real, and it's not what the district plan is promoting. And yes, the district plan is promoting a movement towards intensification and lowering some of the site sizes, but you've also got the existing market in play. So, and those site sizes are certainly of a size that can accommodate standalone dwellings. So we're not trying to say everyone's going to be living in terraced homes or apartments or anything like that. We're trying to keep a more balanced and practical approach to the modelling to provide that Timaru context. It's not Auckland, it's not Ponsonby, it's Timaru. So that's why we've adopted that scenario or that methodology to deliver a more practical and realistic. Because at the end of the day, given the objective of intensification, we need to move in that direction. So this isn't this is over a 30-year period. So this is just starting the movement. This isn't a cliff where we get there and suddenly everyone's going to jump into the minimum site size. It's going to take a period of time to move in that direction. So I've got a high level of comfort that growth in the Timaru market can be accommodated in standalone sites, and it can move towards more efficient use of its infrastructure assets and the urban form efficiency as well. I've talked about how the modelling and the analysis that I've done has adopted and utilised the high growth scenario. And again, that's a low percentage of it actually occurring. But even under the high growth scenario, we're cooking with gas for the next 20 years in terms of capacity. No issues. I've mentioned that earlier. I notice Ms. Dolan still wants to run with the sort of 700 to 900 square metre site, but there was no evidence to support her approach on that, or analysis on what the economic implications of that are in terms of land use efficiency and infrastructure funding. So it would have been useful to have that sort of follow-up analysis done so we could actually do some comparison, but it unfortunately wasn't provided. And that requires any comment. Oh, the other thing in relation to North Meadows, She made the point that there were no large vacant industrial sites available, or very limited industrial sites available in the market. While I didn't articulate that specifically in the report, there is certainly provision for large industrial sites currently. There are, just when I had a look at the numbers again, there were 6 sites over 2 hectares, including 1 over 13 hectares, 2 over 9 hectares, and 1 over 5.7 hectares. So at this point in time, there would be a provision for large sites, and there was no definition of what she means by large sites. So it was hard to break down sort of further, because some of those, for example, the 13 hectare site would be able to be chopped up, but still be considered a large industrial site in the Timaru context. So that's sort of a real quick run through of some of my main findings. But I think overall, I think the direction that the PDP is heading in terms of providing sufficient capacity, and we have added the NPSUD buffers or margins on, competitive advantage margins, to ensure that they're covering that base as well, which is not necessary. So I think the PDP is heading in the right direction and certainly providing sufficient capacity within the zones. Thank you.
Thank you, Mr. Heath. We'll move to the next witness.
I'll turn that on so I don't have to talk so loud. Kevin Kemp with the Drainage Water Unit and Stormwater Team Leader, but previously I was the infrastructure planner here at Council, and so I guess my evidence is based on that original role, and not so much evidence. Really, from the submissions that we received.
Mr. Kemp, could you move your microphone closer to you? We're just having a little trouble hearing you.
Is it not working? There it goes. That's better. From the, I guess, responses to the 42A report that we received, there weren't a significant amount of changes to my previous evidence. So I'll just go through the few adjustments that I have identified as, well, not so much adjustments, but just, I guess, quite or slight changes to the original evidence. For submission 19 on Waitui Deer Farm, they did give a bit more scope on yield that they could expect with that development, and across the full site area works out at about 115 hectares of the land, and they're looking at the 2 hectare or adjusting to being 2 hectare site minimums across that area, and worked out with about 57 new connections from a water servicing perspective. That would just trigger the need for a hydraulic assessment and to confirm that there is capacity in that Te Moana scheme for that volume. There has been upgrades to that network or to that system, to the Te Moana scheme, but this area in particular, part of it's serviced from Geraldine Township Supply. So there just need to be confirmation that that could be serviced. So a hydraulic assessment would be required, and it hasn't been provided at this time. So that would still be necessary to confirm servicing. And then they also raised an option for composting toilets, which that is an option for servicing residential units, but it would have to just be confirmed that they are compliant systems under the regional plan. Yeah, so that's Waitui Deer Farm. For submissions 160, 109, and 108, which are in relation to FDA 11.
So, sorry, Kevin, could I just interrupt you for a second? I've just had word that the online streaming isn't working at the moment. So apparently the experts are online, but the chambers isn't. Oh, okay. Thank you. Sorry to interrupt.
We were having Microsoft issues earlier today, so maybe they've kicked back off again. So for the FDA 11, I guess, suite of submissions, there were some, I know in Mr. Bonas' report, there was the idea of the 2 hectares, using the 2 hectare minimum rather than the going down to 5,000 square meters. That option is feasible from a water supply perspective for the existing units, the existing water that's serviced to that area. That area is within the Geraldine Flat Tamuana subcatchment, which is also serviced from the Geraldine Reservoir, or the urban reservoir. So it kind of has what's existing supply that exists or that's currently serviced is available. So if units are distributed from that existing supply, that's doable, that's achievable. But if there's additional units required over and above, there would need to be further assessment done to confirm if that's available or if upgrades are necessary and those types of adjustments. So redistribution of existing, all good. Over and above needs further assessment to make sure that that supply of water is available. And then from the sewer and stormwater perspective, I know there was some questions around the idea of going from 2 hectares to 1.5 hectare. The impact on local discharges to ground for sewer in particular is probably best assessed by ECAN. That'll be kind of their domain, being that it's outside of our stormwater management area and our groundwater management area. So the ECAN would be the best one to speak on that, on whether those on-site solutions are suitable for that slight adjustment, mainly just because it does increase the likely density of discharges. And the same goes for stormwater. It ends up leading, from a stormwater perspective, it ends up leading on to the cumulative effect that ECAN would start assessing. People up front at the beginning might be fine, but further down the line, it would start to cause a hindrance on the ability to develop and expand. So that's really it from Geraldine. There's no, didn't really have any other comments. For Timaru, there's really only 2 submissions that had further comments on. Everything, what was provided for the other kind of Timaru submissions don't have any changes on recommendation. And so one of them, the one that I have, number 20, submission 20, is the O'Neill property off Canoe Road. So there was a bit more detail provided as part of their response, and that was they did provide a design report from a subdivision that's recently been processed, and it is an example of a design report that could be provided as part of future subdivision, but it doesn't specifically cover any detail of the land that they're proposing to be changed into an FDA for rezoning for future rezoning to residential. So it is a good example, but it doesn't quite really apply to the site in question. And then the idea of swapping that or adjusting the general rule zoning and having that FDA overlay applied, I believe it is slightly risky from the sense that there's been uncertainty on the actual feasibility of development of that piece of land because of potential flood protection requirements, stormwater management areas necessary, and the land that will all end up eating up within that parcel. And then for the Whitewater, Dejoux, and Dejoux submissions submissions 248 and 157, around FDA 13 and FDA 14. I do need to agree with what Mr. Hull raised in there around the $13 to $15 million estimate that I included in my previous evidence. That was in relation to servicing both 13 and 14, because it involved bringing services, particularly from sewer, from our wastewater plant all the way through to directly service those parcels, those areas. And that was for sewer, and then from a water perspective, it was servicing from the existing water supply network. And it also included some pretty high-level contingencies and potential consenting costs. So, and the other, I guess, item that would have been included in that total is, from a stormwater perspective, there's quite a bit of unknown because it is outside of our stormwater management areas that are currently under consent, and so there would be consenting requirements and what type of stormwater management would be necessary for the industrial and that residential area, sorry, not residential, future urban area is a bit unknown without any sort of proposed plan for the sites. Otherwise, that's really the only other comments that I had from the evidence received or from the responses received.
Where are we at with the technology? Are we back on all good?
I think we're back online.
Thank you.
Yep.
Mr. Collins, are you able to take us through? Here he is.
Good morning, Commissioners. So I'm Matt Collins, transport expert. Picking up on Mr. Heath's evidence around there being, in his view, sufficient capacity, at least sort of for the next several decades. The rezonings or the submissions that have been sought, generally at the fringes of the urban area, and so development on urban fringes, can be characterized by creating high dependency on private vehicles and longer trips when compared with more intensive development within existing urban areas, which tend to have shorter trip distances because they're located closer to the locations that people are travelling to, and also greater trip choice in terms of walking, cycling become more of an option. Broadly speaking, the Timaru transport network doesn't have a lot of congestion issues. So the effects of any particular rezoning usually can be managed if that rezoning goes ahead. The caveat with that is that out of sequence zoning can affect council's transport funding, where they've got council obviously has constraints on the amount of funding it has for projects such as footpath extensions, the cycle network, repairs and maintenance, safety, addressing safety issues, things like that. So where rezoning comes out of sequence, that can affect council spend. Obviously, money that might be allocated to a particular priority area might have to be moved to address the cumulative effects of rezoning. So as I sort of referenced to before, there's none of the rezonings have an absolute fundamental constraint on transport that would mean that they would be unsuitable for rezoning. However, most of the sites, there hasn't been, in my view, sufficient assessment of all of the transport effects to understand whether the rezoning would manage the effects on the transport network. So I can dive into detail of particular submitters if you want, but what I thought I would do is rather just talk to the one exception where there was a relatively detailed evidence provided, and that was submitter 231, which is Blackler for 10 Burke Street in Pleasant Point. So with that submission, evidence was provided by Mr. Andy Carr, which is the level of assessment that I would expect should be provided to support rezonings. However, while I agree with the assessment by and large that Mr. Carr has made, I do have some concerns about that submission. So the rezoning is seeking general residential zone, which could enable if we assume a 12 dwelling per hectare yield, could lead to about 100 to 120 dwellings, whereas Mr. Carr has assessed the site as a retirement village, which is what the submitter is seeking. But as I said, the rezoning could actually enable residential dwelling with a much higher trip rate than that assumed by Mr. Carr. I've also got concerns that Mr. Carr has identified that there's the ODP, or the site plan has identified a vehicle connection through to George Street, whereas that would require third-party land. There's also some gaps in the footpath network, meaning that the site wouldn't have connections to the footpath network. Mr. Carr has proposed extending the footpath along Frederick Street. However, there's no provisions that are offered forward to secure that. And likewise, there is a connection shown to, sorry, I'm just skimming through my summary. My apologies. Let me just have a quick look at the map. There was another local street where a footpath connection was proposed. Let me just have a look at the district plan. Sorry, it was Burke Street that Mr. Carr had identified a footpath upgrade for, but there's also a pedestrian connection shown in the concept plan connecting to Frederick Street, and that doesn't have a footpath on it. So while I don't think there are any fundamental constraints to rezoning that site, along with a large number of the other sites, I don't think that TRAN Rule 10 gives council sufficient scope to manage transport effects through future resource consent process, and that gaps in the network or infrastructure upgrades that are needed need to be identified on an outline development plan. Are there any other sites that you would particularly like me to comment on?
No, but there may be questions about particular sites as we move to panel questions that you can answer as they arise.
Yes, certainly am. Good morning, Commissioners.
Ms. Pfluger.
So I didn't hear that. I am able to just give a very brief overview of my initial response based on the evidence that was received, or go straight to your questions, whatever you would prefer.
Thank you. If you just give us a very brief overview, and then the panel will move through the questioning area by area, and when landscape issues arise, then you can answer at that time. But thank you.
Certainly. Thank you. The only landscape expert evidence that was received was by Submitter McKnight, number 30. It was prepared by Mr. Greenshields, a landscape architect, and I found it very helpful. Provided an assessment and cross sections, and in general, it confirmed my initial concerns raised in my memo regarding the effects on amenity as viewed from below. It also proposed certain mitigation measures, which are essentially planting along the eastern boundaries in clusters, which I support, and I think that the effects can be managed. How this is going to exactly work in terms of getting it into the plan. There are still some discussions. We received an email late afternoon yesterday from Mr. Ross about that. It may be a tree planting standard, so that's still something that I would have to consider together with Mr. Bonus and provide you a more informed view on. Other than that, there was no landscape expert evidence. The landscape issues were mentioned in some of the submitted evidence prepared by planners, and as part of that, conceptual plans for discussions were provided. None of them provided any outline of mechanisms of how that would be implemented. So, and none of them contained a lot of detail that allowed me any more detailed assessment to provide further comment than what I already provided in my memo. If you want the submission numbers where that was the case, that was 231, 19, 128, and 237. And then there was one submission where I requested further information regarding the topographical contour data, which was for submission 227. And based on the information that was provided as part of the evidence, I now support the change of the northern boundary for FDA 4. And there was continued support from me for submission 160 and 190. I haven't changed my view on that. I already supported it initially. That was sort of the condensed version, but I'm very happy to go into details for each one of them.
Thank you, and thank you also for the work that you did with Mr. Bonus and Ms. Vila in terms of just setting the scene in terms of your evidence in the statutory context. Ms. Vila filed some further submissions or in response to that this morning, so thank you.
Yes, yeah, I prepared that together with Mr. Bonus. Yeah.
On that basis, Madam Chair and panel, we're available for questions.
Thank you very much. We'll start with just panel questions, just more on the sort of front end and overarching statutory context. Sure. And planning.
That'll be me then.
It probably will be you. I had asked you some questions in conjunction with Ms. Vila this morning, so that took care of most of those higher level NPSUD comments. But in light of your reflection on clause 1.5 in the NPSUD and how the council has pulled together the elements that are fit for purpose, essentially for Timaru, is what I heard. Well, I took from what you said. In the context of a well-functioning urban environment, although the argument is that technically it's really only the Timaru urban area as such that meets the definition of an urban environment, there's an emphasis in terms of Policy 1 around effectively providing housing choice and opportunities, again, fit for purpose to meet the need where that may be. So it's not just a sort of across the district as a whole. So in a planning context, are you able to talk about where providing for rural lifestyle development or further rezoning opportunities in the smaller locations such as Temuka, Geraldine and Pleasant Point fits in the context, or how we should view Policy 1 of the NPSUD?
There's a lot in there. I'll do my best. I guess the first point is probably the discussion that we were having earlier about how we've applied the sufficiency analysis. So rather than do it sort of clinically, we've applied it based on each settlement, and we've asked Mr. Heath to do that and also provide the capacity analysis. The buffers as well. In terms of the rural lifestyle zone, so I guess in terms of housing choice in an urban area for Policy 1, happy, and as Mr Heath took us through this morning, there's sufficiency there under a medium growth projection to 2053. If we get a high growth projection, we start to run out on only a couple of the settlements. And if you look at Mr Heath's memo that's attached to my evidence, I've got him to actually look at the high growth scenario and identify where we get a deficit over that short, medium and long term. So that deals with the residential capacity. In terms of the rural lifestyle zone, it's a really interesting question. And in my evidence, and I'll probably, if I can find it, I'd mentioned this morning that the rural lifestyle zone isn't technically urban in terms of the NPSUD, but you'll see references within my evidence, rightly or wrongly, that's up to you, as to where relevant as applied to rural lifestyle zone requests. I think the NPSUD means this. And the reason why I've done that is simply, as I've identified somewhere in my evidence, in my view, especially given a medium growth projection where we only need 1,000 households to 2053, that's sort of tail off after 2033, we start to plateau. If there's location or scale of rural lifestyle zoned opportunities on the edges of not only Timaru but also those smaller settlements, it starts to degrade from achieving a well-functioning urban environment, in my view, in terms of what we're trying to achieve, and also Objective 6 around the integration with infrastructure. And to put that in some sort of perspective, and again, it's a magnitude thing, looking at the submissions from Paris, which was submission 20, McKnight 30, Simmons 207, Ford 217, Morton 11, and Ford 33. And this is only on the outskirts of Timaru, so it's not looking at those other ones. Cumulatively, that's 205 hectares of people saying, we want a rural lifestyle zone. And at 2 hectares per household, that's 102 allotments. Now, if we need 1,000, all up to provide for medium growth, 10% of that is chunked out straight to rural lifestyle zone. In my view, that's not achieving the RPS limited in terms of rural lifestyle opportunities, but it's certainly not achieving the NPS in terms of well-functioning urban environments as well. Does that answer your question? It was a bit sort of windy, but...
It's sort of, it's a difficult policy context to work in, because on the one hand, we're sort of accepting that rural lifestyle areas will contribute to capacity, and yet there is that tipping point where they might in fact, well, capacity aside, as you're saying, may then detract from the NPSUD requirements for a well-functioning urban environment.
And I think that perhaps stepping back from the NPSUD and well-functioning urban environments, perhaps the more appropriate policy direction for the panel to look at is the RPS 531 in terms of that limited.
I was going to ask you about that. Do we, given we're dealing with a Tier 3 council and we've got that, can we just sort of not get too hung up on?
Unfortunately, the policies and objectives don't give us that ability. But I think you can tear it down. And I think the way that I've looked at it is really around that quantum and scale of the requests. And I've kind of gone, and it's a little fudgy, as relevant to, is not a great way of phrasing it, but I couldn't think of any other way of doing it. And I've kind of steered to the RPS provisions around limited, i.e. it's got to be a small extent of what's being provided, because we have to achieve these other things. We have to achieve consolidation. We have to achieve a coordinated settlement pattern. It has to be integrated with infrastructure. So I think it's dropping down to that next tier.
Okay. All right. Well, the other question I just had was quite a way down in the weeds in terms of getting into the objective, not that objectives and policies are, but more specifically looking at urban design principles. And I note that that policy 531 and the CRPS talks about, it uses high quality urban design as one of the principles that needs to be achieved for urban growth. But the Timaru District Plan, in the context, I think it comes up elsewhere, but I've just circled in FTA P4 when you're talking about the development plan, development area plans, it talks about requiring an understanding of how good urban design principles have informed the design. And I'm just curious about the differences and whether there is any real difference or...
There's an easy answer to this. We don't have any.
No. So what do
level.
they mean in the context of the objectives and policies?
Yeah, look, I think they're probably largely interchangeable in terms of the qualifier would be my answer. But the off-piste cheap answer I'll give you is that we don't actually have anything from the submitters that would kind of demonstrate an outline plan or a DAP level of material where they've asked for a rezoning immediately. That would give us the ability to sort of look at that and make a determination.
But then equally, how does the council decide what good urban design principles are or whether it's high quality urban design?
Look, and I know that that's raised issues in Christchurch as well. So the question is, in the RPS it talks about good design and then...
RPS, high quality urban design. And 531.
Yep.
5315. Yep. And then in your policy 4, proposed policy 4, talks about good urban design. If you can't answer it off the top of your head, I'm happy for you to
No, I can't, and I'd have to look at whether or not we had submissions
what the context, and there may be submissions, but we're also required to give effect to the CRPS. So.
You'll see that I've perhaps rated a couple of provisions out of 10 for some of the other things, and that may be one that if the panels agreed, I agree with the proposition. If we need to be giving effect to the RPS, and the RPS is looking for high, then alignment should be within the DAP. We should be asking for the same phrase. Sorry, it took me a while to get there.
No, that's fine. That's fine. All right. I'll start at the Ros, are you ready?
Thank you, Mr. Bonas. So I do have...
Paper with a lot of pens.
A table with a lot of pens, yes. I do have one very minor question followed by 2 general questions to begin with. So in your summary report at paragraph 40,
yes,
confirmation that you're referring to the McKnights, not the McO'Neill?
That's an easy one.
Yes, yep. Excellent, great. I just wanted to check that for the record.
I confirm, and I've even written it on mine, McKnight, but
great.
Thank you.
Thank you. So in relation to, so this is a question about the FDA Policy 6.
Yes.
And you have given some analysis to this policy in your Section 42A report, which is that given from your analysis, there's no national instrument, regional instrument providing foundation for the policy. And in your view, it would be better the purpose of the RMA would be better served if that policy was deleted. And you've said that given there are no submissions that are in outright opposition to that policy, that there's no scope to achieve that outcome in terms of not having the policy at all. And there's also your analysis suggests that there's no evidential basis for a key clause of that policy. Now, I'm wondering, in terms of clause 16 or other mechanisms in terms of our ability or our aspects for our consideration, I guess, is that appropriate that a policy can run through a process where there's no statutory foundation for it to be there at all?
It's certainly surprising. I think this whole report was a challenging one to write, but that one in particular really was, because the issue that I have with that particular policy is that it opens up a gateway for additional rural lifestyle zone requests, and it's very unclear in terms of application. Specifically, as you've seen in my evidence, have some concern with the 60% of existing rural lifestyle zone and the clarity around that. For urban, I don't have an issue at all because there's a policy draft, policy 8 in the NPSUD, crack on urban if you need it, provide it. There isn't the same for policy 6, and it doesn't really link us back to the RPS in terms of the discussion we were having before. 531, what is the purpose of rural residential development? And it should be limited. So best I could do was flag it to the panel, clearly identifying my disquiet and identifying and stretching clause 16 as much as I possibly could, ways to sort of improve it in terms of its application. I mean, all is not lost. If it stays within it, and again, this is only my view in terms of its flaws, it may not be shared by others, the strategic directions and urban form development provisions still need to be applied. The RPS still needs to be given effect to. Someone could utilise this as the expectation that they can lodge a plan change and a DAP request for future rural lifestyle zone, but then get turned down in terms of a merits-based consideration. But it does create a bit of an expectation.
Thank you. And so in terms of clarity, creating clear expectations for a plan provision and creating that clarity for a plan user, is there a way to make that clearer in this policy by way of a note? Or
I think the provisions or the introduction already identify the relationship with other chapters and the application of, I guess, strategic directions, and the strategic directions chapters do the same. But I guess unless you're a regular plan user, you might miss that to an extent and start down that trail. Again, it's around expectation.
I actually wonder whether or not that's something we could perhaps flag for Ms. Vila to respond to in terms of the interim reply. I know that there have been some submissions filed. Ms. Vila's already referred to them in terms of scope or the ability to make consequential changes, and perhaps we can reflect on that. Yeah.
Thank you. In terms of Ms. Dolan's evidence that we have in front of us around the general urban zone, the GUZ, the fuzz, not the GUZ,
Fuzz, sorry.
the fuzz.
Yep. That's all right. Grizzles and grozzles and gizzes.
Yes. So in reflecting on what the GUZ represents within that broader kind of the evolution or the legacy, the kind of genesis, if you like, of what's been promulgated in this proposal. And how does the fuzz fit in terms of we've got a framework here with policies and rules in front of us. We've got Ms. Dolan suggesting that is something that could be considered, and I think I've appreciated that there is scope within section, our consideration to consider that, but yet we don't have a framework in front of us to see how that would fit in. Have I understood that quickly?
Absolutely, and that's, I guess, my issue with it, to a degree. They're essentially the same mechanism. There's a two-step process in terms of identifying a spatial area in a rural zone at some other point. Under a fuzz, it's an urban zone under the national planning standards, and there's implications under the HPL. That's what we've talked about. Obviously, it can't be rural style zone as well. The FDA, similar sort of process, but it does it through an overlay, but says that you've got to lodge and have accepted a plan change before you can then urbanise it. So I'm not really sure what's being sought, and there isn't a package to look at all. And we've progressed this far. There's possibly also a public fairness scope of submission issue if we change courses now as well, because and is it, I guess, that Ms. Nolan, we are to respond to it. Is it just the areas that she's looking at it? Is it all of them? How would it apply? So there really isn't much for me to go on, apart from saying I think there's enough robustness in what you have in front of you in terms of the FDAs. That's gone out, it's been submitted on. I've written hefty and unwieldy report on it. So there's at least some certainty that there's a mechanism that works.
Thank you. It might be, Madam Chair, it might be useful if Ms Vela was able to address that as well. I think I recall you talking about some scope issues, but I'm not certain that this was covered in terms of fairness to others, that we don't have a framework of provisions in front of us, and that wasn't what was as notified.
Yes, I can address that. I haven't addressed anything in relation to scope in relation to these, but yes I can
Thank you.
address it.
My general questions were answered. So, but for a transport question and an economics question. So
neither of which I can assist with. So relevant experts will turn up, I'm sure.
Yeah, great. Because it's not a site-specific question, so this is for the transport person generally. So Mr. Collins, you talked at the beginning of your presentation about trip distances and being greater when you're doing greenfield development. And look, I do accept that, but I want to know how relevant is that when you're talking about towns like Geraldine or Pleasant Point or Temuka, where the travel distance is already pretty low?
And that's, I don't have the evidential basis for that because I haven't undertaken that level of detail of assessment. So my comment on that was fairly broad brush. It would depend on the extent to some of those smaller communities act as dormitory suburbs or commuter belt at the moment or potentially in the future. For those, if development is happening in those smaller areas and there's sufficient activity and facilities, retail opportunities, employment opportunities, et cetera, to make those self-contained, then yes, I agree that the trips or the distance that or the length of trips that occur there are going to be reasonably controlled because, I don't have the evidence, and the evidence hasn't been provided to me of the extent to which some of those smaller settlements do create trips outside of the immediate catchment.
Thank you.
Does that respond to your question?
Yes, it does. My next question is to Mr. Heath on economics, and it's quite a broad question. So I've understood that you've said from a high growth perspective, it's really only going to be 5% achievable and therefore 95% non-achievable. And you also provided evidence that you applied the competitive margins, which are not required for a tier 3. So, and I wanted to better understand, well, then why would you apply those competitive margins on top of, and what is the effect of that? Because my understanding is, yes, it's great to be transparent, but why apply a buffer when it's not required? And without it, the projected demand would therefore be lower, and the existing zones may already be sufficient. And then does it therefore make the rezoning requests, particularly those that are in a highly productive, on highly productive land, less compelling?
Was that aimed at me, Commissioner Tim here? Was that aimed at me because you were on mute for the first half of the question?
Okay, I'll abbreviate it, but yes, it is for you. So really, what I was saying is you've already said, look, high growth is only going to be 5% achievable, and then applied the competitive margin, so you've added a buffer on top of that when it's not required under a tier 3, and my take on putting those two things together means that projected demand is probably lower than what's been talked about, and therefore it makes rezoning requests less compelling. So why apply a competitive margin?
That's correct. Your interpretation of the likely trajectory of growth is likely to be softer and demand is likely to be softer. We typically do it in the analysis because we want to ensure that the provision of land for whether it's residential or industrial land provides sufficient opportunity for competitive markets to work, and there's unlikely to be any change in market conditions that would cause a sharp increase in land values or prices that would have an adverse effect on the competitiveness of that particular area. So we were generous in terms of, again, really making sure that the district had sufficient provision to meet those requirements, and we took an optimistic view to ensure that. So probably the most optimistic view, high growth scenario plus a margin. So let's just say, only 5% of a chance of being realised. Let's just say they get to 80% of that growth projection. They've still got sufficient land. So it's not until really you reach the high projection, 5% chance, that there's any issues. So I suppose that we were just trying to be conservative in terms of making sure there was sufficient land. And there has been, not necessarily in Timaru, but there has been in other markets where over time the projections can trend towards the high projection. And again, we just wanted to have that buffer to make sure that we provided sufficient capacity. And I've got a level of comfort that that's appropriate.
Okay, great, thank you. And it is helpful for you to confirm that I've understood it right and understand the risk. So,
well done.
Madam Chair, can I just ask a point of clarification? Because it might be how I heard the question. So was the question, if you're taking a high growth forecast and you're also adding a contingency, does that mean that we're likely to perhaps dispel or make it less credible that we're going to need more growth options? Because my understanding is it's the other way around. So what we've done is by providing a high growth forecast, we've inflated what the demand is likely to be. We've then added on top of that the contingency forecast based on that high growth demand, so it's inflated yet again, and then we've applied that against the rezoning requests. Whereas if we'd taken a medium growth only and hadn't provided any contingency, the bucket would be smaller, and therefore it might make those other FDAs more appropriate, or those other requests. Does that help? That's my understanding of how we've applied the growth forecasts. Yep, great.
I've got one general question for Mr. Bonas, and it's a weeds one in the provisions. It relates to reverse sensitivity.
Reverse sensitivity?
Yep. And it's in policy FDA P4 and FDA P5. There's reverse sensitivity, and then in addition there's the normal interface effects.
Yep.
So I just want to really have a clear understanding, in your view, what the difference is, and reverse sensitivity effects of whom on whom is what I'd like to understand.
So it's reverse sensitivity effects on the existing rural activities from the activities coming in and urbanising or rural lifestyle zoning. So that's the whom on whom. And what was the first part of the question?
How do they are they different, or how do they differ from interface effects? So in P4, it's got reverse sensitivity and kind of the compatibility between the areas.
Integration
in
and
FD5, it's reverse sensitivity and then the interface effects is a suggestion you've made to kind of explain what they are. And I just want to really clearly understand from your perspective, are they the same, different, or how are you considering reverse sensitivity effects relative to interface effects?
I'm seeing them as the same thing, but I'd like an opportunity to contemplate that a little bit further and provide a response. It's a fair question. Thanks.
I only have one question because most of it's been answered. But my question is just around FDA versus future urban zone. And when we did a deep dive, the original recommendation in the section 32 was for future urban zones, yet the notified plans went to an FTAs, back in the day, obviously. But my question is, would the future urban zones provide better alignment with the NPS, allow more responsiveness to market demand?
In terms of the history, so this is in relation to Ms Olin's evidence, not mine, but I can talk to the history of it. She's identified a GMS review in 2022, which identified using an FUZ as an opportunity to provide for growth areas. At that stage, there was a draft plan out. The draft didn't include any overlays or provisions for growth areas. It had development areas. All the plans report was doing was saying, here's FUZ as a mechanism. The council, for whatever reason, decided to go with an FDA, not an FUZ. And as I've discussed before, in my mind, the mechanisms are fairly similar. And that's kind of the history behind it. In terms of would it make a fundamental difference in terms of how growth is managed, apart from the HPL question that would have to be sitting front and centre with the panel, in my view, no. Essentially, they achieve the same thing.
No general questions of witnesses. No further general questions at this point. So we'll just move working through each of the development areas. So obviously FDA 1, so this is West Timaru. It is linked to 2 and 4. Am I correct?
Correct.
Yeah. So with that in mind, you can start questioning. You can cover off 1, 2 and 4.
Thank you, Mr. Bonus. So my question around FDA 1 in relation to Westgarth and Gibson, as we've heard this morning from Ms Pfluger about the receipt of the contour information, and you've obviously said in your summary that that is, in terms of your view, that aspect of the submission is resolved.
Yep, so essentially the spatial alignment that
Yes.
the submitter was seeking,
Yes,
absolutely.
that's sorted from your perspective. And in terms of the outstanding components, am I correct that that's the submitter's relief sought seeking immediate rezoning and a more responsive timeframe?
So for FDA 1, my understanding of the submission is rezone now.
Yes.
And for FDA 4, amend the DAP and Schedule 15 to be more responsive.
Yes. And your view is essentially that there's insufficient evidential basis for that relief?
In terms of the rezoning, it's really clear cut.
Yes.
There isn't any analysis at all or outline plan or DAP level of material. For FDA 4, it really comes down to the timing of when that capacity is needed based on the evidence of Mr Heath.
Yes.
I will say, however, that Schedule 15 identifies when a DAP is to be drafted. It doesn't then do a plan change or anything else.
Yeah.
And the council has started drafting up a DAP for FDA 1, 4 and 2 now, but I'd still be reluctant to put a requirement on the council that that's to be out and issued within a more responsive time period.
Okay, thank you. I have no further questions on FDA 1 or FDA 4 at this point, but FDA 2 is a different... FDA 2... FDA 2 relates to the submission of John and Glenys Travers, is that correct?
Further submission.
Further submission, that's right. And that's the evidence we have from Jessica Bald?
Correct.
Yes. So I understand Ms Vila has identified that there's a scope issue there in relation to what is being sought. in the evidence of Ms Bald. And I wanted to talk to you about that, particularly in her evidence statement. She leads to a conclusion at paragraph 39 that if the FDA2 overlay is retained as notified, that there is a potential adverse effect of isolated land being developed in a piecemeal and inefficient manner, leading to potential adverse effects on urban form servicing demands and cohesiveness of development. I wanted to gauge your response to that conclusion that is drawn there.
It's really short and based on 2 points. One is I don't think any of us can go there because there isn't an original submission to agree or disagree with. And I guess the second point, if I was looking at it afresh, I'd simply look at the spatial overlay of what it is that's been suggested, extending a fair bit into the rural area away from Pages Road, and also not aligning with any of the aligning roads and streets. Sorry, it took me a while to get there.
So in terms of scope and merits?
Correct.
Yeah, great, okay. Thank you. I had no further questions on FDA 1, 2 or 4.
Actually, my questions on FDA 3 are for the experts. So, first of all, Ms Pfluger on landscape. And so I'll just check that Ms Pfluger can hear me and I'm not on mute.
Yes.
Okay, great.
Thank you.
So with this particular rezoning request, to bring the timeframe forward, your view was that it will create an abrupt transition from the rural to urban, and it's in a gateway location in the town. And I just wanted to know whether there were any form of landscape mitigation, screening, setbacks, native planting that would reduce the visual effects and then make the rezoning more acceptable.
Can you give me the submission number, please?
So for that, it is Warren and Elizabeth Scott, 128, and Leanne Burden, 72, and ECAN, 183.
Thank you. I just want to go to my notes, please. So in relation to submission 128, Scott, that was one of those where we received a conceptual plan as part of Ms Stolin's evidence, which in general I support that, but it's very conceptual, and so it's very difficult to make any further comment because it doesn't provide any building platforms or any more specifics. So I think they are matters that can be resolved, but it's not. I'm not able to confirm that based on what we've received in the evidence.
Okay, thank you. And it seemed to me that your evidence focused on this being a gateway location. How relevant is that to the FDA 3? Because I couldn't quite see it being a gateway issue.
I'm not sure. Could you point me to that paragraph where I talk about the gateway?
No, I can't, so we can move on from that question.
Yeah. I don't think I did.
Okay, sure. Thank you. My next question's not it's not for Ms Pfluger, it is for Mr Kemp, so infrastructure. And that was just for that particular site there on the Scott's Farm future development area, trying to understand what upgrades would be required to bring forward the rezoning.
Sure.
And also whether they have any, I think you said there was no long-term plan funding set aside for the upgrades there, and I just wanted to confirm that or find out if it's set in any long-term plan funding.
Yeah. So, yep, the LTP doesn't include any, I guess, network extensions. There are long-term plan funding for water service improvements, upgrades in Geraldine, but there's no funding for actual network extensions. That's the main item, really, for all of the development areas. There's not long-term plan funding for extensions of networks to service future development areas or, development areas mainly. So that's from a water and sewer servicing perspective, that would be, I guess, be the main upgrade, is getting the network to the site. So that's one item. And then there would have to be a bit more of an assessment done from the wastewater perspective on impact to the downstream network, and if there's any upgrades of the mains downstream to the Geraldine wastewater ponds.
And I think I heard you say earlier today that for FDA 11, so the Templar Street Future Development Area,
yep,
that does have drinking water serviceability depending on whether or not it's the 2 or 1.5. And I wanted to know, well, what is the difference? Like, do both have then the drinking water, and is the main issue then wastewater or stormwater for FDA 3?
So the main difference for those two is one is rural lifestyle, and the other one is residential, whereas the rural lifestyle area is serviced by the Tamoana scheme, even though it's the Geraldine Flat sub-scheme, which is serviced by the Geraldine urban area. It's still part of the Tamoana scheme, and so it does get so in effect, those sites buy water from the Geraldine supply. And so there's kind of a set availability for water supply. Sewer would be, if the sewer network were to be extended for either 3 or 11, there would need to be capacity assessments done for the downstream network, for the sewer network. So, yeah, but for FDA 3, it'd be serviced water supply from the Geraldine urban supply, and so that would just need to be, I guess, more robustly checked to see what's any upgrades needed from the urban supply to FDA 3. They're on two separate lines. So really what it is that there's a main that comes, the residential area gets serviced by, they both come from the reservoir, but the residential area gets serviced from a main that's servicing the rest of the urban environment, whereas the rural lifestyle supply to that Geraldine Flat area is a separate line.
That's really helpful. And actually, that does explain the difference, because I was trying to understand the difference. So thank you.
They are right next to each other.
My next question, I only have one more question. It's actually economics. And this is, while we're talking about the Scott's Future Farm, FDA 3 in Geraldine, I thought it was probably timely just to ask Mr. Heath a question on Geraldine generally. Are you able to just check whether you can? Yep, great, okay. So my question is, you've provided that granular level of supply and demand, and we've had some evidence in from submitters that talk about their lived experience. So it's anecdotal evidence, and I wanted to know from your perspective, how much do you take that into account, that you've got these communities that are saying, we want to attract people to come and work here, and our businesses are suffering, and one of the reasons for it is that there is not appropriate housing supply?
that would be, through the modelling approach, we've done that through the medium and high growth scenario, and under both scenarios, Geraldine has sufficient capacity under the new provisions being provided. So in terms of the requirement for additional zoning to accommodate future growth, it's not required to provide land that could accommodate housing for employment growth and residential growth.
Yeah.
So, yeah, that's even used under the high scenario. There's sufficient capacity. So it's not a land issue or a land supply issue. It's if the market wants to deliver more homes to accommodate that demand, there's the potential for that to occur. So
That's actually
Yeah.
quite a point of difference here, and I just want to make sure I understand what you've said, which is there is the land available. The issue is people might not be building on that land to provide the houses if people are saying we don't have the houses available.
yeah, and that could be a situation now. Then the market response would be more homes would be built to satisfy that demand. If house prices if there's no additional housing developed, and house prices would, in theory, with demand there, increase. And if that demand increases, that would then catalyse the development and the building of more homes to accommodate that demand. So, yeah, to me, it could be a reflection looking back of we haven't got those large section sizes to accommodate, more builds. But that's not what the PDP is focusing on. Specifically, it's trying to provide a balanced regime of different types of typologies and a more efficient use of land and land resource and infrastructure. So based on my numbers, the land is there for development to occur. And if I can just give you, just bear with me, the median site size in Geraldine under realisable capacity is 586 square metres. So we're not saying they're going to have to be sardines, so to speak. You can still have standalone homes on those sections in terms of the zoned supply available to them.
Right, thank you. Is there also a question, like you talked about housing topology, so could it also be an issue that there's not the right type of homes? So I'm trying to understand the evidence that is in front of us from businesses that are saying we need worker accommodation and we don't have it. Is it possible that it's just the wrong type of houses?
Yeah, there's certainly the housing topology and supply there now is a reflection of the past.
Okay.
So, and they're not alone in dealing with worker accommodation. I've seen no evidence or numbers to say what the work accommodation would be and what their specific dwelling requirements are. I mean, Hawke's Bay deals with it, and Marlborough deal with it, in fruit picking season. I'm not too sure what work accommodation they're trying to refer to. Are they saying there isn't enough homes? Is there not enough homes or is there not enough specific type of home for workers to live? Because based on what we've seen and then in the numbers that are available, there is sufficient homes and sufficient capacity to build more homes to accommodate an increase in population.
Okay, great.
Worker or otherwise. Yeah.
That's helpful, thank you.
Yeah. Yeah. The only little caveat I would say though is that when we're talking about retirement villages specifically, they do have typically have a larger land requirement. They normally have 8 to 10 hectares, depending on the size of the market, of a single land holding required. Now, that's difficult to find in brownfield sites. Although 8 to 10 hectare sites are already developed largely. So they would need to come in and identify a site or a zone, a piece of land, and then get that rezoned for a specific type of development. And you can obviously, that's different to the general market. They have, full continuum of care type facilities and some villas and things like that for retired people. It's just a zone. You don't zone for a specific retirement village per se. So, but that would be one that I would suggest, but that's not working because that's tend to be at the other end of the life scale. So, but the district plans around the country do struggle to provide sufficient land for that specific sector of the market, albeit to be honest, it's the largest growth sector because you don't zone for retirement villages. It's not a retirement village zone, so to speak.
Actually is really helpful, particularly because it's relevant for the Scots Farm. So thank you for adding that in. Helpful.
Yep.
FDA 5.
Oh, no, I have no questions for 5.
Okay. FDA 6, which is Temuka.
Okay, I have a couple of questions for you, Mr. Bonis, please. My first question is, you refer to UFD 01 and Policy 5.31 in imposing the rezoning. If a site is contiguous, infrastructure is feasible and housing demand is credible, wouldn't this support a coordinated and integrated settlement pattern?
I think the key pivot to that is the demand there, and for this particular one, in fact for a lot of them, Temuka's got a surplus, I think, to long-term, 30 years. I'd have to confirm that, but I'm happy to. It's at least got a medium through to 2053. And again, I think it goes to the point that Mr. Heath was talking about. The policy of the plan talks about consolidation. If there's too many release valves, you're never going to get consolidation. You're never going to achieve what your plan is seeking. So, there was a reason why this one was in the growth management strategy. It's in a good location. It's close to the school and various other bits and pieces. If there was demand absolutely off the rails, it would be a really easy thing for me to recommend accept. But there's not. Neither have we got anything in terms of infrastructure and how that's going to be provided. Neither have we actually got a concept plan or how the matters in FDA P4 are going to be addressed by an immediate rezoning. So it's on those bases.
I have FDA 6 and 7, and I feel like there's quite a crossover there, so I might just keep going with my questions because I have some that sort of cross over. So, for example, you've supported FDA 7 for development of 2 years, despite knowing service limitations. Can you explain why FDA 7 is prioritised ahead of this one, FDA 6? And how did you distinguish between 7 and 6 in terms of readiness and justification?
So the submission for FDA 7 was simply in support of what was in the plan. They weren't seeking any change. So from that perspective, accept is very easy because they don't want any amendments made to that. Whilst that was a priority year for 2 years, and FDA 6 was 10. Again, I didn't draft the provisions, but I can only assume it's on the basis that FDA 7 is largely cut up at the moment at sort of 2 to 3 hectare blocks anyway without reticulated sewer. It's largely in a pattern and form that is what it says it's going to be zoned as. So that's probably the reason why it's more of a priority in the plan.
Move on to that one now, because what you've just... So I had a question around that, because I'm on FDA 7 now. So if only 2 hectare lots are achievable in the short term, is the capacity gain meaningful enough to justify its priority status?
I think it's probably, as I was sort of stating in my answer before, more just a recognition of what's already there rather than actually providing for sufficiency. And if you remember in the discussion that we had right at the beginning, the property economics report doesn't use rural lifestyle zone in terms of providing or adding to sufficiency because it's not urban per se under the NPSUD, therefore isn't taken up in the sort of sufficiency discussion. So I think it's probably a pragmatic one. FDA 7's largely rural lifestyle now. let's just get it on the box.
This is probably a question for Mr. Kemp with regards to FDA 7. Has the wastewater servicing for FDA 7 been funded or scheduled in the LTP?
Not that I'm aware of.
Just going back to you, Mr. Bonas, what rationale supports retaining this as a potential growth area without any evidential package, noting that council hasn't, that I understand, haven't even started a development area plan process for this?
The basis for its inclusion is its inclusion within the Growth Management Strategy 2018, and under section 74, I think it's 3, regards got to be had to management plans, so that's probably where it came from in terms of its inclusion in the district plan. And there are only submissions seeking support for what's in the plan. So my hands are tied, there's nothing more I can do with it.
Because I presume you can't answer this either, but what level of engagement has occurred between council and owners of A7 regarding servicing and infrastructure timing, with it being within 2 years?
I can't answer for the council, but I can answer for myself. I've gone out there twice and met with the locals. They're very, very keen to see it brought forward. They would love to see some servicing because it means obviously they get a higher density. But I guess that's why the DAP process is there. Thank you.
I only just have one question, and it's about FDA 7, which I totally accept that you have said you're just supporting what has been put forward and there's no submissions in opposition. Now, we obviously have to take into account Section 6 RMA matters and the cultural values and effects on mana whenua, and I wanted to know, given that this is pretty much a hard no from mana whenua to say, look, we don't really support this unless there's some future direct engagement and connection, then I just wanted to know down the track then, at the next stage, like at what point will a cultural impact assessment be gathered and taken into account?
That was a good question. It would need to be incorporated within the DAP. I'll see if I can find the clause, and it would certainly be a requirement under the Act anyway when the plan change comes through. So it is a requirement of Policy 4. And my understanding was that mana whenua were concerned about increased intensification in terms of waste. The site is pretty much developed out now to 2 hectare sort of average anyway. So if all the rezoning does is ultimately give them an SCA with 2 hectare minimum on the basis that wastewater is not going to be provided, then there won't be any material change. Obviously, the values of mana whenua in terms of maintaining on-site disposal stays, but it won't get any worse.
My understanding is that's their main concern as well. It's about the cumulative impacts on water in Mahinga Kai.
Yep, it's around intensification.
Yep.
Just moving to FDA 8 now, I just have one simple question actually. Can you confirm that removal of FDA 8 from Schedule 15 is primarily, oh, can't even speak.
It's been a long morning for all of us. You're doing fine.
Sorry, based on Waka Kotahi's submission?
As on NZTA submission?
Yeah.
The submission seeks for it to be removed, and the reasons for the seeking for it to be removed are around transport, because that's the role they advocate for. I've identified in my report that based on transport, those matters are sort of finely balanced. Simply around, whilst I think that DAP 4, and given the location of the Manch Road FDA 8, would integrate relatively well with Pleasant Point. It's miles. Pleasant Point doesn't have what I've referred to as social and functional amenity. It doesn't offer a lot of employment or shops or services or various other bits and pieces. So people will live there, get in their cars, drive to Timaru or through to Geraldine. So the transport benefits of it are really low. I've then gone on and said that one of the things that's occurred between the plan being notified and now is the NPSHPL. And part of the site is LUC2, quite a significant part of the site. I've then quite carefully identified that, in my view, it makes very little point to take forward a DAP for this site when it is destined to fail. So no matter what the government does with LUC3, LUC2 will remain. Is that linked to the NZTA submission? No. And I've tried to make that really, really clear. But I think there's still good reasons for it to be removed.
I appreciate that.
Thank you.
Thank you. FDA 10, more a question just to clarify my understanding of where we're up to in the process with that FDA.
I'm not sure anymore. Sorry, I'll keep up. Yep.
FDA 10. So my understanding is that there was a submission package received, but we have no further evidence available to us for this hearing. Is that correct?
That's my understanding as well. There was submissions seeking, this is Forward 33, seeking an extension of the zone. And whilst they provided something, I think it was a submission rather than evidence.
Yes, submissions by Mr. Rabbage.
That's correct. And on my notes I've written, doesn't advanced matters considered relevant in the 42A report recommend rejection?
Thank you.
So this is FTA 11 and the submission by the Paynes in relation to the site. So.
So I do have a number of questions. My first question was on strategic planning justification to rezone now, like to do the rezoning, the acceptance part, for and you've said to put an SCA over top with a 2 hectare minimum lot size. So, and I just wanted to know, like, talking that through, like, what is the justification for a shift now? And also then I wanted to talk more about the servicing and, the limits on servicing water, wastewater and stormwater, and understand the whole site a bit better, so a combination of both yourself, Mr. Bonis, and also Mr. Kemp.
Perhaps if I go just briefly first and just sort of hit the high notes. So Schedule 15 identifies the DAP process for it being 10 years plus. In looking at the site and getting the evidence from the experts and meeting the Paynes, I reached the conclusion that 10 years is not going to make a lot of difference. There's a residual issue there now as to what is the appropriate zone on this particular block of land. as Ms Pfluger's carefully enunciated, and I agree with her, the character and amenity is more akin to rural lifestyle zone rather than a 40 hectare GRUS. And I have some sympathy for the submitter evidence from Ms Wharf when she lays that out in quite that way. So we agree. So essentially it then comes down to, in my view, are those engineering hurdles able to be overcome now or in 10 years' time? And if we were looking for higher density, I would suggest that appropriately there should be a delay because there's a need for a DAP, there's intensification, there's a waterway that runs through the middle, there's iwi issues in terms of wastewater disposal on site. With a more larger lot rural lifestyle zone and very minimal increased intensification, I think I've identified 6 lots. Does that overcome all those hurdles? And in my view, it overcomes water supply. There's this issue in terms of whether or not it sufficiently overcomes wastewater, but it overcomes also the need for a DAP. We're not intensifying. There's a Esplanade Reserve requirement that'll be triggered with subdivision that would require increased Esplanade Reserve along the waterway. What further gains would there be by delaying? So that was the rationale in the planning report.
Yeah. And so just on the wastewater, so the way I'm seeing it, and just this is me testing my understanding, is there could be an issue with getting a wastewater consent, but that's really an ECAN issue rather than this district plan. Or how would you say it then?
Yeah, look, I think in a perfect world, you look at aligning your zoning requirements with what the expectation's going to be. So it does cause me discomfort because the land and water plan has a 4 hectare minimum for permitted activity for on-site water. The district plan has a 2 hectare without wastewater through the subdivision chapter, so that there is a gap there. And the evidence of the regional council is not that there wouldn't be a pathway to get consent, but we don't know what that is yet. And that's why I've recommended that perhaps there's further work for the planners and engineers to do in terms of caucusing around this. So that there's an engineering hurdle to get over, but I guess as a planner and applying the Resource Management Act and applying the district plan, I have some discomfort with retaining the general rural zone over this block of land in perpetuity, or at least 10 years' time, and then there's another bit of work and cost that goes with it in terms of what an outcome is going to be, because the circumstances there are not general rural. So the 2 hectare minimum as an SCA linked in with the subdivision provisions, and that was the alignment or the recommendation that I put to the panel.
I think ECAN, I think they class it as, or they've shared that there's a risk of the zoning creating false expectations. I think that's what the evidence said. So would you agree with that?
So and that's why I said, look, in a perfect world, you'd line these things up.
Okay, thank you. I have a general question on the cultural values that you talked about, and my understanding is that it's been proposed that could actually be worked through at down the track at a later stage, and I wanted to know what is appropriate, when is the time to really consider, to take into effect the cultural values that are connected with the land.
Well, I think Ms Hall's provided the panel with her expert view. I have, as a courtesy, discussed and actually provided her a copy of my report well in advance of it being provided to anyone else, and discussed through this matter with her, but her evidence stands.
Okay, great, thank you. My next question is actually for Mr Kemp, and that's about the sewer system, or the wastewater system. So it's confirmed there's no town sewage supply at the moment, and it's talking about how to deal with the toilet and the grey water. And I wanted to know, from your perspective, how realistic or safe is it for housing to be here when there's no sewage system in place, because you've raised some concerns about the black water disposal, and I wanted to just, you share that a little bit more so I understand what the concern is.
Yeah, so with the black water disposal, the main I guess issue with that is haulage of it and the frequency of having to have your tank pumped out and disposed of, because it's not a septic system that's discharging to land. It requires that it's emptied and disposed of at a facility. So there's just going to be an ongoing cost, which if it is a solution in that basis. It's just people being well aware that there's going to be a cost, an ongoing cost of that. And they would be getting carted to Timaru, not to the Geraldine wastewater ponds, because the Geraldine wastewater ponds can't accommodate black water. We'd have to go to the Timaru ponds. So that's a increase on those costs.
And my last question is about stormwater flooding and runoff. And my understanding of the cultural evidence or the cultural values is that this is a real concern for them. And so I wanted to know from you, if the homes were built here, where would the rainwater go? And is there a risk of it going into the nearby stream?
So it most likely would accumulate at that upper catchment of the Rakapuka stream and then carry on through down to eventually draining into the Waihi. But yeah, so it would ultimately drain into the waterway that runs through the middle of FDA 11. And there's measures that could be put in place, but that is what's going to happen with the stormwater. It's all going to flow downhill.
Okay. Thank you.
Mr. Bonner, just a point of clarification for you. If subdivision standard didn't say 2 hectares and said a different number, say 1.5 hectares, does that overcome the issue you've got from a plan perspective versus the servicing issue?
In terms of the architecture of the plan, yes.
Move to 13 and 14. Do you have questions? Yeah.
Thank you, Mr. Bonas. In relation to FDA 13 and 14, we have evidence from Mr. Hull. And I had a couple of questions around what is presented in that evidence. In relation to FDA 13, right. I'll let you get to the right. Yeah. Okay, thank you. So Mr. Hull steps through, I guess, from the practicability perspective of what's on the ground, what's owned, what's under their control, and what they see to be a more pragmatic result in terms of industrial zoning. And I'm interested from your perspective on 2 issues. Is given that land is bound, and there is very clear evidence from Mr. Hull that there is some kind of logical connection there in terms of practicalities. To what extent is that a consideration in your assessment, and can it be? And then connected to that, is that something that is there an argument there that based on this particular on-the-ground specifics in this particular location, that the, I guess, theoretical projections could be compromised on? Does that make sense, that question?
Yeah, no, it does. Look, and I think in terms of FDA 13, which is the industrial one, the conclusion that I've reached at the end, and look, NZTA were seeking that it be removed, and Mr. Hull was seeking it be rezoned now. I've effectively just held the line, which is an easy decision to make. Look, there's some logical extension to it. I know there's some issues in terms of, and perhaps Mr Kemp can talk to this, it talks about the logical, Mr Hole's evidence talks about the logical flow of industrial development through Washdyke, but my understanding is that that middle block that's currently zoned isn't fully serviced up to a level that necessarily provides for a range of activities or a range of industrial activities for what would be that next block. I've also had to take into account Mr Heath's evidence in terms of industrial capacity and what's provided, and my understanding is that there was, I think it's 95 hectares by 2033 we've still got left. And the conclusion that I ended up reaching was it's owned contiguously by Mr Rooney, or what was Whitewater, which goes a long way in terms of being able to develop anything in a coordinated way. I'm not helped by the fact that there's no technical information by Mr Hole in terms of infrastructure or integration, and hence the conclusion was just to leave it as it was. If there was a shortfall of industrial, that would be an issue. FDA 14 is an entirely different kettle of fish. It's residential. It wasn't identified in the 2018 growth strategy. It was identified in the review in 2022, but on the basis that something substantial would have to change. And on that basis, and also the evidence that I've got from each of the experts, is actually servicing it's difficult. It's peripheral in terms of its location. It doesn't consolidate, it doesn't coordinate, and we don't need it in terms of growth. That was where I went with the NZTA submission.
Thank you, that's very helpful. Earlier today we heard Mr Kemp in response to Mr Hole's challenge on the data, the cost projections that had been used, and I wanted to follow through and close that loop with you in terms of what is the impact of that discrepancy on your, is there any bearing on your assessment there?
Perhaps if Mr Kemp could read you through, because I've seen his notes, what's actually required to service FDA 14. It doesn't shift the needle. It's still a significant amount of infrastructure that would be required. And there's a 900 metre section of trunk mains just to get us close.
Thank you. And in terms of, in Mr Hole's evidence at paragraph 37, there is a statement there around your statement in your section 42A, which says that there is no funding for servicing in the long-term plan. And Mr Hole has said that the fact that no funding has been provided for servicing FDA 14 in the LTP is not unusual and not an impediment to the site being developed. So I'm wondering your response to that statement in particular, or perhaps that's Mr Kemp as well.
I can have a quick go at it. I think it comes down to what the plan's seeking to do in terms of efficient infrastructure provision, and that's both at RPS level and in terms of the proposed plan.
Yeah.
In terms of efficient infrastructure provision, it's not, it doesn't specify or distinguish between private infrastructure and public infrastructure. Also, without any growth, all we're doing is duplicating infrastructure services without additional demand feeding in behind it, which is what Mr Heath was talking about in terms of this. So it doesn't change the dial for me.
Great. Thank you. One further question from me, and this relates to the further submission from Ms Gazzard, who we'll be hearing from during the hearing on behalf of the Farlap Racecourse trustees. So there was a comment in her submission around her understanding of the legal status of the site as a reserve, being the racecourse, and that in her understanding that could not be changed. And I wanted to run that past you just to get your, I'm not sure you specifically addressed that point in your section 42A. You may have. I might be incorrect there, but just wanted to test that with you.
I think it was... very, very briefly, it talked about how the site was disjointed in terms of ownership. And I think there might have to be an act of parliament or something to uplift, or there's something severe, but I'll come back to you in terms of...
Yes, if you want to come back to me on that, that's fine. Thank you.
Look, I know we're running over time. I just would like us to get through some questions that relate to the submitters that are being heard today so that they have an opportunity to consider the answers to questions before they present. So the next one we'll deal with is Waitui Deer Farm. Yeah.
Okay, so I've just thought, right, well, what's the best way to actually get through the questions? Because I have a few and they're connected to Mr. Kemp, Mr. Collins, and also Ms. Fluger, and then to you, Mr. Bonis. And I thought perhaps I just need to clarify with those experts my understanding of what they're saying first before we come back to look at the planning kind of options. So my first question was to Ms. Fluger, and it was really just kind of confirming your position or the point of difference here, because from what I see, Dr. Abbott's provided a vision of regenerative subdivision that includes native restoration and public amenity, and you seem to endorse it in principle, and I wanted to check, is the main concern here about what planning tools will be put in place to actually secure that outcome?
I think my main concern around it was that it would need a DAP to really assess in detail what the amenity effects would be. In particular because it is an undulating landscape and it is of high visual amenity. It really depends where the building platforms are going to be located, how they're going to be accessed, what sort of earthworks are going to be required, whether that would be appropriate to go from the 10 hectare lot size to the 2 hectare lot size as proposed.
Okay. And you did actually, I just want to confirm that you did also raise a concern about no mechanisms to secure the
that's correct.
Presentation.
Yeah.
Okay.
I mean, the vision outlined in Mr. Abbott's report was, I think it has potential, but it was just too high level to really comment on the adverse effect. I think it has a lot of good vision about potential positive effects that can be achieved through revegetation, but it doesn't provide any information about potential adverse effects from buildings within the landscape.
Okay, thank you. That's really helpful. Then my next question then is to Mr. Kemp. And I wanted to, so the updated evidence and conceptual plan includes proposed on-site wastewater solutions. Mm-hmm. And I wanted to know that given that they plan to use composting toilets and obtain a discharge consent, then does that address the risks that you have talked about with the black water disposal and reliance on council infrastructure?
It does, because it wouldn't require the pumping and removing of waste from those systems, and then the disposal, it's being dealt with on site. So it does, covers that off.
Okay, great, thank you. And then my next question is to Mr. Collins on transport. And that is where the submitter has acknowledged that there's a need for a ITA to support the additional 2 hectare allotments, and he's saying that that can be secured through the subdivision standard 6, and I wanted to know whether then that would actually address your earlier concern that the rezoning could generate a moderate scale traffic effects without a sufficient assessment, because it would be assessed at that point.
If you can just give me a minute to look at subdivision standard 6.
Sure.
Subdivision Standard 6 doesn't give the scope to consider effects beyond the immediate site, in my view, which you would normally, or I would normally expect with a development of this scale, or certainly where you're seeking, either rezoning or a change to intensity that's beyond what is anticipated in the plan. Typically, that's managed through the high trip generator rule, TRAN R10, but in this case, I don't think it would trigger TRAN R10. So I haven't undertaken assessment beyond the immediate site to consider whether there are effects or potential effects there that may require mitigation. So my short answer is no, I don't think subdivision standard 6 is sufficient to, in essence, allow the can to be kicked down the road.
Okay, great, thank you for that. And then I just now have a couple of planning questions. I had a follow-up on from the landscape certainty versus landscape vision question, but that's why I was testing with Ms. Fluger whether or not it was, if she had other wider concerns. It sounds to me that her answer was yes, because she hasn't got enough information to do a detailed assessment. I still think it's warranted to say, to ask if there are actually any planning mechanisms that could enable enforceability.
Yep. Oh, look, well, there's this process, but there's also, I guess, if the panel were minded, and I'm not recommending this, you could suggest that the area be an FTA in terms of what happens to it, mechanisms to consider the matters further, what those matters in particular are. One thing I'd make really clear, though, if the panel were looking at heading that way, is that under FTA P3 in the schedule, Council has to pick up the cost for all the priority areas, and there's no gain to the public from this exercise. I would also, I guess, caution the panel that they would still need to overcome the planning hurdle in SD 012 as to limited rural lifestyle development opportunities are provided where they concentrate and are attached to existing urban areas, achieve a coordinated pattern of development and capable of efficiently connecting to sewer and water, which I think is a big hurdle for this one, given the sort of disparity of where it is. So yes, there's a mechanism. It could be explored further.
Okay, no, that's really helpful. And I do have a question about the composting toilets and discharge consents, and it's a Land and Water Regional Plan question, and I wanted to know how these relate. Like, is there any obstacles in terms of the district plan framework to prevent those types of, systems? Or is it purely just a Land and Water, a regional council issue?
Was a policy issue in terms of, I guess, the panel looking at efficiently servicing with infrastructure. In terms of how the system functions, it really comes down to the Land and Water Rule, which has a 4 hectare minimum in terms of on-site sewer disposal. If you can't achieve that, you're restricted discretionary, and you also have to comply with setbacks to waterways and on-site bores and various other bits and pieces. But I think, there's a policy issue for the panel to consider first. Great.
Thank you. I only have one very last question, and that is on, so that's on the cultural values, and we do have the AECL report, but then we get more evidence, but between that, and we don't have Ms. Hall here to be able to question her. So I wanted to kind of frame it into a bit of a planning question to say, as further evidence comes in, and we're looking at this whole kind of proposal, which is retirement from farming and ecological restoration and improvements to the water systems, then how does that actually respond to like an IMP or the IMP or mana whenua positions, and how do we incorporate their updated view in the process?
Simply without setting up another public process, you wouldn't, would be my view. And again, and it was in my summary, there's been 9 months where we put out a preliminary report saying these are the things, if you want us to move forward, we're happy to do so, provide us with this detail, and it hasn't happened.
And just a couple of questions from the panel in relation to the submission from Tristram Johnson. So it's a Temuka submission.
Just humour me, Mr. Bonas, with this question, because I'm sort of throwing it at you. Given your own report suggests sufficient zone capacity in Temuka to 2053, why is further zoning considered necessary at this time?
Quite simply, I've identified that the NPSUD is an issue, but I've set it 12.3.8, given it's effectively infill, and we only get 4 to 5 residential allotments. It doesn't move the dial, and therefore I don't think that there's in conflict with NPSUD.
And would your recommendation remain the same if the site contained 500 square metres of Class 2 land instead of 250 square metres?
Probably not. From going out to the site and having a look at it, seeing how it's used, seeing what's around it, I'd have to go through the aspects of 3.6 again, but if there's any tension, it's very, very minor. The area's constrained. Its entire purpose and everything around it is for residential use and character. It's not being put in productive potential.
Now moving to Mr. Blackler submitted 231, and this is a question for Mr. Heath. Given your economic report does not distinguish the 75 plus age demographic or account for specific aged care demand, how can we be confident it reflects actual housing needs in Pleasant Point?
Excuse me, the demand based on the zone capacity is just over 250, and the capacity is 300 over the long-term high-growth scenario. So that's with, that's growth with a wind behind you and a 5% chance of being realised. So my other point in relation to that was my understanding was that site had some flood issues, which are non-economic, but in terms of the exact scale or quantum of the site size for delivering a retirement village, that would seem to be, it would tick that box in terms of site size requirement. But I think there are other non-economic issues which limit its appropriateness for inclusion. But from an economic capacity assessment, there is sufficient zone land to accommodate future growth, under the high growth scenario even.
This is probably back to you, Mr. Bonas. The submitter's engineer confirms the site can be serviced with developer funding and cost sharing for broader benefits. Why is this insufficient under Objective 6 of the growth chapter?
The engineer's words were, it is technically feasible to service it. The provisions in the RPS and the proposed plan talk about efficiently integrating. They are two different things.
Mr. Collins satisfied my questions with regards to the transport. So thank you.
Look, we're going to wrap up the questions now. To the extent that the panel may have other questions, we will record those in writing and ask for a response, but they cover off the main issues that the panel. So thank you very much for your perseverance on that, and I'm apologetic to the submitters that are waiting in the wings. They're going to appear after the luncheon break, but we do need a break, so we're going to take half an hour and then we'll resume for submissions. Is Mr Bonas going to be about for the remainder of the hearing? So if something arises when a submitter's presenting, we may ask you to clarify that or get your response at that time.
Sure.
Okay. Thank you. We'll resume hearing G on the proposed Timaru District Plan. And our first submitter is Waitui Deer Farm, Melissa Mullen, and Mick Abbott is joining us by video link.
Good afternoon, Hearings Commissioner and panel. So my name is Melissa McMullen. I'm the planning consultant for Waitui Deer Farm. Sorry about that. We have Mick Abbott as the landscape architect available online, and I'm sorry there was an omission from the hearing schedule. This is Mark Balderston. He's the property owner of Waitui Deer Farm. So Mick and Mark are both available to answer any questions, and I have a few quick things I want to cover off, and then I'm more than happy to open it up to questions or to take questions as they come up. So there are some really key features of this site that I just want to reiterate for the benefit of the panel. There's no considerations required for the National Policy Statement for highly productive land, which I know is quite an advantage compared to other areas of growth that have been identified throughout the Timaru district. And as I outlined in the evidence brief, there are solutions available for all the matters that have been identified, particularly with water and wastewater provision. And you'll also see through my evidence that as an alternative form of relief, we've suggested a deferred zoning if that is considered to be the most, a more appropriate pathway forward for this site. I just wanted to quickly also just cover off some points that have been raised this morning, and also some omissions that, and just some clarifications I need to make from my evidence brief that was supplied to the panel. So there is one, I have stated in my evidence that all the SNAs are located within the already existing 2 hectare specific control area. There is part of one at the in the very northern centre, which does straddle the boundary between the 10 hectare and 2 hectare boundary, zone boundary there. I just wanted to make sure that I have captured that, and I apologise for that oversight. You would have been provided by Linda from me a set of potential provisions, so planning mechanisms that may be the best way to address some of the concerns that have been raised by the Section 42A author. I apologise that I forgot to, or I omitted from my evidence to refer to an ecological plan standard, but you'll see that that has been included in that suite that's been provided to you today. Kevin Kemp earlier today, when he was discussing this submission, he referred to a potential yield of 57 allotments. That isn't correct. We're looking at a 30 to 35 allotments yield in this situation, and that does include the existing 2 hectare specific control area yield as well. So I just wanted to rectify that, that comment from Kevin earlier. And I think there might be some questions that might cover off some of my other comments, so I'll leave them for the moment and we'll just refer back to them if required. So I just wanted to cover off and go into a bit more detail the provisions that have been provided to you this morning. Sorry, I'm just coming out the end of a cold and my throat hasn't quite got there yet, so it's quite painful, I do apologise. So what this potential suite would see would be a additional area for rural lifestyle zone included under the allotment size and dimension standard. And so when we refer to the Waitui Deer Farm specific control area, that is only the extension, that only refers to the extension that is being sought in this instance. I did note, and sorry, this was another matter that does require some clarification from my evidence, it would be more appropriate to have something added into subdivision standard 7 for roads, cycleways and pedestrian access, and that would be that prior to any subdivision application being made, a full integrated traffic assessment would be required to be submitted to Timaru District Council. Now, I note that this would actually be over and above the requirements that exist within the proposed district plan as it exists at the moment, but that is, so at the moment in the proposed district plan, a full ITA would be required when 90 residential units or lots are proposed. In this instance, I am suggesting a full integrated traffic assessment would be appropriate just due to the nature of the site, the nature of Waitui Drive, and I think that's been reflected in the comments that have come through from the Section 42A author and the transport comment from Abley and Mr. Collins. And sorry, just to circle back, because I have skipped over one. Today there has been a lot of discussion about the water availability and the water modelling, and so I just wanted to reiterate that in my view that is already required by the water supply standard in the subdivision chapter. But if it would help the panel, then I could offer specific wording in relation to the specific control area after the hearing. I'm more than happy to provide that if required. And finally, that brings us to the ecological restoration plan, potential subdivision standard that I have suggested here. I appreciate it would need to come under its own standard category, for want of a better way of terming that. So this would require a really detailed ecological restoration plan to be submitted with the subdivision application, so it would be understood how the planting would work on the site, and this would also demonstrate, alongside this you'd have to demonstrate, the developer would need to demonstrate the methods that would be used to inform future landowners of ongoing maintenance requirements, and so that is what I envisage with suggesting something like this, is like a covenant or one of those mechanisms that we have available within the RMA framework. And then finally, any landscaping or planting shall consist of Indigenous plants native to the Talbot Forest area, which reflects the work put in by Dr. Abbott and the species that he's identified within the landscaping plan as being the most appropriate for the area and how they could feed into the wider story of ecological restoration within South Canterbury, within that area. At this stage, I think I will hold it there and open up for questions. And yeah, thank you. Yes. Yes. No.
Mark. Probably not. If you've got any questions for me,
Great, thank you, and thank you for this. I hadn't read it beforehand, and I would have put those questions to Mr. Collins on that particular this new provision rather than what I did put to him. So apologies for missing the opportunity to do that. But I do understand it now a bit better. And this, actually reading this and providing this, has knocked off a number of questions for me, so that's really helpful. I do have a few more. The first one I had was just a point of clarification. In paragraph 11 of your evidence, you refer to council considering options for extending zoning, and I just wanted to confirm with that particular statement that this is the process. This is the process for rezoning. There's no other process going on, or is there any consents in train, or is the only application currently with council this rezoning request for this parcel of land?
To achieve 2 hectares in the way that we are proposing, or are you referring to any consenting history for the site?
Or connected to this proposal?
So there is I've left it over there. There has been a subdivision consent that has just been, it doesn't have 2 to 3. It's going through the title process at the moment. And so that creates a 26 hectare allotment for that, which covers the specific control area for 2 hectares. And then it creates, so that just literally follows the boundaries of the zone, of that zone boundary as it stands. And then there is, that then creates 4 other 10 hectare allotments and a 48 hectare allotment, residual, which is in the northern part of the site. I can provide that plan to you. It's just over there at the moment. Sorry. Yeah.
Okay.
But that is so that's been a subdivision process that's been undertaken, which was driven post Plan Change 17 to give effect to what was obtained through that process. There's nothing else in train at the moment. But apart from this process with council. Yeah.
That's helpful. And we've dealt with landscape certainty because you've put some provisions together. So I did want to check in with on the on-site black water systems. So when it comes to wastewater, like how will this be implemented and maintained and remain effective given the scale of development?
Yes, I appreciate there would be a considerable amount of different systems potentially going in as a result of this potential rezone. So we have had a high-level I have had a high-level conversation with Environment Canterbury about any potential issues that may arise at this stage, and they haven't. They've obviously identified things like cumulative effects would need to be taken into account and all that sort of thing, and I appreciate that is a concern. And at the moment, that they haven't identified anything that would be a massive red flag which would stop it from even passing go, which I think is really important because that can be something that can catch developments like this when you do have a considerable number of potential allotments coming up. With regard to the way that the district plan is actually structured, the district plan does currently allow for the wastewater disposal solution, which either has a discharge consent from regional council or is approved by the regional plan. Mm-hmm. So I appreciate there will possibly be a fair bit of mix and match depending on that cumulative effects, because obviously the environment will reach a point where it will hit a limit. And so long term it is quite difficult to know how that would play out, but it's my view that there is enough within what's available on the market out there between continually upgraded wastewater discharge systems and between the permitted activity pathways, that it shouldn't create too much of a detrimental impact on the surrounding environment.
Okay, thank you. My next question is about public access. So I think that you in the proposal, it talks a bit about having public access walking tracks and recreational connections. And I wanted to check in about, well, who will be responsible for maintaining them and what mechanisms, will be in place to secure public access and upkeep? Because I don't think you've referred to it specifically here.
No, I haven't referred to it. Sorry. So Public access is provided in the Geraldine Downs area. That came through on Plan Change 17. So there is an expectation that there will be walking and cycling tracks in the area. With this proposal in mind, that there is potential opportunities that do exist for enhancing and providing those potentially in a much potentially further to what is currently anticipated by the district plan, because you'll see on the E plan it does have the hashed line around the outside of the property where it is indicating those walking and cycling tracks from Plan Change 17. So because those ones in particular came in the Plan Change 17 process, it is my understanding that that is a council related, like that's a council process that they've signed up for and are aware of. Anything additional to that may come about through the development of the site, that would be something that would need to be, again, it's potentially a discussion with council, but there is also an understanding that there are limits to council's ability to support things like this, and therefore it may be more of a private thing just for the landowners within the site to enjoy something like that, but purely through like an easement scenario, where it's not necessarily public access, but it is access for all those parties that sign up to the subdivision.
Okay, thank you. So one of the questions that, so I do have a question about cultural values, because AECL has indicated that they have a concern with it not being connected to services. And so I wanted to know, has there been any engagement with Arawhenua or AECL in the development, in the proposal and in the landscape plan, and have they provided comments on like retirement from farming practices, and whether or not this particular landscape plan really does enhance and protect and have the ecological outcomes?
Yes, so we entered into a discussion throughout the, thinking of time, it was throughout that time when the additional Section 42A, I don't know how to phrase that, like Matt put out his request for further information. Mm-hmm. At that time, we entered into discussions with Araki Environmental Consultancy. They did come back with that feedback that you've referred to, that they don't like the proposal because of the potential effect on the waterway. At that time, we had been doing work with Dr. Abbott, and we had come up with a conceptual plan, which was the ecological restoration plan, which you've seen. So following on that discussion, I sent that through to Kylie Hall, and I said, like, this is where we would, so this is, yeah, this is how this is being pitched as being a real opportunity for ecological restoration and retiring this farmland. Does that change your view of it at all? And we got some really positive feedback via email, which I'm happy to pass on to the panel if that would be helpful. And essentially saying, if this could be achieved, this would be a real benefit to the local sort of flora and fauna and the health of the waterway, and addressing those concerns that they had identified. Yeah,
I think it would be helpful, because for us we need to take into account the impact on cultural values, whether positive or negative. So it would, from my perspective, be really helpful to understand that and see that. My only other question was for Dr. Abbott, and the first question I have is about subdivision layout and visual effects, and my understanding of what you've put forward is that you're placing building platforms on the more elevated sites and then concentrating planting on the lower areas. And I wanted to know, well, first, have I understood that right? And if I have, then does that model impact on visibility of those houses from the public viewpoints? So throughout the Geraldine Township, how would having that building platform impact on visual effects?
First of all, yes, the to do with the planting in the lower elevations, one of the key reasons for that is they're much easier to establish where there's stronger moisture. Certainly, you know, the environment's drying out more regularly, and so that's the reason for focusing the planting beginning there. But equally, there's planting throughout each of the properties that would provide screening not only between different dwellings, but screening beyond the property. And so that capacity, I think, can readily be achieved so that it doesn't create sort of high visibility issues.
And have I got it right that you've said you're proposing 80% native planting on each lifestyle lot? So does that mean there's 20% non-native and then about 80% native?
It's not 20%. Well, if you look at sort of grassed areas and what have you, you could view them as non-native. But the sort of to create that sort of mosaic of native species threading through the development as a whole. So it works to together combine into quite a substantive sort of ecological zone, while still allowing individual owners to have a significant proportion of that land, you know, for their own amenity value as well. You know, the conceptual plan we did looked at that ratio. There's different ratios that could be used, but the capacity for the Geraldine Downs area to support native species rather than sort of livestock farming, I think that's sort of one of the transitions that this sort of can open up.
Right, okay, thank you. My final question, it might come back to planning, but it's understanding, like, how confident can this vision be achieved without any binding plan provisions or any detailed design controls at this stage?
I'd hand that one back to Melissa in terms of what might be those suitable mechanisms. But certainly, there's certainly a desire out there to achieve these sort of outcomes. You know, as we see the challenges and the potential of bringing in native species more into these sort of types of proposals. But I'll hand that back to Melissa for what those mechanisms could possibly be.
I think the mechanisms would be through subdivision standards in the district plan. Also potentially, I know this process doesn't, the difficulty with this process is you can't register things on the record of title because it's not like a subdivision process in that way. So that's why there's the reference to methods in that subdivision standard that I've suggested, because then that would require there to be some level of additional instrument entered into, preferably on a record of title, that would then make it clear to the future landowner that they do have these requirements is not the right word, but responsibilities. I can't quite find the right word for it at the moment, but they do have this need to provide for this level of restoration plan in the future.
Right. Okay. So would that standard then specifically tie to a ecological restoration plan at a point in time, and it is this one, and this must be achieved?
So it's suggesting that at the time of a subdivision application, that so the document that's being created by Dr. Abbott is what I would consider a guidance document. And so people could then pick that up and decide for their own, decide as part of the subdivision plan what parts of that they would like to utilise, and then that's when they formalise the restoration plan that is referenced in this subdivision standard. And then as part of that, it then goes through the planning process, through the resource consent process, and gets the approval from council. And then that gets registered, in the way that I envisage it, then that gets registered onto the record of title and goes from there.
All right, well, I might have some of my planning colleagues take that a bit further. But other than that, they were all of the questions that I had. Thank you.
Ross, here.
Thank you. If I could take you to paragraph 4.3 of your evidence.
Yes.
So I'm wanting to understand where your view is now. I think when you opened your presentation, you mentioned a correction. So in terms of paragraph 4.3, you were questioning why there needed to be a specific mechanism in terms of the SNAs. So can you just talk me through where your view sits now?
My view hasn't changed on that. So literally the piece that pops into that 10 hectare is literally a tree, 2 trees maybe.
In a gully.
Yeah. And so when you look at how when I look at how the role of the SNAs plays into this proposal for rezone, they have been identified on that site for a considerable amount of time now. And whilst I appreciate that there is, in a planning sense, yes, we do need to be protecting those SNAs and all that sort of thing. But because the amount of SNA that is outside is so small, and there's still, the majority of that SNA portion is actually still within that 2 hectare zone, anything that does happen within that SNA in particular will be linked to the entirety of the group that's been captured, if you know what I mean? Yeah.
Thank you. And so in arriving at that view, whose evidence have you relied upon in terms of ecological biodiversity, flora, fauna values and within those SNAs?
So through the package that Dr. Abbott created and submitted as part of the response to Matt Bonis's questions, the SNAs are identified within that.
Can I just interrupt you there? I understand Mr. Abbott is a landscape architect?
Yeah.
Yes, so I'm asking you specifically in terms of SNAs?
Yeah.
So under the proposed plan provisions, there are values that go beyond landscape, is that correct, to your knowledge?
Yes, there will be, yeah.
So in terms of the conclusions that you're reaching here, I'm not seeing any underpinning evidence that you are relying on to arrive at your conclusion.
Right, okay. So my approach with this paragraph in particular was there was specific reference that planning mechanisms would be required to see how the SNAs would be developed or protected and continue to be, what's the word I'm after? Like continue to be protected and I can't quite find the right word for it at the moment, but and so I'm purely referring to mechanisms in that, in my evidence there, and so in my view, the reference to the fact that there had been no comment or there had been nothing offered about restoring those SNAs wasn't appropriate when you viewed what the actual rezone request was for or what the growth request was about. The growth request was about an extension to an area away from the SNAs, and so I considered the SNA areas to be yes, that they are on site, yes, they exist, but actually that they won't be, as of now, Mark could develop the site, could develop where all those SNAs are with 2 hectare allotments. And so I couldn't see how there would need to be a planning mechanism in place to protect or develop those at this point in time.
Right, okay.
Could I just add, just with the SNAs in the document that I prepared was there's 6 identified, and pages 30 to 35 look at each one in detail. There's about 20 native trees still existing across those 6 SNAs. Some of them are just bare grassland with no native species. I think in their current form, there's very little that's there, and any restoration activity will be bringing something back that certainly isn't there in the current form.
Okay, that's all my questions.
So I just want to make sure I'm clearly understanding. So I think the Section 42A report and the current recommendation of Mr. Bonas is that the submission not be accepted? Is that
It's my
that's your
understanding, yes, yep.
Okay. And what I'm looking for is, where's your planning evaluation that addresses the district plan, not the detail, because I understand all of that, but the planning evaluation that underpins your opinions that differ from Mr. Bonas's? Because have I missed it, or is it, I just don't see an evaluation of the district plan provisions, the regional policy statement, and then linked to that, am I also missing your Section 32 evaluation?
My response to that would be, throughout the submission and the further information required by Mr. Bonas, there were references in that to needing to speak to the regional policy statement and to make those assessments of the higher order policy documents. So I believe I've already answered them within those documents. When it comes to a Section 32 evaluation, yes, it is not there at the moment and in a formalised sense. Yeah.
So can I just ask, given you know who the onus is on for a rezoning proposal, why not?
Sorry. I believe what I was primarily focusing on were the issues that really stood out to me at the time as needing to be addressed. And so, yes,
So as a planner looking for a rezoning though, is Section 32 not one of those key fundamental things the planner has to look at?
Yes, it is, yeah.
Right. So then I want to come back to your evaluation as well.
Yeah.
Because I think there's a difference between information that's been provided in part of a submitter package and evidence from a planner. And I just want to check, who wrote what in the submitter package? Did you write it all? So is that what I can rely on for your opinion of those provisions? Or was some written? So it's just not clear. I just want to be clear who wrote what, if that's the evaluation being relied upon.
Yeah, so I wrote I've written every document that's come into the panel. It has been reviewed by Andrew Ravage, who was the director at Millwood Finlay Lob. But anything within that, any changes that he may have suggested, they've come back to me, and it's certainly been a discussion of what is appropriate.
Awesome. So I'm going to take you to a specific provision now, and maybe you can just help me, because it might be that I've just lost it at evaluation.
Yeah.
And it's really around the regional policy statement provisions and the parts that Mr. Bonas has identified, and I've just got to find it now, because I'm switching between yours and his evidence. And it really relates to... can't find it.
Is it within his 42A?
Yeah, it's actually, I've probably got the note of it in yours. Sorry, my computer's just had a go slow. I had it and it's scarpered on me. It's the one, 5 point. Excellent, sorry. That's 5.3.1. Yeah. So that's no, it's this one. It is, sorry, I'm just pulling this. So it's his paragraph 13 to 13.
Yeah.
And because his view and his evaluation is that it doesn't meet that those provisions in terms of the Canterbury Regional Policy Statement. And I'm just wondering if you can point me to the part in your evaluation where you actually specifically evaluate that provision.
Yes. So I have picked up on that comment and discussed it further in my evidence at
You said that you disagree with Mr. Bonas,
yes,
but it wasn't clear to me what your how you'd actually then evaluated the specific parts of that provision.
yes. Now I'm going to struggle to find where it is. Oh, yes, so, yes, 4.9 in my evidence. Yes, sorry, I appreciate I've actually not directly referenced the Canterbury Regional Policy Statement within that paragraph, but that is my response to the comment that has been raised at Mr. Bonas's 13.2.13, and that is my assessment of that provision within the Regional Policy Statement.
Right, okay. Because it's just when I read it, it did appear to be more like just rebuttal or disagreement as opposed to providing your own evaluation to reach a different conclusion.
Yeah.
And that's probably what I was looking for, that if you're wanting a different outcome, where's the evaluation of those the district plan and those higher order documents that, as a panel, we can rely on to reach your conclusion. So that's what I was looking for. And so there's not a comprehensive evaluation of the relevant provisions applying to...
Within the response to Mr. Bonas's request that came out earlier this year, the Regional Policy Statement is discussed within that.
That seems quite generic, though. It was a couple of paragraphs about the Regional Policy Statement, not provision by provision.
Okay.
So have you done a provision by provision evaluation? Because that was the part I was wondering whether I'd missed. Was it an appendix or...?
No, but I can provide that to the panel if they would like, though.
Look, I think you need to just go on record and confirm that the material that you provided as part of the response to Mr. Bonas is your evidence. That would be a good starting point, and I'm happy to provide you the opportunity to go away and reflect on that material and frame your response to the questions in the context of Section 32AA, given it is an amending proposal, and Mr. Bonas did put you on notice in his report that he didn't have sufficient detail for him to even undertake that evaluation. So we're troubled to know how we are going to undertake that evaluation if that level of information is not before us. But unless there are any other panel questions on this proposal, you are welcome to provide that to us following the hearing. We'll set that out in a minute, as we usually do post-hearing, and you'll be given a time frame within which to do that.
Okay.
So thank you. Thank you for your submission today.
Thank you.
Mr. Shirtcliffe, welcome. Thank you so much for your patience with us. Please, when you speak, you push.
Okay, well, thank you for providing me belated opportunities to appear. I hope you're aware that due to circumstances rather beyond my control, since I fell off a roof several months ago, it's been the last thing on my mind until about the last 2 weeks when I've been able to actually sit in an office chair and let alone work at an office desk. I thought I'd begin by just giving a little of my background so you understand I'm just not coming out of a position of little knowledge about things. I've got an undergraduate degree, Bachelor of Arts, majoring in economics and economic history, and I have a Master of Business Studies. For the last 20 years, I've operated my own consultancy business. I've consulted to local government, central government, and a lot of major OEMs, multinationals, as well as domestics. And in particular, in fact, I think I'm probably well qualified to be able to provide you, should you need it, because I did take issue with Mr. Heath's assertion that there was no between rural and urban development, and that I conceptualised and took through two major regional economic development initiatives. One which was about funding activity to create extra value for the wool industry, and the other was for the food bowl, which I did for Canterbury Development Corporation. Subsequently went back into central government, emerged in Auckland and Lincoln, and then finally got to Christchurch. So I've been pretty active in a number of these areas that make the rural-urban link. Moving on to my presentation. I've been frustrated, I guess, by the level of reliance on what I've considered to be faulty analysis underpinning some of the assumptions around the district planning process. And in particular, there's a real problem in terms of the population growth assessment. And if we work through does that work? Where do I point it? Oh, here we go. No matter what sort of business you're in, projections and predictions are notoriously difficult, and I've put up there a couple of quotes that I've pulled out of the Population Studies Centre in Waikato University. And in particular, they have found that projecting population at small area level is difficult. And in some of the work that's been done via Statistics New Zealand, they've analysed that work, and basically they've come to the conclusion that fewer than 1/3 of the territorial authorities are projected to experience near certain decline. So there's some really interesting work, if you take the trouble to dig into it, as to why we ought not to blindly rely on Statistics New Zealand projections, because, as I'll show you shortly, they've been notoriously inaccurate. On this slide, if you look at the black outline area, that is the historical area unit or old town boundary of Geraldine. Until 2 censuses ago, Geraldine's growth was measured totally within that boundary. If you now drive around Geraldine, you'll see that most of the development has happened in the peri-urban area, immediately attached to it and contiguous with it. And when I picked up the problem, because we had also a business, my wife runs a retail business in Geraldine, and our anecdotal evidence was that there was a lot of growth, there were people coming to the town and so on, and it didn't marry up with what we were being told by Timaru District Council in particular, relying on Statistics New Zealand population projections, that there was no growth occurring in Geraldine and everything was hunky-dory. And frankly, nothing could be further from the truth. Now, the council here have provided me with the latest 2023 population by mesh block, which is what I've based some of my analysis on. And I'll just point out that when I started a week ago to get stuck into this, that to get the mesh block information is very nearly impossible. Statistics New Zealand wanted to charge $650 just to provide stuff that you used to be able to get free off their website. So it's been a bit of a challenge getting the information together. So, few home truths. As I've said, the expert reports have been consistently and seriously inaccurate, and not by just a little. I've dealt with the distortion that's presented by reliance on the old town boundaries as the measurement unit for statistics. And in particular, when we start looking at the property economics report, they've pointed out that Timaru District has been growing along the medium growth projection path, which is essentially 2.7% between 2018 and 2023. Fine. During the same period, Geraldine's population, when you start to look down at the data that lies below this, it grew in excess of 11%. The bulk of the growth in Timaru District Council is coming from areas other than Timaru City itself, in terms of percentage growth. So since the 2013 census, 43%. That's not inconsiderable growth in Geraldine. None of that more granular analysis has been undertaken by property economics. And I consider that to be a particularly serious oversight when you are sitting here and considering what you need to provide in the way of future land use. Because, and let's face it, what you're going to take is a best guess based on the best information to estimate the land use. And you've got to also remember that Geraldine growing at that rate has been, despite being hampered by lack of suitable land and recessionary economic conditions over the last few years. It's been quite difficult. So the other issue that I think was touched on is that why hasn't there been more infill in a town like Geraldine? Well, it's pretty simple. You've actually got a restricted area, land supply has been restricted, therefore housing that already exists within the Geraldine settlement has been essentially overvalued. And I'm sure if you look at the statistics, you'll find that Geraldine property sells for a significant margin over property in Pleasant Point and Temuka, for example. So the reason for that is that if you've got to pay $450,000, which is about the going rate at the moment, for something that's essentially a tip site and is only worthy of tipping over, then you have a real problem in getting a payback on buying that land, subdividing or rebuilding with new housing stock. So if you're looking for a reason why there is no good housing stock available in Geraldine, it comes down to the fact that Geraldine has not been allowed to grow and create fit-for-purpose housing, and that is behind a lot of the difficulty that you're going to hear about during these presentations for the Geraldine vets that can't accommodate their staff, for the Barkers bringing in staff for a multinational operation. There's just not that much suitable housing for them, and the primary reason goes back to the fact that essentially the Timaru Council has planned for no growth, and guess what they got? No growth, essentially, within the town boundary itself. So beware expert population projections. This comes from analysis done in the Population Studies Centre by Cameron and Poot. And they looked at the medium growth projection here for Timaru. And without going into all the detail, you can see flashing up in red there how far they were out with their projections in terms of medium growth. Unfortunately, the same analysis wasn't available for the high growth projection, but in this paper from which I extracted this information, they did the analysis for a number of other territorial authorities, and the high growth projections and difference between the error between projected and actual was wildly different. Like it makes these ones look accurate. It's extraordinary, and if you want that information, I can give it to you. I have the paper with me if you do want to drill into it, but it's something that's immediately apparent and jumps out from the research. And again, I just can't highlight enough the fact that I consider that the population analysis that's been done over the last few years is just... If I was paying for the report, I wouldn't. To be blunt. So further, a couple of reasonably germane conclusions that come out of that research. And generally, as I put on the slide here, generally the identified and modelled uncertainty makes the traditional mid-range scenario of subnational population projections of limited use for policy analysis or planning beyond the relatively short projection horizon. So more than 1 or 2 years out, they become inaccurate. They also found that population projections become more uncertain the smaller the geographical area for which populations are being projected. They systematically underproject areas that are growing more quickly, and Geraldine is a classic example of that. And they use the cohort component model to project area units, but the lack of appropriate data at that level makes their projections less plausible beyond a very short future time frame. And that comes directly from one of the authors of that report, Cameron, when I've spoken to him about the issues. So the implications are reasonably clear, I think. Certainly over the medium term, Geraldine's grown at a pretty considerable rate. And all the signs are that it is likely to continue to grow at that rate. There are, for example, I think something like 30 sections that have recently been bought in I think the 2 remaining subdivisions that were available within the Geraldine area, which were on, to be frank, slightly less attractive ground than is available elsewhere. And there are a number of others that are starting to move now, as I understand it. So the question essentially is the assumptions underpinning growth that are used in the PE report. So they lead to constraints on suitably zoned land over the life of the PDP. How are we going to accommodate the sorts of growth that Geraldine's clearly exhibiting? You have to remember Geraldine is in a fortunate location. It's based on the tourist route. It has essentially a microclimate. People come to the town because of its nature. It gets a lot of day visitors from Ashburton, Timaru and further afield. It behaves quite differently to Timaru or to Temuka or to Pleasant Point. So in terms of common sense, it seems to me that the PDP is unlikely to support the likely requirement for Geraldine in the future. Now, this is a bit of a brickbat probably, but I think it's well due, and that is that the operative plan in place right now is just having its 10th birthday of its expiry. If you're going to have a similar lengthy process at the conclusion of this PDP, if it's hopefully made operative in 2026, I suggest it would be prudent for you to be planning for land supply out to 2046 as a minimum. And startlingly, if you assume, say, a 1.8% annual growth rate in Geraldine, and I think there's good reason to suspect it's more than that, especially given an improved land availability and better housing stock, that by 2036 we could be at 4,130. That's 19% growth over 10 years. And 4,940 by 2046, which is 43% growth. Which, if you think back, that's exactly what Geraldine did between 2013 and 20, whatever it was, 20, I forget the year, but it was over a 10-year period. So, fairly simplistically, if you take for every 2 people you have a house, you're going to need 365 houses and 770 in 2046. And that's not looking at the RLZ growth. So the proposed GRZ lands will be very nearly full by 2036 and totally inadequate by 2046 in my submission. So my message, I guess, for the panel, that there's a deal of caution required here. And I can't be clearer than that, and just saying that if you would be remiss to take the overall Timaru growth rate as a projection and impose that on the Geraldine settlement. They are 2 totally different animals. Now, to the second part of my submission, which is the piece of land that I'm involved with. There it is there. It's bounded. Unfortunately, I don't think this has this got a pointer? Oops, no. But it's essentially that keyhole block up there. Okay. At the northern end, we've got 6 existing wastewater ECAN consents. We had some years ago done a subdivision plan for that area where we were down to about a bit under 1 hectare lots. And that, in terms of wastewater, was approved. And that's one reason why I'm thinking that your minimum lot size is a problem. Coming down to the, what's that, northwestern corner, there's existing town sewer and water infrastructure almost at the gate. Due south of there are the wastewater ponds. Just where the circle is, the main sewer runs out to the wastewater pond. I cannot, for the life of me, understand how that opportunity was ignored in terms of providing for more intensive use. So we support the RLZ. We think it's a lost opportunity for Geraldine. And if you look at the location, it presents quite a sound opportunity to create something sensitive there that gives a gradual transition between rural and urban. It's well located. It's immediately adjacent to Geraldine's roading and water infrastructure. There are 3 direct feasible access points to the Geraldine's existing road and water infrastructure. Arari Station Road, Tancred Street and Campbell Street both touch on that piece of land. It's within easy walking distance of amenities, 10 minutes to town, 3 minutes to the high school. We've already, with the existing subdivision that we have done there, we've provided a buffer against reverse sensitivity issues with neighbouring agricultural activity. We've dealt with that issue. Now, it sounds as though Mr. Bonus is going to disagree with me here, but my recollection of the visit is quite different from his. And that is that I was left in no doubt at all that there was no opportunity to review this as anything other than an RLZ opportunity. And given my previous encounters, shall we say, with people that have written a Section 42A report and dealt with various of the planning decisions, once you get to the stage where it looks as though you're on a loser, there's absolutely no prospect of getting them to change their mind. So this submission is essentially a plea for common sense and a logical approach to the PDP. And I would suggest that the commissioners should take the opportunity to go out and actually see for themselves the land and see whether what I'm saying is reasonable or otherwise. Because I and a number of other people have come to quite a different conclusion about what the best use of that land is. So, considerations. Geraldine's growing fast in Timaru District as a whole. Geraldine is already at the 2048 projection made in 2018. Population projections I've dealt with are just inaccurate over that period of time. And my submission is that the RLZ zoning that's proposed for 584 Arari Station Road appears to be an inefficient use of a scarce resource. And in particular, of course, the RMA at Section 7B does require resource to be used efficiently. And note the strategic direction of the GMS. And it's about, obviously it's about providing the correct amount of housing, and it's got to be sufficient to meet demand and household choices arises. And as I think I've pointed out, there are serious reasons why you should reconsider whether the information that you have received as to the adequacy is actually correct. And I'd absolutely welcome the opportunity to have the discussion with whoever it is that gets the job of having a look at it again, because I think they need direction. So I've come to a few conclusions there. You've got them before you. And it's probably pretty clear from the presentation I've given to you as to what I think they should be. And that's it, really. So I'd be happy to take any questions that you may have.
Thank you, Mr. Shirtcliffe, for quite a compelling presentation, and you've certainly hit the message home about the reliance on the expert data. There was one point in the presentation when, because you had a level of detail that you took us through and was really helpful. There was one point that I wasn't really quite sure about, and that was your comment at the very beginning around like challenging the evidence from a rural and urban link, and that wasn't quite in the presentation. So
no, but it only occurred to me when I heard Mr. Heath, was it, that was talking earlier, and he said there was absolutely no link, and well, I've got to tell you that that's just wrong.
Then my second question is, you've already gone through the infrastructure and the servicing, and I was going to ask you if you've had any conversations about why the infrastructure was considered not feasible connecting to this site.
I have absolutely no idea how they came to that conclusion.
Right, okay.
No one that I have spoken to has been able to tell me what's inadequate about it. There may be a slightly smaller sewer right at the end of Arari Station Road before it gets to the main interceptor. I don't know. It could be something of that nature, but given that we're probably at that corner 20 metres from the main line, it's not insurmountable.
And then there were also some cultural concerns that were raised, cultural values around, so AECL did not oppose in principle, but talked about services being connected to fully reticulated infrastructure. And it seems to me that your presentation is that you think that it should be as well, and that it's feasible, and that would overcome the cultural concerns or the cultural values that have been raised. And I wanted to know if you've engaged directly at all with mana whenua?
No, I have not.
Okay, thank you. And then I also just wanted to just get a wider understanding of what the vision is, like what it might look like for this particular site. So moving into a general residential area, like what number of housing would that actually, or what number of sites would that actually create? And then do you have any vision for like landscape or housing type or layout design?
Some years ago, Millwood Finlay Lobb did a couple of schemes for me. And at the left-hand half, we had, I think, 12 reasonable sized residential style lots going out to, at the right-hand, at the far end there, to something more like quarter of a hectare, that sort of thing. So there was sufficient room to get, without too much difficulty, 20-ish sites. If we went more intensive, we could get a lot more, of course, if you're going to make it completely residential. But to be honest, I'm not sure that that's a particularly good transition into the rural and a less intensive form of development would probably be sensible to achieve that transition into countryside.
Okay, thank you. And we have been out on various site visits over the course of the hearing, but we will more specifically visit over this week the particular sites and have a closer look. So thank you.
Can I just check in with you? Can you you mentioned that you had 6 wastewater consents associated with the
northern end
portion,
yeah.
And a subdivision scheme for lots of less than 1 hectare?
Yes.
When did you go through that process?
That would be about 8 years ago.
And you haven't actioned those consents?
No, but they're current for another 4.5, because we had to keep getting it extended because Timaru Council dragged its tail, frankly, over the planning process.
Right. And do you think there's demand for those sections?
Absolutely.
I'm just curious as to why you haven't gone on and given effect to those.
Cost.
Cost.
And I had one rather unpleasant experience with the council over the ones that we did manage to allocate. We got to the door of the Environment Court and...
Okay, well, we don't need to go down that path in this context, but that's helpful to understand that. And just in Mr. Heath's presentation, he was confident on his projections based on a high growth scenario with a margin, which I think is 15% they've applied, as ensuring that there was sufficient land available, even in Geraldine, for future growth scenarios. Do you dispute that conclusion?
Absolutely.
In terms of land availability?
He's wrong. I can't put it more plainly than that.
And have you considered, in reaching that view, the availability of land within the existing residential areas and the potential for larger lots to be further subdivided or enable further housing development?
If you look at the reasons that people move to Geraldine, it is not to have a house where they look at their neighbour's toilet window. There's been a number of infill projects undertaken, in particular in the Raukapuka area, which is just slightly to the northwest of that view. And they've destroyed the amenity in the area. A lot of people go in there. It suits some people, but it's not for everybody by any means. People move to Geraldine because they're getting away from the rat race by and large. They're looking for something with a bit of space around with them. 2 hectares is way too much for most people. 1/4 of an acre is way too much for most people. 1/8 of an acre, yeah. I think probably 1/8 of an acre in the old parlance is probably something of a happy medium around what people might expect in the way of a residential section within Geraldine. But 400 square metres in a house, it's not an environment that everybody would be happy in, and certainly that's the comment that I've had. And in terms of demand, I've had quite a number of people come to me and ask, when are we going to subdivide that front paddock in particular, because they're looking for land that's got a better amenity value than some of the stuff that's available right now.
So are you looking for a stock standard residential zone, or or more of a bespoke zone that sits somewhere between a lifestyle zone and a standard residential zone? Yeah,
well, essentially I think it would be the best and most aesthetically pleasing solution for it. It's not as though I'm out to make everybody live on a handkerchief-sized plot. You've heard my view of that. And if we're able to retain control of the development of that land, then it would be my intention to put together a more transitional style of subdivision, as I've spoken about, going from the residential just at the Cascade Place interface through to support a couple of larger blocks at the eastern margin.
And my final question for you is, was this making a submission on this, on the notified proposed plan, was that your first interaction with the council around identifying growth areas for Geraldine, or had you participated in the earlier feedback?
I have submitted frequently, shall we say, on the issue of their statistics. And the only reason that there are extra mesh blocks now incorporated in the Geraldine area is because I actually went to Statistics New Zealand and raised the issue with them and argued it through with them. And there was an, oh, you're right. And it's taken 2 census periods for them to get to the stage where I think there's something like 8 new mesh blocks or something that have been added to Geraldine.
Okay. Well, thank you for your presentation today and your patience to be heard.
Okay, thank you for your attention.
Yes, good afternoon, Commissioners. My name is Miss Hornsey and I appear with Mrs Burden. Just before Mrs Burden speaks to her evidence, I do wish to put her submission in some sort of context. Mrs Burden's not an expert witness. She's a resident in Geraldine and she has lived there for a long time, and that is what she based her statement on. She has a very keen interest in civic matters, and the reason she made this submission was not that she wants to develop her property, but she wants the council to be aware of the potential and the need to provide for a coordinated, cohesive approach to any future expansion of the township in this particular part of Geraldine. As I say, she's not planning to develop her land, but she knows from her experience and knowledge that this council has previously identified 73 Connolly Street as having potential for residential development. So it was identified in the 1980s. This council ordered the preparation of the report by Opus in 2009. So it's not unrealistic, but it's certainly not the intention of Mrs Burden today to try and persuade you that Mr Bonus' recommendation is wrong. She's just simply not trying to persuade you that it has to be done. She's trying to alert you that when you are considering the needs for Geraldine and for residential or lifestyle growth, please bear in mind what she has lived and learnt. Thank you.
Thank you for the opportunity to speak to my submission regarding the future development of the Geraldine area and our property as well. And I'd have to say I support a lot of what John has said, and it's not that I've liaised with him of late. I actually haven't talked to him for about a year, even though he's a next door neighbour. I've lived in the Timaru district for 52 years since I'm married, and I was a councillor here for 12 of those years. And despite my experience with local government plans, I must say in the 25 years since I left the council, the process of making a simple submission on a district plan has become so complex and expensive that it must surely be out of the reach of most ratepayers and deny them the opportunity to have a say on what they want for their own town. Only those with deep pockets can afford to pay for the expert evidence they need in order to have their views considered, which in my view has led to disjointed town planning for Geraldine. rather than taking a sensible overall planning approach as they did in the plan drawn in 1879, which we've got a copy of somewhere, which is quite amazing because it lays out all the sections, it lays out the recreation areas, where the police station will be, where the council will own land, and all those sort of things are marked out in it. And I think that's great planning, 1879, and it was followed. The development of Geraldine it's getting very fragmented. You're not looking at land conditions or anything like that, and most of the development has gone down the south end of Geraldine, where they allow it, and that once was zoned light industrial, and they switched it to residential. But I mean, I've seen all that land flooded at least once or twice in my life in Geraldine, so it doesn't augur well for the future, and I know a lot of people think that's a very damp area to live in. And I'm saying future development areas should be placed where they are needed and where people want to go, not what they pay for. So people can pay a lot with consultants and get it zoned residential, but it's not actually where people want to go. Being next to the township and having a lifestyle village and a future development area marching closer, I believe that having a future development area overlay placed over at least those parts of my property that were included in the 2009 Opus plan makes sound planning sense. It would ensure that as the village and land further north is developed, if it is done in a coordinated way that makes the best use of the local road and network and other essential infrastructure. And that was in 2009 when we met with the Opus people what we asked for. We wanted a plan that took on Mr Shirtcliffe's property, ours, the Scots, McFarlane's, and then right up to Templar Street. And the roading would come through from Tancred Street and carry on round and connect with Templar Street. And all that was thinking about roading of keeping vehicles off the state highway that runs through, and all those things there, and recognising that you would need a pumping system for sewerage in that area to pump it slightly uphill, and things, but you know, you'd only need one. If it was a coordinated approach, you'd have one pumping station to do all that area. So it was trying to take into all those things and get it sorted. The use of effective surface water management techniques, such as appropriately engineered swales, would benefit the whole of the receiving environment. And you have to have swales in that area because the council doesn't have any stormwater, and I know all about swales now because the lifestyle village has swales. Just unfortunate they didn't make them big enough, and I suppose that's the regional council's problem because they're responsible for that. But they don't take any consideration of the type of land that they're putting them on. And it amazes me that the ones at Templeton are 3 or 4 times the size of the ones we've got in the village, and it's free draining soil at Templeton, and it's not so free draining up at the lifestyle village. So consequently, I get a lot of their water down with me. So all these things, you know, if they're created in a piecemeal fashion, you know, it just impacts further down. I'm not asking for my property to be rezoned. I'm simply asking that the overlay be applied to protect what makes good common sense. I disagree with the statement made by Mr Bonus that my property could accommodate 86 to 106 households. After providing for an esplanade reserve on either side of the waterway, which is the Rakapuka stream that runs right through the property, and excluding the low-lying areas, the scope for building size is much less than 86. I also disagree with the growth projections made by Mr Heath. As set out in my evidence, the only constant in the expert assessments that have been done over the last 20 years or so is that they have all been proved wrong. I recall one expert from Dunedin stating that the demand for new houses in Geraldine for the following 30 years or something would be 40 houses, and by the time he presented the report to the council, there was about 38 new houses being built or built. So he was slightly out in his predictions, wasn't he? The district planner, head district planner, did a report, and he was out by miles too. So there's been consistent, that's been consistent all over. I've got some things here. The satellite image of Geraldine, if you look at it in 2010 to 2020, just how much growth there's been in the town in that time frame area. Desktop exercises do not reflect what people actually want. South Geraldine, as I said, is wet and damp. At one time, no burials could take place in the cemetery when I was on council because of the high water table. There are a lot of springs and ephemeral waterways. Those of us who have lived here for a long time know where the water goes when it rains heavily. This is why sections in Rokapuka are in demand. Geraldine is thriving, and many of the people who are choosing to live here come from outside the Geraldine area. They come from the North Island and overseas, and I think it's a huge number, like 40 or 50% of the people that moved into the lifestyle village came from outside the district, nowhere near the district. On paper, there are sections that may become available in the next 15 years or so, but that does not mean people want to buy them, and if they're not where they want to build and live. It also, I might add, means that unless the people that you've earmarked to do those developments are forced to do it, you can't say that they'll actually do it in the next 10 or 20 years. I mean, their circumstances could change, the economic climate can change, all those things impact, and if they can't make a profit out of it, then I don't see why anybody would go ahead with the subdivision. So that's all my comments. Sorry, Mr. Bowers.
Kia ora. I did have a number of questions that were going to be quite site-specific, but I think based on your evidence where you're saying actually, in fact, might not necessarily be about the vision for this particular site and it's more a vision for Geraldine as a whole, I might just take the opportunity then to ask some of those Geraldine-based decisions to get a wider view.
And I can't say that I'm going to do anything in the next 10 years. I don't know. That's what I mean. And I was told by council staff and things in 2009 that unless you plan to do it in the next 10 years, you could not nominate and put anything on it. So I haven't done that because I simply don't know. And I wasn't going to lie and say yes to get it and say, yes, I was going to plan to do that and then not do it. I just took the view that at some time in the future I might, but not at the moment.
Yeah, no, that's really helpful. Yeah. You're reserving an opportunity.
Yeah.
Great, got that. When you spoke about seeing incidences of flooding and you talked about it being south, and I've got a map of Geraldine open now, and given that you've lived there for a really long time, I wanted to better understand where is the flooding. So we've got, maybe I'm reading my map wrong, but north is like the Templar Street area, and I would have thought coming further through to FDA 5, which is the Young Farm, is south. So were you saying there's more flooding south or slightly out?
It's not slight.
Depends which river's flooding at the time.
Not quite north-south, they're sort of...
Yeah, it's sort of... So the south there, north there, east there, west there, sort of like that for Geraldine. Yeah. Sorry.
So in terms of where you see more flooding, so I think out to one side of the town there's like Jolly Street and Shaw Street and Barker Street out at one side, and then out at your side is more towards the Orari Station Road area.
That area, yeah.
And that's the area that actually you would see has more flooding?
No, well, it depends. So on the south side of the Geraldine Township side, you know, where the shops and things are, for example, there is a Serpentine Creek that runs through.
Yes.
When I was on council, we put a dam up on the Geraldine Downs and Talbot Forest to help hold the water, to try and stop the flooding, because twice in the short time I'd seen it flooded, and that goes right down through town, and especially down in those new areas that have just been subdivided right down the bottom end of town. So that's where the flooding went. To be fair, Talbot Street itself, that comes right down and along the river, but where the road is, has never been flooded, but it is further towards the river and the other side. And you just need to, as I said to one of the council staff, if only you'd sit down and read papers past, you would learn where all the flooding had been and what areas and how many floods and things had been. So that's that one. On the other side of town, it's just serious rainfall events. You've got the Waihi River that comes in and round and cuts through, but there are places where it naturally runs the water. And if you can look at old aerial views, so some of the ones back, so there was one good one, and it was at the Regional Council in Timaru, but I don't think they've put it on that mapping thing that they've got now for Canterbury Maps, but there was one there that you can see where the water runs. Even our property, you can see where water runs all through that area, and in our place it's more obvious because the ground hasn't been worked. It's been more like a lifestyle block, never been worked, but the ones further up in that, it runs, and I can show you photos of where the water runs and where you'd never build on it. To me, you'd have to design round that to allow that water to keep flowing. But then you've also got the Arari River, and then you've got the Sweetwater Creek, which is sometimes called a few other things. So that floods, and it flooded out. And where the Regional Council don't maintain the streams and the clearance and things, then that blocks it, and then it floods down and it starts running down the roadside and things like that, and that can cause flooding in properties. The last major flood, I suppose, I saw through there was in was it 85 or 86 we had a flood? And that was all on the Templar Street corner and round there. And there was a dip in the road that ran across the road just down from the corner and through like that. And in the last district plan, we designate that could not be residential because of that flooding. The people appealed it to the Environment Court, so they decided to override us and let them do whatever they liked. So they filled it in, and then they've been building on it. And it was interesting when we had a heavy rain 2 or 3 years ago, the first place it went was down and went exactly where it had always gone. Whether the ditch was there or not, that's where it was going to go. So water's interesting. If you live in a rural area, you soon learn how it behaves and things, and it goes where it wants to go. It doesn't matter what you do.
You know, that's really helpful. And then my other question was, so Mr. Shirtcliffe talked about the inappropriateness of infill housing in Geraldine, and I wanted to know what was your view on infill housing? I think he said they were an eyesore or something like that.
Some were, but some people, as he was quite right, some people want little sections. Mm-hmm. We had one up the road in Connolly Street, and he built his house, and he left the designated amount but from the boundary out to the fence that he had. Other than that, there was nothing there, and he's got his garage and enough to drive his car and turn it face outwards and drive out, and the rest around the house, the 3 to 4 feet or whatever it is, metre around, is all concrete. That's what he wanted. Right. Whereas other people want a small house and a large section because they love gardening. So there's all these variations, and I must say I do think that some young families would like a bit of land around them so the kids can go outside and play. We all moan about children sitting inside watching television all the time, but if they're not allowed and nowhere for them to play, what do they do? So there was a lot of bigger sections, but I think a lot of them were infilled, and at one stage, the council wrote to people with big sections and said to them, it was a suggestion that they might like to subdivide their section, but they worded it in such a way that a lot of them took it to mean that they had to do that. So a lot of sections were subdivided and inbuilt within them, and you can see that if you look at going down deep, look at the thing, there's a lot of infilling has gone on already.
Okay, no, that's really helpful. And I was being unfair. It wasn't an eyesore. It was very professionally said as lowering amenity value. So
depends what they're doing. Yeah.
And then my only last question is just to still get a wider understanding of Geraldine, and knowing that we heard it's on a tourist route and lots of travellers coming through. And I just wanted to know, does that somehow change the type of housing? Does it make Geraldine different in any respect?
No, I don't think, not majorly different, no. I mean, it's just, they're just all subject to the same changes that you get from architecture, different things. We haven't got a huge number of black houses yet. They don't seem to, those corrugated iron ones and things like that look fantastic at Twizel and around in the Mackenzie country and that. Don't look so good in the town with the trees and things. And, Georgina is known for its arts and crafts and things like that. Museums now, we've got a lot of museums, if you're interested. But we've also the plantings and things, not only the native bush, but the English trees and things. And I've had a, National Garden Conference visiting my garden, and they just said they can't believe how big the trees are. I can't believe how big the trees have got. In Georgina, they're huge trees and things, and it's all that sort of stuff that we've got. And then intermixed with that, you've got the wonderful bird life, we've got everything like that. So everybody plants to enhance the things, but what they like, So it's some freedom for people to have what they want,
Great, thank you. They're all my questions, but it's been really helpful to hear your views for the area and acknowledge your civic service.
Do that. No? Okay.
Thank you.
Hello, good afternoon, Commissioners. Ken, just confirming that you can hear me.
We can hear you. Can you hear us? Fine.
Yes, I can. Thank you.
Thank you.
Lovely. So good afternoon. I'm Jess Bold and I'm providing planning evidence in relation to submitter 272, which is Glenys and John Travers. I will provide a summary of my evidence. Specifically, I will address scope. So my evidence addresses a request for the panel to consider a minor extension to the Future Development Area 2, or FDA 2 overlay in the proposed Timaru District Plan. The purpose of the extension is to better align the overlay with property and land holding boundaries and thereby enhancing the overall coherence and implementation of the FDA 2 overlay. The request, in my view, is responsive to the growth objectives identified for the Timaru urban environment. The site in question is located directly adjacent to the notified FDA 2 overlay and Timaru's existing urban boundary. This location is experiencing increasing demand for residential development, making the minor extension both logical and strategically aligned with the district's urban growth direction. I do want to acknowledge the difference in opinion between myself and Mr. Bonis regarding the scope of this evidence and whether the relief requested was in scope. For some further context in assessing scope, I have applied the Clearwater 2-limb test, which considers whether the change is reasonably and fairly within the general scope of the original submission and further submission on those submissions. And secondly, whether any potential affected persons would be denied an effective opportunity to participate. In terms of findings, the proposed plan introduces the future development area overlay and invites public input where the future growth should occur. My evidence responds directly to that purpose through a request for a consequential change. It seeks to include additional land immediately adjacent to the proposed FDA, land that shares similar characteristics and development potential. This is not a new or unrelated issue. In my view, it's a logical extension of the proposed FDA. Under the first limb of the Clearwater test, my evidence is on the proposed plan because it deals with the same resource management question: how and where to accommodate future urban growth. The planning rationale, objectives, and policy context are all the same. Under the second Clearwater limb, there is no prejudice or procedural unfairness created by this request. The relief sought is directly connected to the notified area, and any person with an interest in this wider area has had an opportunity to participate through the proposed plan process. No new affected parties have been introduced, and the effects of the extension are consistent with those already under consideration. Further, this request does not seek to rezone the land, and there remains opportunities to engage with other parties prior to and during the preparation of a plan change if this is to occur. So to conclude, I maintain the opinion that this minor extension will increase the potential development capacity in a strategically appropriate location, enable a more cohesive and efficient development across 3 larger contiguous land holdings, and help to avoid fragmentation and reduce the risk of a development hole between the Timaru urban edge and existing rural residential development. That concludes my summary. I'm happy to take questions.
Can I, just before we go to your planning evaluation, I just really wanted to interrogate a little bit further the issue of scope. So your client is a further submitter, not an originating submitter. So have you sought any legal advice as to whether or not the Clearwater tests actually apply to a further submitter?
No, I have not.
Okay. And in terms of public participation, at least with an originating submitter, there is the opportunity for the submissions to be summarised and publicly notified, and then potential further submitters can come in and either support or oppose. But where is the opportunity for members of the public or potentially affected parties to comment on a further submission if you're seeking an extension?
So there isn't in terms of the submission process. I think where I have landed in terms of my view is the request is for an overlay extension, and so it's not requesting a zoning change. So that provides a future opportunity for people to become involved during that process.
But we're not dealing with that process here, we're just dealing with the proposed plan that's in front of us.
Yes, that's correct.
Okay. Look, with the caveat that the panel does have significant reservations as to whether there is any scope at all to consider the submission point, for the reason that it is a further submission and not an originating submission. In the absence of any legal submissions to support your argument, I just would like to place that on the record, that we do have difficulty with that. But I will allow questions from the panel on the merit argument, but with that caveat in mind. They may be superfluous, but I'm not going to rule on that right now. Thank you.
Thank you. Can you hear me, Ms. Bold?
Yes, I can.
Great, thank you. So the scope issues aside for my questions, I am interested in the phrasing of your amending proposal, in that the words you use are minor extension to FDA 2. And I see from the detail of your evidence that the land area that forms part of your request is 40.78 hectares, and that would equate, I think you have specified this in paragraph 32, that would equate to between 307 and 425 residential sites. Now, how can you justify the request being minor in scale?
Sure. So there's an opportunity, I think, here in terms of the overlay allowing for further investigation to occur in terms of potential yields for this area. The evidence I've presented is based on a concept, and I acknowledge that the further submitter has not had an opportunity at this point to further look into what type of development yield, what type of development could potentially occur in this site. There is, I think, from my view, there's an opportunity to look into a range of residential options, and this could be larger lots or smaller allotments.
Okay, thank you. Also related to that, I understand that the justification for the request is to align the property and land holding boundaries, which would increase coherence. And when I look at the map of the requested space, I'm having trouble seeing that the request relates only to a minor adaptation of property and land holding boundaries. And I guess a further comment would be that we have had legal submissions today which does clearly and squarely place the onus of the evidential basis for an amending proposal on those who are requesting the amended proposal. And so do I take from what you've said today that you're still very much at a conceptual stage and that we really don't have in front of us any detailed assessment? Would that be a fair comment?
Yes, that would be a fair comment.
Thank you very much.
Thank you for your presentation today.
Thank you.
Right. We have a little bit behind. I think we will just take a break. 15-minute break and then we'll, sorry Ms Francis, we're always delaying you in your presentation. You thought you'd squeaked in. No, we'll take our lunch and break now, our afternoon tea break and then resume. All right, we'll get back underway. Welcome, Ms Francis. You're on.
Kia ora koutou, ko Deirdre Francis toko ingoa. I'm here today to answer any questions you have in relation to my evidence, but online I also have Mr Treewater and Dr Massey, who have provided additional evidence in relation to FDA 11, the Templar Street Geraldine one. Mr Treewater is a groundwater scientist at the Regional Council, and Dr Massey is a scientist in the Contaminated Land and Waste team at the Regional Council. Dr Massey is actually currently beaming into you from the United States, so it's, yeah. So I would just, if you've got any questions, we'd be happy to answer them.
We get on to topic questions. I just wondered if you might be in a position to help us or know someone who can help us. We just, earlier there was a presentation from Mr Shirtcliffe and he spoke about an existing subdivision that he has not yet developed but has consented, which includes 6 wastewater consents. And he indicated that was perhaps about 8 years ago. And do you know whether that would be through the Land and Water Plan process, the same sort of rules that we are discussing in the context of the Payne and other sites in Geraldine?
Eight years ago, let me just have a quick look here. So it became operative in, was a plan change in earlier this year, but I don't think that related to that. And the actual plan, 2018. So possibly. But if you have, if you do have specific questions on that, I'd
in our post-hearing minute, and we'll direct them to Mr Shirtcliffe as well, but perhaps if the Regional Council can facilitate getting documentation, then that would be helpful. Sure. Thanks. Okay.
So the first group of questions I have, or actually in fact majority of the questions I have are for the experts. And I think I'll just start with the contamination. So that's Mr Massey. And
yes, hello.
So I just have a few general questions about this to better understand, just to really better understand how it kind of falls and fits into the decision that we need to make on this, in this hearing. And so what I wanted to know, just quickly is, well, what do we know so far? So can you explain what types of activities in the past might have caused contamination on the site?
Sure. So on the listed land use register, there are currently 3 different sites that are listed, and all of them are listed for Hazardous Activities and Industries List Activity A10, which is persistent pesticide use, and it's usually applied when we have evidence of orchards or market gardens, that kind of thing, on a particular site. So in this case, we looked at some of the historical aerial imagery and had evidence of market gardens or orchards, something of that nature, dating back to, I believe it was the late 1960s and 1970s. I just managed to minimize my evidence window. So, about the late 1960s was where these particular sites showed up in the aerial imagery. And I'd just like to note as well that in addition to the legacy contamination that we know about, it's quite common to discover additional contamination either during development works or sort of in preparation for development. So these are just the ones that we know about. And it is entirely possible that there are other things that have occurred on the property that we don't know about at this time.
Thank you. And so does that mean, so in terms of
usually those would be things that are either recent. So, for example, if there's a burn pile, a burn area that somebody had, that can cause contamination. And then something else that would be an example of that is something that we couldn't see on the land. So a buried a rubbish pit or an offal pit, for example.
Great, thank you. So in terms of what we know, which is, so putting aside the unknowns, so the known is the pesticide, and so I just wanted to know
That's correct.
What's the concern about what would happen to the health of the waterway or Mahinga Kai if that particular contamination was not managed well?
Right. That's a really good question. So right now we don't know a whole lot about these particular sites. For example, no one has taken samples to our knowledge of those particular sites. So at this point, we're just going off of the photographic evidence. But in a general sense, the general risk to the waterway would be more of one where contaminated sediment during development works would get into the waterway, and that's usually managed with a construction phase stormwater consent from the regional council. And then, of course, there are separate operational phase stormwater consents, but those are generally written to mitigate the risk to the waterway, and of course, the construction phase stormwater consent is as well. But by the time we make it to the operational phase, I don't imagine that once something is consented that there would necessarily be any risk to the waterway. It's more just kind of making sure that everything is consented appropriately. Well, first of all, investigated appropriately, and then if there is contamination that needs to be managed, then that would be consented through the regional council, through just a normal stormwater consenting process.
Right, okay, thank you. So in terms of then, like development and timing, then
yes.
when is it safe and responsible to get, to really get that information and understand the contamination risks? Is it now at the rezoning time, or is it at the consent time?
That is a very good question, and forgive me because I'm not particularly familiar with the specific process that we're in right now. I'm usually involved in more consenting stuff. So generally, we would expect it at consent time. However, and certainly for a district council, we usually recommend before a subdivision is made, if contamination is a concern, we usually recommend that the investigation occurs before subdivision. So where does that fit in the context of this process? That's a really great question. I would say, I think the investigation can probably occur at either point, because through the National Environmental Standard for contaminated soil, I don't think at any point the district council would necessarily lose control, if you know what I mean. They can require through the NES for contaminated soil, they can require an investigation prior to granting NES consent, and certainly before any works were to happen. Since the sites are listed, I would think that the NES consenting process would have to occur.
Great. Okay, thank you. That's all I have on contamination.
Sorry, I can't hear you just now. Sorry about that.
I said thank you. That's all the questions that I have on contamination.
Okay.
So
Great.
I have a few more questions on groundwater. So
Okay.
shall I move to them now? Mr. Trethua? Okay, great. So I'm looking at, and particularly about FDA 11, and I'm trying to understand what, you've given quite a lot of evidence. It's been really helpful, but I'm trying to understand what the land can and cannot do naturally. And I wanted to understand, you talked about it naturally cleaning and filtering wastewater, or whether the contaminants just pass through to soil and then reach groundwater. And so I wanted to better understand your comments about what the land naturally can and cannot do.
Okay, I don't have that kind of information. That's the type of assessment we usually ask for, and that usually comes in the consent process. So there's been nothing presented to me as far as what the land could remove or could not remove from the discharge.
Right. Okay. So.
I'm sorry, I've lost your voice. Okay, you're back on now.
I'll sit closer. So what I was particularly looking at is that you mentioned the talking about oxic, I think it's oxic groundwater, and I wanted to understand in like everyday language why this is different or the same as other areas.
So this area is, to where it is mapped, is mapped as a low potential for redox reactions, which would help reduce the nitrogen concentrations that would enter groundwater.
Okay. And so what does that, so if this land was rezoned now and homes were being built with on-site wastewater systems, then what could go wrong in terms of this particular site, and what might happen to the water or the environment over time?
If the treatment of the wastewater isn't sufficient for what the site can handle, that would mean that contaminants above what you would normally want would be transported down gradient with the groundwater. And that may result in adverse effects to down gradient receptors such as wells or the Rununga sensitivity area.
Right, and that was actually going to be my next question, was you've mentioned about it moving through to spring-fed streams which are connected to this particular land, which are culturally significant. And I wanted to know if the development went ahead without proper servicing, what the risk to that waterway would be. What would we be looking at as a potential outcome?
Well, the risk to the groundwater I would consider high. What the risk would be for the down gradient receptors, again, would depend on the level of treatment for the proposed wastewater treatment systems.
Okay, great, thank you. There are my questions on groundwater. I just had a couple of planning questions.
Okay, I'll try those.
I'll go to Ms. Francis.
Not for you, I think we'll ask Ms. Francis. Thank you.
He's welcome to try.
So my very first question is, it's more really at a really high level about why ECAN was providing this evidence on this particular site. Like, it seemed quite specific to here and not other future development areas that we're looking at.
That's actually an easy question. That's because in Mr. Bonus's 42A, he actually specifically asked us to provide further information on groundwater.
For this site?
For this site, yes.
Okay, that's helpful to understand. And quite a bit of your evidence talks about giving a false impression down the track that there might actually be a consenting pathway under the RPS. And I wanted for you just to really summarise what the biggest issues or challenges are to obtaining a consent.
In terms of the wastewater?
Yes, for the ECAN jurisdictional issues.
Yep. It's basically what we look at is what the current state of the groundwater is. So if it's a high nitrate level area, that's usually where there are issues about whether the on-site wastewater systems can be granted. There have been examples in the past where subdivisions have gone through and then people have bought that land and then they've gone to put in their wastewater management systems and they can't get consent. I'm not saying that's the case in this particular site, but that's the sort of thing I would like to avoid happening.
Is there more of a risk with this site than the other sites?
Not that I know of. We don't have enough information.
Okay, so it's not particularly site-specific that you're raising this issue. Okay, well, that's helpful because the evidence, I guess, is about this site, so it was trying to understand why this site is different than anywhere else, and it's not, so.
Yeah.
Okay, thank you.
Thank you, Ms Francis. One question from me at paragraph 36 of your evidence.
Sorry.
So here you've clarified the relief sought from Regional Council's submission in terms of FDA 5, FDA 6 and FDA 13, and you've clarified that the Regional Council's submission requested that long-term FDAs be identified outside the proposed district plan and another document. And I'm not sure I follow that. If they weren't included in the schedule, in effect, that means they are deleted. I just wasn't sure how the first sentence, whether that reconciled with the...
No, that's fair. It's probably a little bit pedantic. Basically, the Regional Council made a submission. It didn't make it on any of these an original submission on any of these particular FDAs. So it made a submission saying that it had concerns about long-term FDAs being included in the proposed district plan. In my opinion, it's a step too far to say that that's a request to delete them as FDAs. It was just about where they sat. We hadn't turned our minds to whether they were because we didn't make any submissions on any specific FDA.
Thank you. That's a good response to my pedantic question to your pedantic point. Thank you. And so just going back to your previous paragraph, and I think this follows on from Commissioner Mackay's question, in terms of the risk of foreshadowing these FDAs in the provisions might lead to pressure, but you've also said that the overarching strategic direction and the associated provisions are robust enough to probably prevent that happening. And so earlier in your evidence, you had provided examples where perhaps that strength wasn't present and that then led to problems. So are you saying that the likes of the examples that you've provided, you don't see that playing out here? You're satisfied with the strategic framework and the provisions in that sense, or are you still wanting something strengthened?
I think there's always a risk, and I don't think you can ever completely get away from that risk. But as I've said in my evidence, I didn't write the original submission, but when I came to look at it, my way of looking at whether there was an issue in terms of, and that was particularly in relation to out of sequencing, I then went through the provisions of the proposed district plan, and every question I had that would have caused me to think there was a problem was answered by the provisions that were within the proposed plan. So I think it's as robust as it can be.
Enjoyed reading through that analysis. I found that quite helpful. Thank you.
Thank you.
And so my last question was, in the absence of any foreshadowing via an FDA, would development pressure exist in these areas anyhow? How much does the FTA actually kind of add to the perception or that pressure?
I think there's a risk anyway, but I think that when you flag areas as FDAs, it's flagging that it's considered there is an opportunity there.
Thank you very much.
I've got one, just your final paragraph. And I just want to clarify that this is just if the panel is inclined to accept the recommendation to provide immediate subdivision, recommend a joint consent assessment pathway process. I'm assuming that's external to this process, or do you think there needs to be some kind of a signal and a rule somewhere? I just want to know what you want us to do with that statement.
Yeah. To be fair, I haven't seen any district plans that actually include anything like this, and there is a provision within the Act to do it. I guess what I was trying to say, and didn't say it very well, was that I think when you have subdivisions like this where there are potentially, where there's also a requirement of resource consent from the Regional Council, that Section 91 process is the best way of dealing with it, because you don't want to, well, in my opinion, having a subdivision there, the people that then go on to buy those lots, they think that because they've got their piece of land that they can develop on it, and that's not necessarily always the case.
And I've just got one follow-up, and I'm probably asking you just because of your knowledge working for the Regional Council. So I'm just curious about an approach of utilising compostable toilets in terms of a plan change, a rezoning proposal. And I'm just wondering if you've got any experience through the work you've done with the Regional Council where that's been a solution that's been accepted at the time of a rezoning proposal or a future development proposal.
In my understanding, there's not a lot of compostable toilets used. People don't tend to like them, and I don't think district councils are very fond of them either. But they have been used. I think there was a subdivision in Fairley that looked at them. I may be wrong about that, but that's my understanding. But the problem, the compostable ones, you need the two chambers. So you have one chamber that fills up for 12 months, and then after 12 months you start filling up the other chamber, and you can take the waste that's in there that's composted, and you can apply it to land as a permitted activity as long as it meets certain conditions. But there's no liquid discharges from a compostable toilet. So that means that I don't think I'm answering your question.
No, I think you've answered it enough, so that's fine.
Sorry.
Thank you.
I have a groundwater question and a question to you, Deirdre, but also I'll start with you. So you've highlighted the uncertainty of obtaining resource consents for on-site wastewater management systems. Would it be your view that no rezoning should proceed here until a comprehensive wastewater feasibility assessment is completed?
I guess there's two stages to my answer of that. Is that a reasonable thing to request of people? Because normally that would occur during the resource consent process. But then with subdivision and then putting in the wastewater system, you're dealing with two different people usually. The people who do the subdivision don't usually put in the wastewater management systems, and the people that buy the land to put in the wastewater management systems, as I said before, they're probably going to be assuming that they will get it. And probably they will. I don't know, because I don't know what the condition of the water is below. So I just would feel more comfortable if there was more information about that. But to be fair, the RMA process doesn't require that to happen.
And just a groundwater question, and that is, there's a mention of mounding or drip, mounding is it? Yeah, or drip irrigation might be needed for wastewater. So this is to, I don't know what one, to Mark. I think that, yeah, okay. In your view, is there any evidence these systems would be feasible or effective given the less than 2 metre depth to groundwater across the site?
There's been no evidence given to me to review regarding that, but I am familiar with consents that have had shallow water that have achieved getting consents with shallow water and installing wastewater systems.
No further questions for the Regional Council. Thank you very much for your presentation. Mr. Hull for Rooney Group. Welcome. We've got two statements of evidence from you, so over to you, what you deal with first.
Tēnā koutou katoa. I think in terms of my statement of evidence on the financial contributions, I heard the discussion this morning, and I'm probably happy just to take that as read and answer any questions if you have any. I just would clarify in relation to the example I used where producer price index is applied. I used the example of the Waimataitae sewer catchment. So I had checked with Mr. Kemp in terms of the financial contributions and how they're applied in relation to that when I use that as an example.
On to growth, we might just check whether there are any questions on financial contributions. Fine. No, thank you. My only question for you was just a follow-up from the discussion this morning around the open space and recreation. I'd asked a question of the council to go away and do some further sort of inquiry as to what the basis of the 4% was in terms of an evidential basis. But I also asked the question about what information sits behind other districts using the 4%, and I wondered whether you and you've obviously looked at a range of documents to try and find the source of that. Did you look at other districts and what information they may have had before them before determining that level of contribution?
No, I haven't gone back and looked at that detail. I just know from my experience working for 3 different district councils, they're often they're based on first generation plans or often before that, and often those percentage contributions just carry through into future plans and often aren't challenged.
What sort of information would you expect should sit behind that in the context of Timaru?
Well, I guess what I was looking for in terms of Timaru is what the money was required for, what its intended use was, and that's so I think from our perspective there's no issue in terms of paying the financial contribution, but it obviously has a flow-on effect in terms of the cost of the work we do. So we needed to be satisfied that we knew there was a use for it, and so I guess what I would be looking for is to see in terms of past use with the existing contributions in the operative plan, where that's been used, and that's where I couldn't find anything in the long-term plan, and it just seemed to be sitting in a reserve at present, or any future intended use where I think the comment was made that because the 4% hasn't come in yet, there was going to be expenditure down the track, but I couldn't see anything in the projections either for that. So yeah, I'd just be looking for some sort of background as to what the need for it was.
Well, thank you for those comments, and we'll see what, we'll ask some questions of Mr. Dick. Maybe an opportunity for you to comment on that as to whether that satisfies the submitter's concerns.
So in terms of growth, our interest is in provided evidence in relation to FDA 13 and FDA 14. FDA 14 is there's a portion of that that's owned by Timaru Developments Limited, and Mr. Dew made a submission, not seeking to rezone that, but seeking to bring the FDA forward within the 10 years. And I guess the background to that, at the time we made that submission, was thinking that that might have brought it in out of the NPS highly productive land, but we know that that's not the case now, and obviously accept the position where Mr. Bonas has landed. FDA 13 is owned by Rini Holdings in terms of our interest, and part of that was purchased from Whitewater Properties, and so we made a further submission in relation to that. In terms of zoning, our preference would be that the zoning could be brought forward, and what I've tried to do is just set out, I guess, the background for acquiring that land and the current development that's occurring on that Rini Holdings land, and just showing that actually we are running out of land very quickly, and if we could, we would move into FDA 13 straight away if we were able to. And I guess the key for us is the ability to be nimble is incredibly important to be able to make business decisions, and things can change very, very rapidly in terms of being able to take those opportunities and grow. So I do agree that, I mean, there are some limitations in terms of the servicing that is available to FDA 13, but we've always been open to working through that with the council, and I guess the key point there is that we really haven't had those discussions with the council to date. In terms of stormwater, we did participate in some workshops, and we did try to get our land brought into the global consent that Timaru District Council has applied for, but that wasn't taken up. So we're still keen to pursue that with the council if they're open to that. It's just that I guess the growth projections from Mr. Heath have kind of said that really there's ample industrial land available already, and in terms of what we do on that site and the adjoining sort of land that we own, we'll be at capacity very soon, and could move into FDA 13 as soon as we were able to. And I guess with FDA 14, well, as I said, we haven't sought to rezone that, but I've tried to provide some background there in terms of where we landed purchasing that part of the site that Timaru Developments owns, and we did look around for a long time for other suitable land, and we were looking at other land within Washdyke. And when you narrow down all those other issues that you've got to work through in terms of suitable ground and land that's subject to flooding, there isn't actually that much area available. So that was actually one of the better sites that was available that was close to town. And I heard the discussion this morning in terms of the servicing and the cost, and I would just say in terms of their estimate, that 13 to 15 million from the council, I think our estimate is that we could provide that 900 metres of main trunk line for well under $2 million. So it's quite a big difference, and that was just, it seemed to be pitched as being one of the, apart from the demand for the growth, with the growth and the proximity to the rest of the residential area, that to me seemed to be a big obstacle that it was being sort of pitched in terms of the infrastructure. Yeah, so that's really the background to that, and I'm happy to answer any questions.
Thank you. So that's good to hear that you were able to tune into that conversation this morning, and some of the questions and answers there. Thank you for setting out the background. I found that quite helpful when I was looking at the plans and understanding the lay of the land and the nature of the request. In terms of FDA 13, you've mentioned today that you could there's demand for that, you could fill it ASAP. I picked up from your written evidence that you had tenancies in discussion for their triangular piece of land to the west of the railway line, but I hadn't picked up that you had tenancies or discussions underway immediately for FDA 13, unless I've missed something.
That's correct. Also, yes, in terms of FDA 13, well, there's nothing cemented in, obviously, because it's not zoned, but there's certainly plenty of interest. I'm not suggesting we could fill it tomorrow, but what I'm saying is we could move across the boundary and into that straight away, because the work that is underway at present will, and some of that is quite far down the line, so that a lot of that will happen later this year, and that will fill up that Rooney Earth moving site.
So you have confidence that in terms of the request to have that more responsive, that would be within the next 5 to 10 years, rather than 10 and beyond? Is that what you were suggesting?
Yes, yeah, absolutely. So the Rooney Earth moving site with all the bulk storage sheds, that takes you to the northern boundary of the current industrial zone that joins onto FDA 13, that those areas are on my attachment 3 in yellow. So there's the Morrison Park site, is at that northern boundary. I mean, that is currently, it's being finalised at the moment for development, so that will occur later this year. So that's fairly far through, as is the development above, on the opposite side of Seadown Road, on the eastern side of Seadown Road, above shed 19. And then there's some other work occurring out towards the State Highway, just to the north of PGG Wrightson. So all that's fairly well down the track.
Thank you. And in Mr. Bonis's reply to my question this morning, which you've obviously heard online or sitting here, it was regarding the practicalities in terms of how Rooney operates at present, and I guess the ease and convenience that your request would provide to you, as opposed to utilising industrial land elsewhere. And I guess I'm interested in, would you accept that the statutory tests relate to the, in terms of the projections that we have, the projections clearly state that there is capacity elsewhere, so you're not disputing that aspect of the projections. And so other than the fact that it's practically, and what I've inferred from your submission is that it would be inconvenient to have to seek industrial land that isn't consolidated at this location. Is there any other factor that presents a constraint to you using other land in the other industrial land that's projected in the district?
So yes, we do. Rennie Holdings has other industrial land, so we've got quite a big block at the southern end of the town as well. But this particular site at Washdyke sort of acts like an inland port with all the bulk storage sheds, and there's an operational weighbridge there. So what happens here is most of the business in relation to the tenants in those buildings, a lot of that product comes in and out of the port, and it's weighed as it comes in and goes out. So it all kind of feeds into that operational hub there. So there's an operational need for that location, and it doesn't really make sense to replicate it elsewhere.
Right, thank you. That's good to have teased that out there. So operationally, consolidating everything at this location is an operational need. Yeah, that's essentially what you're saying. Thank you.
And we've got all the industrial accesses to and from the site. Like there's one off the State Highway, there's one off Seadown Road. There's sort of like an internal haul road through the site, like quite a road network through the site.
Great. Thank you very much.
Any questions? We need to keep moving, so just keep.
I actually had a question on FDA 14, and it related to the cultural values. However, did you say I just want to be clear that I understand, is your submission still that you want to bring forward the rezoning, or have you accepted that it might not be possible under HPL?
In terms of FDA 14, I don't think we've got scope in terms of our submission.
Okay, great. Well, I won't ask my question then.
One, maybe two questions for you. And it's just a follow-on question from, I was going to call you Councillor Day, but no, you're a commissioner, sorry. You've described strong demand for both industrial and residential developments, but do you have any recent examples or data that shows this demand is continuing?
In terms of the industrial, yes, just in terms of our day-to-day business, there's a number of current proposals that are on the table, and I've set out in my evidence, I think, why that is in terms of what we can offer in terms of a turnkey product for tenants that lease that industrial land. With the residential, I guess that we just know through experience, and that's through Mr. DeJu and the work he does with Timaru Developments. So we've got, we've done quite a few subdivisions within Timaru itself. We've got a 57-lot subdivision underway at Pages Road in Gleneaty. We've got 2 subdivisions under construction in Temuka at present, and a number of those are under contract. So I guess that sort of market feel for demand just comes directly from Mr. DeJu's knowledge.
I just wonder, is there any risks that bringing forward FTA 13 and 14 could draw investment away from already zoned areas, or are you confident the market could support both? I know they're different, but...
I think in terms of FTA 13, with the industrial, I think what we do, what Rooney Holdings does there is different from what occurs elsewhere in the industrial parts of Timaru, and I think that's part of the reason it's grown the way it has. With the residential, certainly what we're trying to do, or what Timaru Developments would like to do with FTA 14, is try and provide more affordable sections. And I guess what we see with the Rooney earth moving business is there's a lot of employees there, and there's a need for affordable housing, and there's a need for that close to business, because a lot of people do commute from Temuka, for example. And we know from experience from the development we're doing and have done in Gleneaty, that those sections are far more expensive than what we would hope to provide through FTA 14. So the Gleneaty sections are over $350,000. So what we would hope to do with FTA 14 is have something much more affordable in the market in that sort of $200,000 to $250,000 range, and we think we can do that because we think it's a lot easier to, even though there's been discussion about servicing, we believe it would be a lot more affordable to service, and it would certainly be a lot cheaper to construct because of the geology. It's on alluvial gravels. It's good ground. The sections in Gleneaty are actually quite expensive to develop.
That just reminds me, there was a discrepancy in the report on FTA 14 around the property economic assessment identified a yield of 718 household allotments, where your submitted package said 150.
Also, that's in relation to the land that Timaru Developments owns within FTA 14, so we don't own, the racecourse takes up the majority of that.
No further questions for me. Thank you very much for your evidence.
Thank
you. Chris and Sharon McKnight, Monique Thomas and Lucy O'Brien. If they haven't got anything to present, can we come back to them tomorrow morning if we've got any questions? Because that's Temuka. Do you have any questions for Ms. McMillan in relation to Christian? Not today, but if anything comes up, we'll communicate to them. Well, all here. Amanda's online. Thank you. Welcome. Thank you for your patience. Long wait today. You are our last submitter to be heard today, so we'll sit as long as we need to, so don't feel rushed. Thank you.
Thank you. Good afternoon, Commissioners. I assume you have my legal submissions, which were filed last night. Have you had a chance to read those yet, or would you like me to take you through them? Okay, no, that's fine. There's nothing in particular there, I think, that I need to discuss with you this afternoon. I think there's no particular legal issues which arise in relation to this site or this submitter. You'll also have, of course, the expert evidence that's been filed. So we've got the evidence from Mr Babbage in relation to the site and the history of development, or particularly of the adjoining land. The evidence of Mr Milner in relation to highly productive land, and Mr Milner is available online if you've got any questions for him this afternoon. Mr Greenshields has prepared some evidence for you in relation to landscape, and he's also prepared a graphic supplement which you have on the screen behind you there. And Mr Greenshields has also been out to the site this morning and has just taken some further images for you in relation to views from the sports ground and also from the walkway, which is in the bridge within Centennial Park. And those viewpoints essentially confirm that you will be able to see the existing consented dwellings within the existing subdivision from those locations. And then lastly, of course, but not least, we have Mr Ross, who has provided you with some planning evidence in relation to the submission. So in terms of the current status of matters raised in the Section 42A report, so Mr Bonas has confirmed in his summary statement that all of the matters raised, or shall I say, all of the issues raised in his report that needed to be addressed in evidence have in fact been addressed, and that from his perspective there are no outstanding issues in terms of an expert evidence point of view. Mr Ross and Mr Greenshields have promoted a draft standard in relation to planting to ensure that the mitigation that's discussed in the evidence of Mr Greenshields actually happens at the time of. So that wording was provided to Mr Bonas and Ms Pfluger last night, and I understand that Mr Bonas and Mr Ross, if the panel's comfortable, will prepare a joint witness statement just purely in relation to the wording of that proposed new standard. But essentially it relates to the clusters of trees to be provided along that boundary and the distances between them, the minimum height and minimum spacings, I think.
I think a joint witness statement would be helpful for us, so yeah, you can take that as yes, please.
That's fine. So other than that, I don't have any particular other things to tell you about really this afternoon. I think our evidence is reasonably thorough without trying to overwhelm you and addresses all of the issues raised, so happy to answer any questions or have anyone present a summary if you'd like.
Can your witnesses please just present summaries?
That's fine.
Thank you.
Perhaps if we just take you through the conclusions of their evidence. So we might get you to go first, Mr Rabbit, if you just want to take the Commissioners through your conclusion. Thank you.
So in terms of my evidence and the conclusion, it's only one paragraph. That the rezoning sought would enable a modest extension to the existing Brookfield subdivision and would see the efficient use of existing Timaru District Council infrastructure within that zone. Earthworks and stormwater associated with the development of the 5 additional lots that would be enabled by the rezoning can be managed so as not to affect Otapua Creek. Thank you.
That's clear, but thank you for that.
Thank you.
Mr Greenshields can go next. Would you like him to take you through the supplements, perhaps after a summary?
Yes, please.
That's fine. If you take the panel through your conclusion and then perhaps to the supplement.
Would you like my full conclusion? It's 9 points, 9 paragraphs. I can sort of provide a
a briefer summary of that, if you like.
It's been a long day, so if you could take us through your summary, your conclusions as they are, that would be great.
Sure,
Thank you.
absolutely. Okay, so my conclusions. The requested RLZ extension, which is the site, which would provide 5 additional rural residential allotments, will not compromise the existing and emerging landscape character of the receiving environment due to the RLZ extension having the same minimum lot size requirements as the existing RLZ, the Brookfield RLZ, and the requested extension of the provisions of the Brookfield Special Control Areas, which will enable the integration of the RLZ extension area with the adjoining Brookfield RLZ. The RLZ extension will exhibit the same openness, high level of amenity, outlook and rural residential lifestyle as the existing Brookfield RLZ zone. The open rural character and visual quality of the surrounding rural area will be maintained. I do not consider the proposed RLZ extension will give rise to cumulative effects. In my opinion, the scale and character of the surrounding receiving environment is able to successfully absorb this change, and future developments sought to the rezoned RLZ will integrate with the adjoining Bluestone Rise subdivision, and that's actually referred to as the Brookfield Heights subdivision. This is due to the RLZ extension exhibiting an aesthetic coherence with the Bluestone Rise, which in turn is assisted by the requested extension of the Brookfield Special Control Area. A sense of openness, low density, well-treed development will maintain and integrate the rural residential lifestyle, character and amenity. I consider the rural production value of the overall site as compromised due to its area, and the rural production potential further restricted due to the surrounding fragmented lots and proximity to existing dwellings and future building platforms. This opinion is further supported in Mr. Miller's statement of evidence. Consequently, the amenity values of the overall site reflect those of the rural residential lifestyle area. Viewpoints at or above the elevation of the proposed RLZ extension will view the RLZ extension and future dwellings in the context of the adjoining Brookfield Heights subdivision. Viewpoints from Otipua Creek Walkway, Centennial Park and School Park sports grounds will be subject to more visual change due to their considerably lower elevation than the proposed RLZ extension. The School Park viewpoint will have open views towards the proposed RLZ extension, which will also include views of the existing fencing and some future housing built within the existing RLZ, the Brookfield Heights subdivision. The cross-section in my graphic supplement and then also further the supplementary photos illustrate that some rooftops of the buildings within the existing RLZ and the Brookfield Heights subdivision may be seen from this viewpoint, and I actually correct that and say they will be seen from this viewpoint as the supplementary photos show. Only partial intermittent views from Otipua Creek Walkway and Centennial Park will be possible through gaps of intervening existing vegetation, reducing the overall visibility of the RLZ extension area from these locations. As illustrated in my graphic supplement, as illustrated in my graphic attachment cross-sections, mitigation through the use of clusters of trees on the eastern boundary of the proposed RLZ extension and downslope of the dwellings will provide a softening to the visual prominence of additional dwellings on the skyline. Trees behind dwellings along the western boundary will also provide a softened backdrop, further integrating the dwellings when viewed from the lower elevations.
Overall, I conclude that the developed RLZ extension would appear as a mix of trees and low-level housing with areas of landscaping and open space of the same scale and treed appearance of the Brookfield RLZ or the Brookfield Heights subdivision. There will likely be a short duration of temporary effects on those viewpoints which are lower elevation than the proposed RLZ extension area, while the trees mature to a comparable height of the dwellings. However, when established, the trees will be integrated with the structures or the dwellings in the landscape, and any structures will be visually filtered. I consider any mitigation measures as such, I consider any mitigation measures such as planting can be dealt with as part of the subdivision consent application. However, further to that, Mr. Ross and myself have drafted some provisions to be formed. Thank you. And I'll run through the just my graphic supplement if you like. So, if you may, thank you. Oh, sorry, skip context too, please. Is that going to work? Can you see that? No. Yes? Sorry, okay, so there's a view of the site, and in particular the sort of white washed out area is the oh, thank you, Andrew. And so the orange arrow points are the viewpoints that I've taken looking towards the site. The blue ones are just sort of context photo of the existing receiving environment. And then you can see there's a section line there. I've developed two sections which show the proposal in a sort of unmitigated and mitigated form as well. Oh, gosh. So here's some selection of photos from around the site, and so you can see there's a quite a difference, quite a compartmentalisation of the landscape, and sort of a finer grain lot size, mix of quality of built form and vegetation and land uses as well. So this viewpoint here is taken from the Centennial Park Scenic Drive, or looking across towards the Brookfield Heights subdivision. You can see there the fencing's quite evident, of the timber fencing that's there, and then the proposed extension site sort of sits in front of that on the brow of the hill. So from this viewpoint, the proposal will be seen in context with that subdivision behind and the future housing. Similarly to this viewpoint too as well, from Quarry Road, looking across School Park, sports grounds to the site as well, you can see the fencing in the background, and sort of that view will be viewed in context of the development behind. So this is at the lower elevation where the proposal and the housing will break the skyline, and then similarly the housing in behind as part of the Brookfield Heights will also break the skyline as well, and that's shown in my supplementary photos. Another site just looking across the BMX track, same again. You can start to see the fencing of the existing development behind, and the proposal just on the brow of the hill. And similarly again from the swing bridge as part of Centennial Park, you can see the fencing there and the proposed site in front. So this is actually standing on the corner of the site, up the top left there. You can see where the viewpoint's taken from, looking across it, so it gives you a good understanding of the the surrounding receiving environment, the land use, and then actually also the topography as well. And so based on these cross sections that I've created, I looked at the Otipua Creek walkway and how the topography is taken from the survey contour information, and how the viewpoint from Otipua Creek looking up towards the site looks in relation to the proposed housing, and then also the housing in behind as part of the Brookfield Heights. So the top one there is in its unmitigated form, and the below that is in its mitigated form, proposing those clusters of trees on that eastern boundary to break up, to not screen, but sort of to break up and filter views of the site and sort of provide a character that's in keeping with the rural residential lifestyle. And similarly, so this is the longer viewpoint from School Road Park. Same sort of thing with that one. You can, similar approach, looking to add clusters of trees in front of the dwellings to help break up those views. And also with the housing in behind as part of the Brookfield Heights development can also be seen. And so here's the photos I took this morning from particularly the two viewpoints where they're of lower elevation. So this one's from the School Road viewpoint, and we've used a survey staff at 4.5 metres height, which is the height of one of the controls in the special control area, and also the 20 metre setback from the eastern boundary of Brookfield Heights. So that shows the housing as part of that development, those lots you will be able to see from this viewpoint. And then there's an 8 metre setback there as well, which is not overly different to the 20 metre. And then similarly from the Centennial Park swing bridge as well, same approach. We have the survey staff up there which shows the 20 metre setback and the 4.5 metre height building control there. Again, showing that future housing will be seen from this viewpoint, and also breaking the skyline as well, and then similarly the 8 metre setback. And that's me. Thank you.
Thank you, Mr. Greenshield. Just for clarity, so this handout that we've got here, has Ms. Pfluger seen and responded to that this morning, or is this new? Is this in addition to the supplementary that we were circulated on?
Yes, is it in addition? I'm unsure whether Ms. Pfluger has seen that.
Okay, thank you. Thank you for talking us through the photographic images today. That's very useful. So in terms of what I can see, I'm clear that I can see the location of future housing from key viewpoints in relation to existing fence lines and the adjoining development area. Did you consider the need for any photographic simulations of how the actual built form would look and how mitigation would actually look? It's often quite a useful way to consider landscape effects.
Yes, I did consider that, though we didn't produce it. I was of the opinion that the cross sections provided that sort of sufficient amount of detail. It does have the houses are shown in there to the building control heights, and then the supplementary photos they're taken this morning was sort of an aid to help that viewpoint.
Thank you.
My question's really just trying to understand how you mitigate the effects. So it's clear that you change a landscape, there's going to be an effect. And I was trying to understand how you limit that. And you've talked about putting trees at the back of the house. And I wanted to understand, how does that mitigate a dwelling effect? Does it look more in nature and more in keeping?
Yeah, so what that provides, it provides a backdrop to the housing, to the dwellings, and that helps soften that edge, so it sort of takes the appearance from housing off the skyline.
You mentioned another softening effect, which I didn't have noted, and I wanted to know, what was the other one you talked about how to soften? Trees behind, and there was one other thing.
Yeah, and the clustering of trees in front as well. And then also further to that is the special control areas, which we're seeking to extend over this extension, which also provides things around material choice, so just design considerations around material choice of housing, light reflectance, and additional landscaping as part of the dwelling.
Can I just ask, just from a landscape perspective, how you characterise Centennial Park? Is it essentially considered an urban park, or is it a rural park? What's the sort of nature of, how would you describe Centennial Park?
I think it's sort of in keeping, it's sort of a fragmented, if you like, in a way. It has vegetation which provides a sort of more rural park-like type character. It also has vegetation that provides perhaps more of a natural character, particularly around Otipua Creek. It is a historic quarry site, so it is also a modified environment too. It also provides other amenity values around recreation. Don't know, is that?
Trying to understand in terms of the compatibility of a rural lifestyle type development with the type of amenity that Centennial Park provides, and whether it's more akin to a rural environment or a fringe, rural urban fringe type environment, or whether it's more in the nature of the edge of an urban area, therefore more of an urban amenity park.
I think where this proposal sort of adjoins the Centennial Park edge, it's part of, I see it as a sort of a well-integrated extension to that existing rural lifestyle zone. And so it provides a sort of transition area between what is urban to rural.
Thank you. I have no further questions for you.
Thank you.
Lastly, we'll turn to Mr. Milner perhaps next. He's with us online. I just about forgot you, Mr. Milner. You can chat me later.
Good afternoon, can you hear me?
Afternoon, we can hear you. Can you hear us? Fine.
Yes, can. That's very good.
Thank you. If you could just take us through a summary of your conclusions, and then we'll see if there are any panel questions. Thank you.
Okay, so my assessment of the site has addressed its productive capacity in order to understand any constraints that prevent the site from being economically viable. In terms of clause 310 of the NPSHPL 1A, the permanent long-term constraints found include a subsoil pan that impedes subsoil drainage, resulting in a perch water table. And perch water tables are very difficult to drain because of the lack of permeability in subsoil. These sort of soils are not suitable for horticulture and are best used for grazing sheep and light cattle. So it's probably cattle less than a year old. Heavy cattle will damage weak topsoil when moist. And for my site inspection, there was evidence of that having occurred in the past on that site. B, a lack of scale. The site is 2.5 hectares, of which only 2 hectares is highly productive land. This creates a cost structure where fixed costs become an unscalable burden on farm financial performance. Isolation. The site is completely isolated from other areas of highly productive land, which in turn prevents any viable amalgamation or lease opportunity in order to achieve economies of scale. I have compared the site's profitability against the beef and lamb economic service data found for the site and found that the site is not economically viable for rural productive purposes. In fact, it'll result in a loss of around $240 a hectare per annum. In terms of Clause 310(2) of the NPSHPL, the constraints which exist cannot be addressed through reasonably practicable options that would retain the productive capacity of the LUC land within the site. Therefore, in my opinion, Timaru District Council can be satisfied that the rezoning sought by the submitters is not precluded by the NPSHPL. Thank you.
I don't have any questions for you either. That was very straightforward. Thank you for your evidence and analysis as against the NPSHPL. That's most helpful.
Thank you. Lastly, we have Mr. Ross.
Kia ora, hearings panel. So my analysis, I'll just run through my conclusion, then just a couple of extra points as per conversations with Mr. Bonas earlier in the week. So my analysis of Section 32 matters determines option 2, which was the rural lifestyle zoning, being the amending proposal, to be a more efficient, effective use of the site. My assessment has provided a pathway through the higher order direction of the NPSUD and has adopted the assessment of Mr. Milner for the NPSHPL. Furthermore, the expert evidence of Mr. Greenshields has concluded that the impacts relating to landscape and character can be absorbed within the existing environment. In light of the additional evidence, expert evidence which address landscape character and highly productive land, that anticipated earthwork controls can be implemented at the time of future subdivision and stormwater managed so as to avoid any adverse effects on Otapua Creek, the relief sought and amending proposal can be accepted. So following expert evidence being lodged on behalf of the McKnights, Mr. Bonas and I have spoken and generally agree on the amending proposal subject to the landscape matters raised by both the experts in the landscape realm. And I think it, as we've already indicated, we'll go away and prepare a joint witness statement to refine that rule that was circulated. And I'd also just like to know, I know the hearings panel have already mentioned in the summary that was circulated on the 4th of July around submitter 30 being referred to Mr. O'Neill, and I know Mr. Bonas, you've had quite the workload, so there was just another correction there. I think that the site was referred to as being 2.26 hectares. It's 2.6 hectares. That was just one other little thing that I sort of would correct. So happy to answer any questions.
Thank you. At paragraph 9.7 of your evidence, you're speaking to cultural values there. And yeah, at that paragraph, excuse me, my brain is just taking a whirring a bit at this point. You're talking about Ms. Hall's evidence. And I note that in her report, she expressed concern that at the scale proposed, the further residential development in the area may degrade the values for Kati Hurerapa. And I wondered whether you had engaged with those values specifically, or is your assessment contained specifically to earthworks?
No, my assessment's predominantly, well, it is around earthworks and control of that and stormwater.
so you didn't assess those wider values?
I consider them, but I haven't specifically outlined them in this, no.
So in terms of the scale of the development, this might be something that we could check in with Mr. Bonas at some point as well. Might be useful just to hear back from Ms. Hall at some point about her concerns to see whether have you communicated?
Could I clarify something as well? So the original submission from McKnight was quite a large, substantial block of land, and the ACAL assessment was predicated on that, as per my Section 42A, saying it's just not clear. Mr. Ross and his team have narrowed that down to 2.6 hectares. Thank you, Mr. Ross. And it's now some distance from the waterway and those values of Maori as well that were raised. So I have some comfort, and I assume Mr. Ross has reached the same conclusions.
Thank you, Mr. Bonas, for stepping in there. That's very helpful. So I now understand that the reduced spatial extent that has been confirmed has addressed those values that were expressed by Ms. Hall, and so the issue can be contained to the matters that you've expressed here. Thank you. All of my other questions have been addressed through the process. So yeah, that's all for me. Thank you.
I've got one, and it could be because I've just read it wrong. It's just a clarification. Paragraph 815. I'm just checking I've got the right, this is my worry, I've got the right NPS, highly productive land. It's just your reference to objective 4, should that be policy 4, or what? Because there is no object, so.
Yes.
Cool, thank you, I just wanted to clarify.
It's not, and it's been 8 hours, I'm just looking at the clock tick through.
No, that's good, I just wanted to get that on the record whether that was right or not.
That's absolutely my doing. That's nothing wrong.
Cool.
So your brain's still working?
My I've got one other tiny thing. I just want to get, so paragraph 817, you've used the words that it's, and it's the third paragraph, similar to Mr. Bonas, I consider the proposal as not inconsistent with objective 5211 and is consistent with objectives. I just want to understand how what your differentiation is between not inconsistent and consistent. I think I understand it, but I'd like your explanation.
Right, so in terms of consistency, it's when I'd look at it, I'd read the objective as a whole, and I'd look through the whole sentence and look at that. In terms of not being inconsistent with, I think it would achieve certain components of it, but doesn't conflict with it in its entirety.
Great, thank you. Thanks for that clarification.
I've got no additional comments to make. I just wanted to check in with you, Mr. Bonas, in terms of where we are at with this particular application, given the narrowing of the scope formally. You indicated in your report that it wasn't clear to you what was occurring here. So,
no, I think we're fine. So when I wrote the Section 42A report, the scope wasn't clear. The evidence that came in from Mr. Ross and his team confirmed that it was broad, and now it's been narrowed to 2.6. And the evidence that the council team has received is based on that narrowed 2.6 hectares, plus the information on HPL and plus the information on landscape matters. Consequently, I advised in my summary this morning that whilst there's another mechanism as to sort of absolutely nailing down the rule as to tree planting around softening the edges, my recommendation would be to accept the submission on the basis of what it now is.
that's right. I was just going back through your table and I wasn't quite finding that particular reference, but that's helpful. I'll read it again, sorry. It's late in the day. So, Ms. Thomas, so that brings us to the conclusion of your formal presentation. Was there anything else that you wanted to add?
No, I don't think so. I should have perhaps noted in my opening that Mr. McKnight apologises for not being here today. He had an appointment in Christchurch which he was unable to change following the date change.
No, that's fine.
Yeah.
No, that's okay.
If you've got any questions for him, we can certainly put those to him, but I think everything's covered otherwise.
Okay, no, thank you for that, and thank you for the very comprehensive presentation and evidence which addressed the outstanding matters in the Section 42A report, because that's the helpful approach to these processes, so thank you for that.
Just in terms of a site visit, would you like, you're obviously capable of driving there yourselves, the roads and everything are all there, construction started on some of the houses, so you don't need a guide if and when you want to visit, you're welcome to.
I'll check in with our local panel.
I think I'm quite capable of guiding the team through, but thank you.
Take your gumboots.
Yeah, that's fine. I've got plenty of those. Plenty for everyone, actually.
That's fine. Thank you very much, and thank you for your patience. So we'll adjourn. Is there anything you wanted to... We did have one submitter.
Thank you.
Sorry.
I had just seen her come in and out of the room, so I wasn't quite sure whether we had one more.
That wasn't our intention. There's been a sort of conversation going in behind the scenes that I didn't think that the... Yes, so the approach is that if we have questions, we'll put them in writing. But, yeah.
In that case, I don't have anything to do today, no.
No, it's been a long...
Lots for tomorrow, but...
yeah, a long day, and I think we'll take a break. So we'll adjourn for the evening and see you back tomorrow. Thank you.